Mother, court is not audible, mother.
Because the cost has been imposed for each 10,000 rupees.
You said your matter, your case is numbered. I said, ask the court officer why your matter is not. Yesterday you moved, if I remember.
This is a fresh matter. The FR
That's
number has been
what, fresh
given.
matter, I said. If it is, office objections are cleared, all the fresh matters are in the list. That means yours is not.
The court memo, they will not scrutinize the matter.
No, that's wrong.
And as will
That
you-
is wrong. There is a SOP, they'll do it. If they're doing of anything of that nature, please tell the court officer, that's what I've said yesterday. Please don't repeat the same request. Huh? Did you tell the court officer? I asked. Did you tell her? Didn't I tell her yesterday? Did I say? I said specifically, if there is any difficulty, if they are not doing it, tell the court officer. Court officer will do it. Will pursue that. Yes, call the list.
My lords,
My lord,
my lords,
Monday, I said.
Posted today, my lord.
Huh?
It is posted today for the final argument. It is for the eviction suit.
When is that? When did you file that?
The last one, my lord, before vacation. The case has been filed yesterday, my lord.
If it is filed yesterday, if that is office objections are complied with, it will come tomorrow.
Today it is posted for the final arguments. my lord.
What can I do?
It's suit for the eviction, my lord. Permission filed.
If it is arguments will be over, then the court has to pass orders.
It may be posted tomorrow. I'll comply the objections to it today.
If it is complied, it will come. For that, I will not issue any memo. You comply, it will come.
my
It will
lordship,
come. Don't, I request advocates not to make any mentions. I am not going to take it up anything.
my lordship,
Huh?
Urgency in the matter,
my lord,
judgment
with my
of the
lord's
eviction matter is assigned in this matter, my lord, wherein, my lord, wrong court has passed a judgment and
When is the
decree.
order passed?
Notice had been issued
That's
No.
what?
2 months back.
Yes, it will come if the notice
What
is
is the
served.
eviction, the warrant is issued, delivery warrant.
When is it issued?
Delivery warrant is issued, your case is left tomorrow. I came to know now that the wrong court has passed an order.
Correct.
It's a nullity.
That
Otherwise,
is
it
a
will-
nullity that we will see.
Otherwise, I will be evicted, my lord, in the execution proceedings.
No, when was the matter filed? when was the
That filed
petition
2
filed?
months back.
Huh?
At the first instance, the emergency notice had been issued. And my lord, already 2 months are over. Now they have taken the delivery warrant.
When
They
was the
will-
delivery warrant?
The case is left tomorrow. They may take a police help also.
When was the delivery warrant issued?
And I came to know now. Online I came to know that deliverance, because once the judgment is passed, my lord, they don't wait for the other side to appear. Notice actually issued, warrant is actually issued ex parte. I came to know from online that warrant is issued. It is posted day after tomorrow.
This is not today after tomorrow.
my lordship,
If everybody mentions at a time and this mentioning goes on like this,
TCR has been issued to the Honorable Court.
huh?
TCR has been issued to the Honorable Court in CRP. The
What is
property
urgency
going-
now? What is urgency?
The property is going to be alienated from the respondent, madam. Interim order is necessary.
When is it passed? When is
466.
when is the writ petition?
The petition is filed and in the month of December.
We will see. No urgency for that. Yes, my lordship.
with my lord's kind leave.
Huh? What is your problem, Mr. Umesh?
My lord, one matter, my lord has ordered.
Wait, you
the
please
thing is
wait.
allowed. Amount has to have been
You
transferred
please
to me.
wait.
I'm sorry, ma'am. I'm sorry.
Yes.
I6 is the delivery warrant is issued. They have already paid the process for eviction. Yesterday I filed the case, madam.
If it is filed, it will come tomorrow.
Please, madam, I will follow up.
My lords, there is
Ah,
Please.
my
yes.
lords, urgency is there. There is a threat of disconnection of power supply to my installation, my lord. The order was passed, my lord, on 16/4. But however, my lord, the communication was done is 27. Now I am on my request, my lord, they are assured not to disconnect, my lord, till 4th.
You filed the writ petition.
I have filed it yesterday.
It will
my lord.
come. I've asked them to list all the fresh matters.
Yes.
That is what I am telling the advocates repeatedly.
My lordship,
My lords, it's a pending
my
matter.
lordship,
The only urgency is that there is some risk that my security will be invoked. The matter is before the trial court tomorrow. That's the only reason I'm mentioning it.
When was it filed?
My lords, it was filed on March 2026. The notice was issued the other side. We've served. We've also filed an affidavit of service.
When is the matter coming up before the trial court?
Tomorrow, my lords.
This is the matter tomorrow.
my
My
lordship,
lordship,
my
it is a
lordship,
pending matter, my lordship. The stay has been granted in this matter. My lordship.
I'll not take up it now. That
my
matter,
lordship,
yes. Hmm?
Is not allowed. And therefore, it sets up the third party as a tenant. But it files execution suit, gets it by virtue of compromise. And thereafter, whether files execution takes delivery for warrant. State was ordered by this order, but that was communicated to the board of those things are removed. And now, the third party builder board has been put up any day, next week.
We'll see. No, just.
my lordship, my lordship, writ of mandamus, my lordship.
Yes.
My lord, the case is fresh matter. The case is listed before trial court on 5/6, my lord. When it may be taken up tomorrow.
It will come.
My
If it
lord-
is fresh
My
matter,
lord-
it will
my
come.
lordship, there is a threat for my life and property, my lordship.
It was heard in before vacation, my lord, and listed after vacation. It is on 5/6, my lord. When it may be tomorrow, my lord.
Date must have been given.
Date is not given, my lord. It is listed after vacation in the order.
What is urgency now?
My lord, we are like it is vacation eviction, my lord.
Ask your senior what is urgency, come tomorrow.
My lords.
My lordship, this is writ of mandamus, in spite of order passed of protection order passed against the defendant, the police is not at
When is the
all,
writ petition filed?
27/2, my lordship. A notice was also issued. There is a
Wait.
threat for
It
my
can wait.
property.
Yes.
Every day,
Let
my
them
lordship,
come.
in the media also it is coming, my
We will
lordship.
see.
My lords,
Yes, there is no protection for
All
me.
waste of court's time. When this list will complete with all these mentionings,
My lordship, there is a threat for my life and my family also, my lordship.
we will see.
Therefore,
Yes,
it may be listed at least day after tomorrow, my
I will
lordship.
see. Yes.
Trial court has set
Totally.
down the matter for evidence,
Huh?
my lords. Trial court has set down the matter for evidence tomorrow only, my lords. Our application is allowed and they are same was challenged before the sound court. And the matter was set down for evidence, my lords, tomorrow.
When was
itself.
the writ petition filed?
On 9 to 26, my lord, notice is also already issued, my lords. The matter was
All
deferred.
matters of February, urgency is in the month of
My
June.
lords, matter was deferred for 2 weeks, my lords. Thereafter, the matter was not listed.
You know what the matter which were, all the matters which were not, which have not reached from the last 4 months, this court can't take up all the matters now. So this court want to have a manner in which the matters to be listed. So please allow the court. I can't take up all the matters like that. Yes,
I am the dealer of a petrol pump, my lord. Eviction order was passed against the petrol pump IOC. The regular appeal has been filed before the first appellate court. The owner did not accept the notice of the court. In the meantime, execution was filed and I was evicted from the petrol pump. Thereafterwards, I filed an application before the execution court to restore the position to because the RA is pending. I was restored and I was given the position for 3 months. That order has been challenged before the owner, before this honorable court, and my petrol pump has been again attached and closed in view of the order of this honorable
when was
court.
the order?
19/5/26, my lord. I applied for the certified copy. Yesterday, I got the certified copy. My loss per day is 80,000 rupees. I have to pay interest to the bank as well as to the IOC. I filed an impleading application.
Day after tomorrow. Yes.
This, my lord.
My lordship,
Your lordship has expected this matter to be listed today. Matter before the trial court, my lord, is for tomorrow for recording of evidence. Fag end of the
Why
trial.
it is not listed?
In fact, we made a request, my lords. The file was not sent, is what we were informed, and they were asking, my lords, for a memo. The registry, my lords, was asking for a memo, and without a memo, my lords, the registry was informing.
No, it will not, memo for fresh matters.
Please, my lords, it is a fresh
No.
matter. Lordships are directed, my lords, the matter to be listed today because, my lords, the date before the trial court is
So
tomorrow.
if have you given the memo
Please,
to
my
the court
lords.
officer?
Please, my lords.
I don't remember asking, asking the court officer to go, send any memo.
My
If I
lords, yesterday,
remember.
my lords,
I said you
lordships-
just wait. And if it is a fresh matter, it will come. That's what I said.
My lords, and just to submit, my lords, this matter is listed before the trial court tomorrow. I made this request yesterday. Lordships are directed, my lords, for the matter to be listed today. I'm requesting if your lordships can accommodate me, my lords, tomorrow. It is
Office objections are not complied.
Please, my lords.
Look at there tomorrow.
Lordships, kindly.
Yes. Yes, tomorrow, yes. Huh? Fresh matters, don't give the memos, they will come. Yes, next.
My lordship, there is an order of protection, but they are
Yes.
not at all protecting us, my lordship. The police is not protecting us. That is why I have filed this.
Yes.
One CRP matter, landlady's petition, 2017 eviction petition, decreed, but dismissed. CRP was filed before your lordship. Decree was, dismissal was done because my sale deed was.
See all this next week. Yes.
Next week, Lord.
We'll see next week. Not, no, don't give the memos now. Yes.
My lord, urgency the vacating.
Chair, when interim order.
25 minutes.
Huh?
2025 minutes.
You can wait. Yes.
My lords, KB matter with respect to termination of electricity, my lords.
When was it?
My lords, the matter was heard before the vacation. It was supposed to be listed after the vacation, my lords. The matter may be heard this week, my lords.
Next week, I'll see. Please
My
make a
lordship,
mention
this
next
is,
week. Yes.
My lordship, the suit is for eviction, my lords. Party is a senior citizen, 74 years, my lords. His health is critical and his due of,
Is there a writ petition?
it is a CRP, my lords.
When is that? CRP or writ petition? When is the matter?
2024, my lords.
Huh?
2024.
We'll see. Wait for a week. All these old matters, wait for a week.
He's due 6 lakhs, my lords, rent.
Whatever it is, wait for a week. We'll see after Monday. That's what I'm saying. Yes.
DRT matter, my lordship has disposed of the matter on 21/4/2026, my lord, directing the petition to approach the DRT, my lord, and also extended the interim matter, my lord, for a period of 4 weeks, my lord. That was expired in the vacation, my lord. But therefore, I filed an application.
But DRT is working in the vacation.
My lord, the party, my lord, is suffering from
That is
RTC.
not that's not the problem of the court. That is court consciously has given because DRT is working.
My lord, another 2 weeks, my lord, I filed an application.
We'll see whenever it comes. Yes.
Next week, my lord, any date, my lord.
I think every matter I can't tell the advocates repeatedly. I'm saying old matters, please wait.
Execution petition.
No, please wait. Yes, call the list.
Milord, may I make one submission?
Yes.
Milord, in one matter, Milord was gracious enough to allow the petition appeal, but the amount Milord is ordered to be transferred. My colleague is there. It may kindly be taken up for being spoken to tomorrow or day after tomorrow, any day convenient, and the amount has to be refunded to me.
Yes, take it up.
One submission, my lord, on the part of the 2020.
Published.
Further hearing, part of matter, DRT matter, 2023, my lord.
What is urgency now?
My lord, the bank, the petitioner obtained
We'll
stay, my
hear
lord.
this matters next week, not this week. Yes, next. When I am not considered and I said I will take, I'll hear it. There is no use in making repeated requests. Please understand. Please understand. Just call the list.
List number 1, page number 1, serial number 3 to 6, page number 2, 7 to 20.
My lords, item number 7, my lords.
Serial number 7.
My lords, the arguing counsel is out of station today, my lords. The
This matter will come only in the month of July. If anybody wants adjournment. List this matter in the month of July.
Grateful, my lords.
Serial number 10.
At the request of learned counsel, the petitioner. Yes. Yes. Huh?
Writ petition may be dismissed, my lord.
Now,
Please.
you can wait for that. Yes.
Serial number 13. 13
Yes.
for petition ballot next week.
Huh?
Next week, 13.
5 to 34,
1 kilo.
13.
Serial number 13, 1.
Serial number 33, my lord.
Why it's coming up? What is this list? Why all these matters have come? I said fresh. How come it's already noted? This 14. 14 is a fresh matter. 25 from 25 they are not listed. And why are you asking for time?
I have some inconvenience today, madam. Kind of next week, madam.
No, next week. Any matter you are asking adjournment in the month of July.
July.
This is matter in the month of July.
13.
Serial number
14 he has mentioned.
13.
13 July, 14.
33, my lord. Serial number.
No. You are seeking adjournment in the month of July, not in the month of June. Yes. This is matter in the month of July. Yes, next.
33, my lord. 33, my lord.
Page number 3,
30, 33, my lord.
Till 20 there are any matters. Yes.
page number 3, 21 to 34.
32.
20? No, next week. List is matter
33, my
in
lord.
July. Yes, next.
33, my lord. 33.
Yes. Yes.
Page number 4.
33, when do you want?
The first week of July, my lord.
Yes.
Page number 4, serial number 35 to 46.
Hello, 39 serial
Yes.
number. Next week, man. Next week.
Is July 39 also? And why are you filing matters, 25 matters, you don't even get the office objections complied with and wait, and in the 26th matter comes again, you want time.
No, my lord, there the annexures are all are Kannada, so translate.
Doesn't matter, that's the problem of the court, isn't it?
9 matters are connected, madam.
Huh?
9 matters are connected, so.
All 9 matters will take up. Where are those 9 matters?
Kindly give a next week, ma'am.
Give the list to the court officer. Yes, take that list.
Page number 5, serial number 47 to 57.
My lord, 56.
Yes.
Kindly released in the month of July first week.
And why did you file the CRP in 25?
There is an inconvenience. There is an inconvenience. My senior.
No, it's not inconvenience. You have no interest to pursue the matter. For the sake of it, you file and you want to show that the matter is pending in the High Court. That's the only probable reason why all these petitions are waiting from 25 till 26 to get it numbered. This is matter in the month of July.
Page number 6, serial number 58 to 69. Page 7, 70 to 80.
77.
Yes.
Petitioner. I am not well.
This is matter in the month of July.
Please.
Page list number 2. Page number 6, serial number 25 to 28.
Serial number 25. The respondent.
For orders matters, don't call.
Senior not well, so 1 week time.
This is 20?
5.
List number 2, serial
25 is orders. That's what I'm saying. Orders don't call.
Yeah.
No, till 25, it's only orders matter. Don't call 25. Then after interlocutory applications, you call. Yes. Yes.
Page number 6, serial number 26 to 28. Page 7, 29 to 31. Page 8, 32 to 35. Page 9,
Serial number 34.
36.
Serial number 34, my lord. I
Yes.
have to file my statement of objection. It is heard and the interim order has been granted to the petitioner. I have to file my objections. It is ready. I have to obtain the party signature who is out of station. Next week, any date will be fixed, my lord.
You appear for the respondent.
Yes,
At the request of Land Council, the respondent lists this matter in the month of July.
my lord, may I request some.
Interim order only granted.
Kindly extend the interim order.
Granted is extended. Yes.
Page
Short
number
date,
3.
because
The
there's some,
difficulty of the court is, as you have seen,
I can understand.
it is not possible. I can't give any short date. If a short date is
But I
given,
would
I
have-
can't accommodate.
My lord, I would have gone with the matter unless, my lord, that statement of objections party is outside. That's the reason.
This is matter on 17th of June.
Please.
Yes.
Page list number 3. Page number 1, serial number 1 to 4.
4, my lord, serial number 4, my lord, kindly have 10 days time accommodation, my lord. We want to some ascertain some papers, my lord, kindly.
Have
Serial
you
number
informed the other side?
4. I am the petitioner, my lord.
You are the petitioner. Respondent
side.
also has to be
I will
informed.
inform.
No, inform. You have to inform and then make a mention. Wait for your turn. Yes,
Page
next.
number 2, serial number 5 to 14. Page number 3, 15 to 23.
20, 20, 21.
20. Hmm.
And also 23 also.
Hmm. Why?
Because that the government has issued a notification on 7/3/2019, regularizing those permit granted issued as on 18/12/2014. Those bunch matters have been heard, not yet been decided, because that we are waiting for that decision, because there are far-reaching consequences of that one. Therefore, your lordship kindly.
Have you informed the respondents or the other side?
He is the petitioner.
Yes, all these matters in the month of July. Don't give a date. Yes.
2021.
I have filed my rejoinder to the statement of which he has filed. Your Lordship.
Yes, 20, 21, 22, 23. All the 4 matters. Yes, next.
Page number serial number 24 to 29.
Serial number 25, madam. Petitioner, winner not there, 1 week time, sir. Government present.
Yes, AGA.
I am appealing for the petition. The matter is settled before immediately. 25, AGA.
In the month of July,
Serial number
at the request of Learned Counsel, the petitioner.
Serial number 24, my lord.
Serial number 3.
Huh?
Serial number 3.
You are a party in person?
Yes.
Serial number?
3.
First list.
Which list?
First list or second?
Cause 3.
Huh?
List number 3.
List number
Not
3.
yet called.
Serial number.
Yes,
Serial number 24, my lord.
yes, 24.
July first week, my lord. We posted on July first week.
Number 3. correct.
Yes, AGA.
I have informed, my lord.
Is there any interim order in this?
No, no, my lord.
Yes,
Serial number
in the month of July, 24.
29, my lords.
Yes,
I appear for the respondent. I pray for some time, my lords.
you have an interim order in your favor?
No, I pray short accommodation, I pray short, really fix on a shorter date.
Why do you want time?
My lords, the arguing counsel's hurt his head.
This is the matter on 9th of June,
Grateful.
at the request of Learned Counsel, the respondent.
Page number 5, serial number 1.
Not necessary. Yes, list 3.
Mention, madam.
List number 4, addendum.
He is asking for some, what is that? List number?
Number 14%.
List number 3, first matter, he says.
Lordship,
number-
list number 3, serial number 33, lordship.
3.
Number 3.
Huh.
4379, writ petition. Ma'am, last date was 28th April. So Form C fulfillment was incomplete. So I was asked to get that Form C. So today only the courts opened. I'm following with judicial. Please give me short date.
When?
This weekend by
This
this
is the
Friday.
matter on 11th of June.
Thank you.
Lordship, list number 3, serial number 33, my lordship.
Yes,
6th adjournment, lordship.
DRT matter.
Yes, my lordship.
Why?
Senior is has undergone to minor surgery. Is ill health.
Is this matter on, have you informed the other side?
Yes, my lordship.
Connected matter is also there.
Connected matter is also there.
Is this matter on 23rd?
Yes, my lordship. Or 15th. Or in the month of July first week.
List the matter on 7th of July. Yes.
May I make one request?
WP motor vehicles matters. That other benches weekly, one day that they used to take.
That is what we require. That's what I was telling the advocates, wait for a week. So that looking at the what are the pending matters, how to take up, the court will get an idea. Yes.
Please.
Number 1, for preliminary, serial number 1, Bhargav G.
My lords, for the petition.
Yes.
The issued order is at page 19.
Yes.
The petitioner is the defendant number 4. And the respondents 1 to 3 are plaintiff in the suit. It was filed by the plaintiff for the party. Separate position of certain property mover for it. In their case is also got the father of the petitioner as well as the respondents on 1 to 3 are the brothers.
Can you please use the mic?
Father of the petitioner and the respondents number 1 to 3 are the brothers. And a suit for partition was decreed. Against the said judgment and decree, the petitioner herein and others have preferred the RA came to be dismissed. Thereafter, RSA was also filed, it is also came to be dismissed. However, the plaintiffs have filed the final decree initiated the final decree proceedings, wherein, in fact, the defendants have taken contention that one of the properties left over, it was not included. They made an application in the FDP proceedings to include the very said property. After hearing both the parties, the said application was allowed. Agreed by the said order, he has approached this honorable court. The respondents 1 to 3 hearing over the plaintiffs approached this honorable court. This honorable court has also confirmed the order passed by the trial court. Thereafter, the plaintiffs have amended the schedule, included the property
which is left over as schedule number 7. Thereafter, the problem starts. The learned judge has not passed any order with regard to the inclusion of the additional property in the FDP proceeding. Therefore, the petitioner has filed an application. The learned judge dealt with the application without framing any issues and dealing with the matter. They recorded the evidence of the plaintiff, and thereafter there was no evidence from the defendant side. Accordingly, proceeded to pass an order which is Annexure A.
Let's see the order.
Annexure A, page 19 begins.
Whether the respondent number 1 proves that item number 7 of the petition property is joint family property, whether petitions prove that is their self-acquired property.
Yes, these are the points framed at the time of passing the order. There was no points for framed for consideration or to prove either by the defendants or the plaintiff. Just heard the matter. Thereafter, the evidence of the petition plaintiffs were recorded.
What was the earlier order of this court?
This earlier order of this court is confirmed, my lord.
What was the order?
Order is confirmed. The suit was decreed by the learned trial judge.
No. With regard
So
to
for
this additional property to be included.
It has to confirm the order of the trial court. The trial court has allowed the application.
Allowed the, what is the application was to include
inclusion of one more property which was left over. And thereafter, the plaintiff has amended the schedule also, is included the property. No issues were framed on that point. Whether the plaintiffs are entitled for the defendants are entitled for the share in the property or not. Directly proceeded to record the evidence. And he has filed statement of objections. That was also came to be dismissed on the ground that you have filed the statement of objections for the same. And unfortunately, that has been confirmed by this honorable court.
That is what I am asking.
Yes,
what is that order? How can, without there being an issue, without there being any material, whether it is a self-acquired property or it is a joint family property?
Your lordship, while amending itself it was included as a joint family property. There was no opportunity was given to.
That's why please show those orders. That I would like to look at those orders.
I have produced along with the writ petition.
Yes, page number.
That page 53.
Yes.
From para 6, it could be relevant. It is also an admitted fact agreed with the judgment passed in OS number 477/1990. A regular appeal was filed with the instance of the present petitioner. Further, it is resultant in filing the regular second appeal also in RSA number so and so, which admittedly came to be dismissed on 23/8/2011. As such, throughout the development in regular appeal and regular second appeal, the present petitioner had taken active part in the matter. Therein, as such, was aware of every development that has been taking place in the matter. In such a situation, his mere single sentence statement that he would not secure certain documents to file his statement of objection is really surprising. Added to the above, as he has also not mentioned as to what those alleged necessary documents that were required for him to prepare his counterclaim or the statement of objections. In the absence of giving any details as to what restrained him from filing the statement of objections as the earliest, a mere single sentence statement that due to non-availability of certain documents, the delay has been caused is not convincing.
No opportunity was given to the plaintiff to file the objections. That was questioned before this court.
Yes, ma'am. No opportunity was given. The objections.
That was affirmed.
Yes, ma'am. Affirmed. So far as all these proceedings, your lordship kindly, once the property is included, irrespective of I don't think these proceedings were necessary for even for the plaintiff or the defendant. Filing statement of objections to the schedule.
No, so, that's why I'm asking, where is
yes,
that order?
This was not at all necessary.
No, where is that order including these properties?
That is another order, your lordship may kindly say, that is also produced along with the writ petition. Page 47. Operative petition begins from 49. The petitioners are the plaintiffs who are the respondents herein. They have challenged the order passed by the trial court, so far as amendment concerned. The petitioners plaintiff filed a suit for partition and it is contended by the defendant that they have excluded some properties for the purpose of partition. The defendant number 4 filed an application under order 6 rule 17 CPC and the same came to be allowed, again which this petition is filed. It is the contention of the defendant that some of the joint family properties were not included in the suit scheduled property for the purpose of partition. By allowing the application, the plaintiffs were directed to insert the property mentioned in the application and carry out the amendment. The learned judge further referred the judgment in the case of Shio Pujan Roy and other sources.
This order is not at all clear. Where is this order passed by the trial court on this order 6 rule 17 petition?
Your lordship may kindly see. That has been enclosed, may I pass it?
Please pass on. So, while allowing that, the court has left it open. The plaintiff is at liberty to prove that the intending property is a self-acquired property by separate inquiry and also providing an opportunity.
Please, ma'am. So far as the procedure has to be followed, ought to have followed by the learned judges to frame the issues with regard to this point.
He framed the issue.
No, while passing the order, it is framed. It's not in the order sheet and wherever it was not found. While passing the order, the learned judge framed the issues.
So what is the prejudice that is caused to the defendant?
Your lordship, I have not been allowed to prove my case that whether that is a property granted in favor of elder brother. When they were in joint family, one thing has been proved that they are the members of the joint family. While he has filed a partition suit itself contending that it's a joint family property, see, we are in joint family. While they were in joint family only, the property was granted in favor.
So what is this IA, now the present IA? Please come back to that again.
Yes,
Order on item number 7 of the petition schedule property.
Yes, my lord. With regard to the rights of the property, the learned judge has to decide after framing the issues. That procedure has not been adopted. That is my main grievance. And apart from that, also while passing the order, just because I have not led the evidence, the learned judge cannot pass the order in favor of the plaintiff. Unless and until this, the plaintiffs have proved that it is self-accord.
No, who has at your behest, at the behest of the debtor, who say according to it is a joint family property?
According to defendant number 4
whoever it is,
and other defendants, it's joint family property.
According to the plaintiff,
they stated that it is self-accord property as it was granted in favor of his father while they were. And there is a settled law that when any property is granted in favor of the family, and just because of granted in the name of particular person, it cannot be said that it's a joint family property. But the learned judge just referred some.
No, please come to the order. Let's see that.
Please. Para 19, your lordship could see.
Yes.
Page 35. Impugned order, para 19. As per Article 22, 228 of Mullah Hindula, the property which has been granted with the government in the name of the member of joint family became the separate property unless it appears from the grant that it was intended for the benefit of the family. Except Exhibit P1 does not refer that the intended for the benefit of the family. Exhibit P1 does not refer that the grant was intended in favor of the joint family, but it is specifically stated that the land was granted in the name of Chikkaya, who is the father of the petitioners. The said Chikkaya had acquired the said property by way of grant order passed by the then Amaldar of Belur Taluk. By virtue of this grant, presumption arises in favor of Chikkaya that it was his separate property. To rebut the same, the respondent number 4 was required to prove that it is intended for the benefit of joint family. In the case on hand, admittedly, as per Exhibit P1, item number 1 of the petition scheduled property has been granted in the name of the father of the petitioner Chikkaya, way back in the year 1956 by then Amaldar by wide order so and so. Based on the said grant as per Exhibit P2, mutation has been mutated in the name of the father of the petition. Subsequently, on the strength of Exhibit P2, mutation, the name of the father of petition is reflected in the RTC of the said property as per Exhibit P3. After demise of the father of the petitioners, the petitioner being the class 1 legalists have inherited the said
Yes, I have
property.
seen the order.
Please. So my submission and endeavor before your lordship is that proper opportunity has not been given to the defendants to establish whether it is
What is proper opportunity?
proper opportunity, my lord, when see prima facie the property was granted in the favor of father of the plaintiff. When they were
Proper opportunity is, you have marked your, the evidence is there.
no,
on-
your,
on
your
behalf.
lordship, I have not laid evidence.
Why you have not led?
Your lordship may kindly see the start the time for cross-examination. That was rejected, immediately posted for argument.
That you should have questioned it that time, but not after passing the order that no
Your
opportunity.
your
is
lordship
given.
may kindly impugn order if the prima facie it is not in accordance with the procedure.
No, that is one aspect that I heard.
In that aspect only it is that liable to be quashed.
Had an opportunity long back when the issues were framed in this manner.
My lord, one submission. Before that, the 3 years the matter was pending before this honorable court and stay was granted in the writ petition filed by the plaintiff.
How long these proceedings will go on?
Your
like
lordship
this?
may my sub-
FDP of 3
my-
of
your lordship may
23,000.
kindly see it is a valuable property. It's granted in favor of second. Limited time may be granted. We will finish up the evidence and all the things. Opportunity to be given. Matter may be remanded for fresh consideration.
Again, another round of litigation on some other.
No, my
ground.
lord. Time-bound directions may
What
be
is-
given.
My lord, wait. Lordship, suit is of the year 1992.
19?
Suit is decreed in the year 1998. They preferred first appeal, dismissed. Second appeal was at the Honorable Court, dismissed the appeal in the year 2011. In the FTP proceedings, they filed an application to incorporate one more property. It was left by the plaintiff. It was allowed on 28/9/2013.
On 3.
Yes, at the instance of the petitioner hearing, he has participated. We have amended the petition copy. They have not chosen to file objections. So ultimately, I have let in evidence. They have cross-examined in part. Later, they filed an application seeking permission to file objections. That came to be rejected. This honorable court also confirmed it. So later on, they didn't choose to seeking for recall or to file to lead evidence. Even they didn't adduce the arguments. Ultimately, this court below.
What do you say about his submission with regard to the procedure that is adopted?
Well, your lordship kindly see. Only whenever there is an objection, court will frame the issues. There is no objection for their in the FTP proceedings. Court while passing the order frame the point for consideration that is required under the law. So far as that property is concerned, my lord, I have produced all the documents, Exhibit P1 to P11. Only aspect is that documentary evidence has to be looked into. Exhibit P1 is the grant certificate by the government. It is clearly held, court will held that it is a self-acquired property. What they have not chosen anything about to say whether it is granted for the family or not. At this length of time, they came and seeking time before this honorable court.
Heard, reserved. Yes, please.
Reserved.
Till number 2 for orders. Rajendra, yes.
This on the
My lord,
maintainability.
have challenged the order passed by the trial court, my lord. Instead of filing the petition order 47 rule 1 subclause R, I filed the writ petition by mistake. Hence, I request the sound court kindly permit the, convert the proper petition into the MFA, my lord. And necessary changes shall make, my lord.
The petitioner has filed the present writ petition, agreed with the order. Where is it? Against,
Order passed by on 28/4/2026, my lord.
agreed with the order passed in I number 1, invoice number 8004 of 2025, where the court had granted injunction restraining the defendant from alienating or encumbering the property. When a writ petition is filed, officers raise objection with regard to the maintainability, as a writ petition is not maintainable and the petition has to file a MFA. The land counsel with the office objection with regard to the maintainability is sustained, and the petition is the writ petition is disposed of, giving liberty to the petitioner to file the appropriate to convert it, or you want to
Converting.
The liberty is granted to the petitioner to convert this writ petition into a MFA within a period of 1 week from from today.
Permission may be granted to any necessary amendment may be carry out also.
What necessary amendment?
If necessary.
You have to do that, then
Yes,
you
my
have to
lord.
do
Yes,
all
my
that.
lord. Yes, my lord.
It's permitted to convert this into a MFA within 1 week from today. For statistical purposes, the writ petition is disposed of.
Cell number
Much
10.
obliged.
Please don't.
Yadunandan,
For the petitioner, my lord, I would like to withdraw this petition, my lord.
Give a memo.
Please, my lord.
Write a memo and give. The memo is filed seeking to withdraw the writ petition. Dismissed as withdrawn. Yes, 4.
4. Sunil.
A writ petition of 2024 is listed before the court in 2026. Even when the matter is listed, there is no representation on behalf of the petitioner. List this matter for dismissal in the adjourned list tomorrow. Yes, next.
Cell number 5. Cell number 5. Suresh Kumar, yes.
This also same order in the adjourned list tomorrow. 6.
Cell number 6. Cell number 6.
This is a writ petition of 2025, same order tomorrow for dismissal.
Cell number 7.
Adjourned.
Adjourned 7. Adjourned. Cell number 8. Cell number 8.
I appear for the petition, my lord.
Yes.
Here, the petitioner has filed a suit for partition and separate possession in OS number 528 of 2000, my lord. That came to be decreed on 23/4/2021, my lord. Then again, the respondent, during the pendency of the suit, item number 7 and 6, which have been mentioned in OS number 528 of 2000, have been acquired by DRDO, that is Defense Research and Development Organization. So the petitioner came to know that those 2 items have been acquired by the DRDO. He filed an application on 6/1.
No, this is a writ petition of 2025. We will order notice. Who are the respondents?
There is nothing to be stayed here, my lord. Your lordship may kindly order for issue of notice to the
That's what I'm
respondent.
saying.
Yes, my lord.
The petitioner shall take out hand summons on the council. These are all appearing before the trial court. Anything is pending?
No, my lord, because the claimant has died. His LRs have not been brought on record. Therefore, his LRs have been made as parties. Kindly order for issue of notice to the LRs of the deceased person.
Where is that IA for bringing the LRs on record?
No, that has also been dismissed, my lord. That is, I am one of the claimant which I have filed an application to implead me as one of the claimant. LRs have not been brought on record, my lord. The deceased claimant.
Where is the impugned order?
Pardon, my lord?
Where is the impugned order?
Yes, my lord. It is against me.
Impugned order.
Impugned order has been passed on. 15/10/2024, page number 20, my lord.
Page number 20.
20. 20 to 22, my lord.
Read that order.
Pardon, my lord?
Read that order.
IA number 1 of 2023 and 2 of 2023 filed by one Kempaya, that is the petitioner herein, praying to implead him in the case. It is relevant to note that this case has been disposed of on 29/3/2003. Therefore, this case is not a pending case and there is no material on record to show that the judgment passed by this court dated 29/3/2003 has been set aside, modified, or the case has been remanded to the court for
How
fresh
come a
appeal.
writ petition is maintainable?
Writ petition itself is maintainable, my lord, because
Pending before the
no, my
trial
lord,
court.
I have filed an application on 6/1. Your lordship may kindly peruse annexure M at page number 138, my lord. I have filed an application during the pendency of OS number 528 of
You must
2000.
have filed anything during the pendency, but
Yes,
now
ma'am.
no suit is pending, no proceedings are pending before the trial court. It is only in a disposed suit, you filed an IA.
No, I will get right. I have got right only after the disposal of OS number 528 of 2000, wherein that
I'm
case
only
has.
asking you, when a 227 writ petition is maintainable,
Yes, my
or
lord.
are
it
you
is-
supposed to file a CRP or a writ petition? That is what I'm asking.
It's a writ petition.
How? How writ petition?
Because the case has been disposed of, my lord.
So whenever a case is disposed of, it is a writ petition under 227.
Yes, my lord.
This writ petition is not maintainable.
Then, before dismissing my appeal, my lord, the permission may be granted to file CRP against the order which has been passed by the trial court.
File a writ petition in, when is it 3/7/2025, and you don't even comply with the office objection. Suit is
No,
disposed of.
all the
in
office
year to-
objections have been complied
Why
of.
is it coming today only for the first time? When has it come up before? Where is the? where is
No,
that,
I have complied
order?
all the office objections on 21/11/25 itself, my lord.
It is coming up today for the first time.
First time before the court, my lord. No, all the office object, 3 times it has come up before the registrar, my lord.
The learned counsel for the appellant petitioner submits that office objections will be cured during the course of the day. When is this, 19?
No, yes, my lord, I have
2026, February.
21/11/25, I have complied all the office objections, my lord.
You cannot look at what is there in your file. You have to look at what is there, what is the order for the registrar.
May I know the order, my lord?
19/2/2026. You said you will comply with the office objections. Even on that day, office objections are still subsisting.
Kindly grant me 1 week time, my lord. I will look into that and then what is to be complied with.
The
regarding the
council,
office.
then again on 2022, the council for the petitioner partly complied the office objection. The office of following objections had to be completed. Single writ petition is filed for challenging more than one IA to be clarified.
Writ petition is maintainable, my lord. I will convince this honorable court.
Yes. Does this matter on 10th? The petitioners shall make submissions with regard to the maintainability of this writ petition. Yes, 9.
Cell number 9, NS 1.
This also.
This
Yes.
is,
Yes.
this is a plaintiff's writ petition. The plaintiff filed a suit for partition and separate possession. In that suit, the plaintiff filed a memo for withdrawal of the suit. And defendant number 6 to 7 also filed withdrawal of the suit. The both memos has been all out. However, the counterclaim filed by the DAT is continued.
The counterclaim?
Counterclaim filed by the defendant number 8 is continued. So that I have challenged before this honorable.
Notice to the respondents. Issue notice to the respondents.
Cell number 10.
May permitted to withdraw the writ petition, Master.
Yes, take the memo is filed seeking to withdraw the writ petition. Dismissed as withdrawn. 11.
Cell number 11. 11.
Same order. Dismissal tomorrow.
Serial number 12,
Dismissal tomorrow. Appear for, in 12?
12.
Please.
Yes.
My lord, sir.
What is the order
The
impugned?
order impugned at annexure A,
Hmm.
permitting the plaintiff to carry out the amendment based on the factual scenarios are that, my lords.
The order is passed on 4th August 2025,
Please,
almost a year back.
my lords.
What has happened thereafter?
My lords, it has been posted for additional framing of additional issues and giving a chance for the leading the additional evidence.
Still want to argue on this?
Please, my lords.
You still want to argue?
Please, it is at stage of evidence, my lords. Giving additional evidence, if any. My lords, sir.
Then what are you doing by filing this writ petition on, from November to till now? And why should we put the clock back now?
My lords, sir, the impugned order at annexure A speaks regarding the.
Forget about it.
Please.
For the last 6 months, why you have not complied with the objection? For the last 6 months, the matter must have been listed so many times and they're proceeding with the matter.
My lord, sir, I have taken steps for complying and all the, again and again, it has been posted for the, before the restart.
Well, it will be posted because
Please.
you have not complied with the objection.
It has been complied and it has
Notice to
been.
the respondents, petitioner is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 23rd of June. If the memo is filed, list this matter on 24th, or else if the memo is not filed, the writ petition shall stand dismissed without further reference to the court.
Obliged.
Serial number 13 and 14 adjourned. Serial number 15.
This case, I am challenging the order dated 8/1/2026, permitting the plaintiff to amend the petition with regarding the prayer of the plaintiff's concern.
Where is the order?
Order at page number 183, my lord. Operative portion. At page number 187,
Suit is of which year? 24.
suit for injunction. I am the purchaser of the plant schedule property from the father of the plaintiff. And I have permitted him to take in charge of the plant schedule property. Thereafter,
What is the original prayer?
original price injunction. At,
He sought for a bare injunction.
yes, ma'am.
Now he wants
He wants
declaration that he has
declaration as well as adverse possession also separate prayer is wanted to include. And from his birth, he is asking for adverse possession. He is aged about to 34 years. And from 35 years, he wanted to see the adverse possession as a original owner. And I purchased the property in the year 2015, ma'am, from his father.
Since the title is decided, comprehensive seek additional relief of declaration of title in order to avoid multiplicity of proceedings. Where is the original plane?
Like that, page number 25, my lord. At page number 26, he pleaded that through his mother's money was involved in purchasing the property along with his father.
Sir, it is a property purchased.
Purchased by the father of the respondent number 1, the plaintiff. I am the defendant number 2, the purchaser of this plant schedule property.
Please come. When counsel for the petitioner submits that the court, without considering the objections filed by the petitioner who is a defendant in the suit, has allowed the IA filed under Order 6/17 and permitted the plaintiff to amend the pleadings and the prayer where the initial suit is for injunction basing on title, and now it seeks declaration of title and adverse possession, that he has perfected his title to the property by way of adverse possession. It is submitted that the court, by way of a cryptic order, has allowed this petition without considering the objection. This court has perused the order and considering the submission of the learned counsel for the petitioner, there shall be stay of all further proceedings pursuant to the order dated so and so by so and so till the next date of hearing. Petitioner shall take court hand summons on the counsel same appearing with the trial court and file a memo to that effect by 30th of June. If the memo is not filed, the stay granted by this court stands vacated. If the memo is filed on 30th, list this matter on 1st July.
Number 16, Ramesha.
I am appearing for petitioner, my lord. It is a defendant petition, my lord.
Yes.
The impugned order passed under Order 38 Rule 5, attachment before judgment, my lord. My lord, the respondent one, the honorable.
Where is that order?
Annexure A, my lord.
Page number?
Page number 14, my lord. Para 15 and 16, my lord. The finding of the honorable trial court.
Let's read that. What is the suit for?
Suit for specific performance to register the joint development agreement executed by the respondent petitioner, my lord. The para 14, my lord. In the objection statement, defendant 1 and 2 have stated they have called upon furnished security. No order can be passed for attachment should schedule pass. There is no threat to alienation in favor of the third parties. The plaintiff has filed a present suit for relief for agreement to enter into joint development in respect to schedule property against the defendant. He has aware that in so far as has spent 3 crores 46 lakhs 50,750 rupees towards conversion of the property, towards payment of money dependent to put.
What is the order of status quo?
Well, Lord, the order 39 1 and 2 has been came to be disputed by trial court, stating that the documents which have been relied by the respondent one is unstamped. Therefore, that order came to be application came to be rejected, my lord.
It is at MFA. It's filed in MFA. There is a status quo.
Status quo is there.
So what he could not achieve in that, now he wants it by way of this application.
Subsequently, he has filed the application for attachment before judgment, my lord. That I have taken the contention in the objection statement, my lord, is prolonging the matter, not leading the evidence. So indirectly forcing to come settlement of the.
Please come. The petition is agreed with the order passed by the trial court under Order 38 Rule 5 of CPC, wherein the court has directed as issued a show cause notice and furnish security for rupees 2 crores within 30 days from the date of the order. When counsel for the petitioner submits that initially the plaintiff has sought for an injunction and the trial court has dismissed the same. Agreed by that, they filed an MFA. In MFA, the court has already ordered, there is an order of status quo. And now the present IA is filed and the court, without any basis, has directed the petitioner to furnish the security of 2 crores within 30 days. Next 30 days. And it is submitted that the order passed by the court is not sustainable. Next paragraph. Considering the fact that already there is an order of status quo in MFA, MFA, and again passing an order directing the petitioner to furnish security for petitioner defendant to punish the security for 2 crores. Prima facie appears to be not a well-considered order. Hence, there should be stay of all further proceedings pursuant to the order passed in I number 1 of 2025 by so and so till the next date of hearing. Same in this case also, to take out hand summons, file a memo by 1st of July. If memo not filed, the writ petition, the stay shall stand vacated. If memo is filed, list the matter on 2nd of July.
Till number 17, RB Sadashivappa.
My lords, kindly pass over.
Pass over. Yes.
Cell number 18. 18, Tagraj.
No representation, list this matter for dismissal tomorrow
Cell number 19.
in the adjourned list.
19,
Lordship, the petitioner is a member of First Defendant Club, the social club registered under the Register of Societies Act. What has happened, my lord? For the frivolous reasons, they were suspended earlier. I challenge the suspension order way of a declaration and injection suit. When the suit is pending, I adduce the evidence also. The first defendant is postponed for a cross-examination. Suddenly, in between that suit's pendency, they have expelled me, my lord. I filed an interrogatory application, IA number 2, for a stay of the suspension order. That came to be rejected. That's why I'm before your lordship.
What is the suit for? What is the suit for?
Declaration and declaring that my suspension is illegal, not maintainable.
That is a suit.
Yeah, that is
What
my
is
suit.
this IA?
IA is for that. Meanwhile, pendency of the suit, my lord, sub judice, they have expelled me from the membership.
You have questioned the suspension.
I question the suspension.
Now, the interim order which you are seeking by way of this IA
Yes.
is virtually allowing your writ petition, allowing
No,
your
my lord,
suit.
when no, the suit is pendency, during the suit is pendency, they are also contesting. And notwithstanding the pendency of suit, they expel me. I filed an IA for staying of that expulsion order. Let the suit, my very beginning of the suspension itself in the challenge.
Let's look at your plaint. Where is your plaint?
The writ petition prayer, my lord?
Plaint.
Plaint. Hmm? 30, yeah. 30. This one, yes.
Declaring that the order
Yes,
of
ma'am.
suspension.
41, my lord,
41, declaring this order of suspension.
declaring the
dated
order of a suspension dated.
void.
Yes.
And now come to your IA.
Yes, madam.
Same order you are questioning.
No, I questioned the expulsion order. Expulsion, my lord. The expulsion order, I questioned it. Because meanwhile, they've expelled me. They said the suspension order recommends me for the expulsion also. That is why I worded it that also that expulsion order dated to 12/6, my lord. The suspension is 12/4, the expulsion is 12/6, my lord.
Please read the order.
Yes.
Paragraph 12.
Order.
Page number 18.
Yes, ma'am. Para 12. It is contained that the plaintiff, when the matter is sub judice, The plaintiff is not permitted to issue a impugned show cause notice. It is evident the suit is filed by the asserting the illegality of a suspension order dated 21 impugned order cost a notice based on the other charges. As such, the court of they considered that view of the impugned order show cause notice the issued by the defendant society, the plaintiff hosted the purview of the or domain of the adjudication of this suit. Hence, a points taken by the consideration held in negative with an observation that the plaintiff is not precluded from assailing the impugned show cause notice through a separate suit or before the competent forum. And following order, the application filed under section 151 of the
Not
CPC.
relevant.
Yes. No. What happened? The trial court has misguided by himself, my lord. What has happened? I challenged the suspension. The evidence was adduced.
Suspension notice dated 12/4.
Yes.
Is based on what charges?
And the charge sheet, whatever it is there, the declaration suit, I filed it. They're saying
You have to
that
answer my question.
Yes, my lord.
Why you were suspended?
I suspended because I misbehaved in the club membership. That is what I floated the rules of the club during the
That is the cause of action.
cause of actions.
Now, the present suspension order, which you have questioned by way of this IA,
Yes.
is altogether, which is unconnected with that, where you made a defamatory statement or some message against the committee.
Yes.
It's a separate cause of action. Basing on that, they have issued a show cause notice. You submitted your explanation. Court has passed, the respondents have passed an order.
No, my lord, what has happened, the earlier suspension is still pending. That is also the cause of action for setting up the law into the motion. I have made a defamatory suit against them, or whatever it is there. But I would challenge the impugned order of my suspension. Now the expulsion also continue the part of my earlier suspensions, coordinate with that my expulsion. See what has happened, it is not for expulsion, they are not initiated a separate suit for me, a separate proceedings as per the bylaws.
After filing the suit, they have done so. Please come
Yes,
to
yes,
the order.
still suit is pending, my lord. I have adduced the evidence. They have taken the time even for a cross-examination. That time they came with us a new plea, my lord. See, that part is that the trial court is ignored.
Respondent's petition is permitted to take out hand summons and shall file a memo to that effect. The memo is filed on 3rd of July. This is matter on 7th of July.
Till that expulsion can be stayed, my lord, because it is pending before the court.
No.
Then number 20. Raghvendra case.
And for the petition, I discuss.
Yes.
That is annexure E1, page number 84. It is a suit for partition. In a suit for partition, I filed an application to deposit the rents by the tenants.
In a suit for?
Suit for partition. I am one of the defendant in the partition suit. I filed an application to deposit the rent before the trial court. The trial court rejected my application. Already you filed an application under 1 Rule 10. 1 Rule 10 was not considered. 1 Rule 10, I filed a separate writ petition before the Sarva court also. That is also pending. Tenants to be made a party to before the trial court and directed them to deposit.
What happened to that? That order 1 Rule 10 is dismissed.
1 Rule 10 is also dismissed.
Then what did you do?
Then I filed the application for both applications. One is 1 Rule 10, one is for deposit of rent by the tenants. 1 Rule 10 application was dismissed. That is also writ petition is pending before the Sarva court.
What is that writ petition number?
Writ petition number 11450 of 2026.
Just along with so
And I request Sarva court to directed the trial court to proceedings will be.
No. This is matter along with, write on a paper and give along with so and so. This is the matter on 23rd June.
Then number 21.
11450 of 26.
21.
For the petitioner in this matter, my lords. Agreed by the order dated annexure A, my lords. If my lords kindly come to page number 23.
Amendment of pleadings.
Please, my lords. There are 3 applications, a common order is passed.
You are the plaintiff.
I am agreed by order 6 rule 17.
You are the defendant or the plaintiff?
I am for the defendant, my lords. If my lords kindly come to the application, which is available at page number 87, annexure H.
What is the suit for?
Suit is for permanent and mandatory injunction filed by the plaintiff, my lords. The cause of action he pleads on the date of 2015. defendant number 1 has intervened with the possession of Schedule A property and Schedule B property is mine, and he files an permanent injunction. Apparently, if my lords kindly come to page number 87 for a moment in the IA, he wants to introduce, he is not the owner of the property initially. If my lords kindly come to the amendment sought at para number 6A, the plaintiff submits that the subsequent to filing of the above suit, the first defendant brought to the notice of this honorable court that he has executed a release deed dated 8/9/2014. This release deed is executed by the plaintiff in favor of the daughter. So on the date of filing an application, the suit is of the year 2015, my lords. My lords may kindly see the cost title to the application. The suit is of the year 2015. He wants to bring the fact which is prior to filing of the suit which has been incurred as one. Second aspect is, my lords, if my lords kindly come to the prior.
I'm looking at paragraph number, para 6A to be inserted.
Please, my lords, I may be permitted to read. The plaintiff submits that subsequent to filing of the above suit, the first defendant brought to the notice of this honorable court that he has executed a release deed. This knowledge was brought by the defendant number 1 pursuant to filing of the plaint. He didn't plead it. There was a suppression of fact by the plaintiff in favor of the third defendant. Thus, the third defendant was brought on record as a party to the defendant number 3 in accordance with the law. Subsequent to that, upon further verification by the plaintiff, he came to know that the first defendant alone did not execute the said release deed dated so and so, but also his wife Lakshmama and a son by name Baswaraj and another daughter by name Manjula have also jointly executed a release deed dated 8/9/2015. In view of the same, mandatory injunction needs to be passed against third defendant also, directing her to demolish the illegal construction put on the Schedule C property and also permanent injunction. This is the prayer A. Prayer B, to add the word defendant in prayer B. In a suit for injunction, my lord, cause of action pertaining to one particular person is already spelled out. It is not a suit for declaration bringing all the records on play. One. Second aspect, my lords, if my lords kindly come to.
Please understand, in respect of a property, the one defendant has executed given the rights or by way of a release date in respect of 1 and 2. According to him, there is an interference or a construction is made by the defendants. Now that property stands in the name of 2 or 3.
Plaintiff's daughter.
Whoever it is.
Please, my lord. Suit is filed by the plaintiff. On the date of filing the suit, he was not the owner of the property at the threshold itself. He has instituted the suit. Now, daughter has come on the record. She is not sought for any prayer regarding injunction. On the date of filing the suit itself, a release was executed. That is in the year 2014.
No, plaintiff is the father and defendants are the daughters.
Not all the day. It's a suit for permanent injunction, my lords.
Yes.
Defendant number 1, 2, 3 are the third parties. They are nowhere connected to the plaintiff. Yes. Now, Order 1 Rule 10 application and Order 22 Rule 10 application. Order 22 Rule 10 was filed by the daughter, impleading herself to the suit as a plaintiff number 2. Her case is that my father is not the owner of the property. I am the owner of the property. Kindly implead me as a plaintiff number 2 was filed by the plaintiff. That was allowed. Now, that order is also challenged before this honorable court in writ petition, and that is also stayed.
Not necessary. Yes.
Please, my lords. Now, the court below, if my lords kindly come to Annexure A for a moment. Knowledge, release was executed prior to filing of the suit. His knowledge was well aware. Suppression of fact. Trial has been commenced. Now, if my lords kindly come to Annexure A, what the trial court is that trial court points out that there is no any prima facie case made out by the plaintiff and allows the application. If my lords kindly come to Annexure A at page number 23. Is the page number 28 is the reasoning starts by the court below. If my lords kindly come to page number 29, paragraph number 13, reasonings. It states, if really the plaintiff has approached the court with clean hands, instead of filing an IA number 8, that is under Order 6 Rule 17, he ought to have called upon his daughter applicant IA number 1/25. Hope my lords found it. Reason starts at page number 28.
Paragraph.
Paragraph is at page 13, my lords. Paragraph 13, page number 29. Annexure A.
Yes.
Please, my lords. If really the plaintiff has approached the court below with the clean hands, instead of filing IA number 8 under Order 6 Rule 17, he ought to have called upon his daughter in IA number 1, Srimati Manasa, to file the necessary application to implead herself as a plaintiff, but he has not chosen to do so. Next page, my lords. Page number 30. At paragraph number 15. First 2 lines itself. Therefore, it is clear that the plaintiff who has suppressed the material facts. The court note downs that he has however, the aspect itself is not a ground to dismiss the suit is one, it is tells. If my lords kindly come to the 6 Rule 17 operating portion at page number 9, paragraph number 17 for a moment. Hope my lords found it at paragraph number 17, fourth line.
Complete reading this 15.
Paragraph number 15, my lords. However, the aspect of the matter itself is not a ground to dismiss the suit of the plaintiff at this stage. Now it's a prima facie case shown to the satisfaction of the court. During the pendency of the suit, more precisely on 6/4/2022, a gift deed in respect of Schedule A property was executed in favor of the applicant, Srimati Manasa. Admittedly, the plaintiff has filed a suit for permanent injunction and mandatory injunction. However, in respect of plain schedule property, he has not sought for any declaration. Please, my lords. My lords may kindly come to paragraph number 17 for a moment.
You are saying that by the time the suit is filed, he has already gifted the property to his daughter.
He is not gifted the property. There was a release which was executed by the plaintiff in favor of his daughter, telling that Schedule A property has been released in favor of them. There were 3 holders of the property, my lords. 2 of them have released in favor of Manasa now. She is come under Order 22 Rule 10, telling that during the pendency of the suit, I am the owner of the property, she has come. That release deed is executed in the year 2014, wherein plaintiff has filed the suit in the year 2015, claiming that he is the owner of.
What is this 2022?
My lords?
What is this date? 16/4/2020.
16/4/2000 gift deed is defendant number 1. That is my father executed a gift deed in favor of me. That is defendant number 3. In regard to that, that is a gift deed. If my lords kindly come to page number 7, paragraph number 13. In addition to the applicants in IA number 2/25 also contend that the construction is being carried out in the public road, which caused inconvenience to them. In the view of the matter, the proposed amendment is just and necessary to decide the real dispute. However, the court draws a finding here, my lords. However, the court is not satisfied with the conduct of the plaintiff Jagdish. So
No, ultimately, what is the prayer? He says that there is unauthorized construction on the road.
No, my lords, this prayer is, if my lords kindly come to the plaint for a moment. Annexure B, page number 35, the plaint starts.
Come to the prayer straight away.
Prayer is at my lords, page number 42. Wherefore, the plaintiff prays that this honorable court may be pleased to grant an order of mandatory injunction directing the defendant to demolish an illegal construction put on the Schedule B property. Schedule B property is a public road. He does not have any authorization, is one. Second, grant an order of permanent injunction against the defendant, restraining the defendant, his agents, servers, workers, or anybody claiming through under him for proceedings with the construction work of the Schedule C property. The locus of the plaintiff on Schedule A property, if my lords kindly come to the Schedule A property which is shown, he claims to be the owner of the property. On the date of filing of the suit, he himself tells that on the date of filing of the suit, I am not the owner, my daughter was the owner. What is the authorization or what is the locus for the plaintiff to call in question all these aspects, my lords?
Yes.
Please. So,
she wants to be pleaded as plaintiff number 2.
Plaintiff number 2, that has been
allowed.
challenged before this honorable court, my lords. This court has granted a stay of the said order.
Let it go along with that writ petition.
My lords?
Let it go along with that writ petition. Stay
Please,
is
my
granted.
Amendment is questioning the real controversy between the parties. In view of that, my lords, an order of, in fact, there's one Supreme Court judgment, my lords.
No judgments are required now.
No, fundamental character of the suit is changed.
List along with WP number so and so.
7802 of 2020. My lords?
Notices are served in the.
Notice has been served, my lords. Order of this has been stayed. This order has been stayed.
List along with WP number so and so on 17 June. The petition is permitted to take out hand summons on the counsel appearing for the respondent.
Ma'am, until that, let the
You have already a stay.
order of stay of the order, not the proceedings, my lords. I have sought for an interim prayer over it because it is challenging.
I can take up any time, but I'll not grant stay. This is matter on 10th of June. The petitioner shall serve the hand summons on the counsel to the respondent before the trial court and shall file a memo to that effect by 9th of June. If the memo is filed, this is a matter.
Obliged.
So number 22 urgent, 23 Agnes Suman Mahadev.
May please your lordship. Petition before your lordship, not the father of the respond number 1. Respond number 1 has filed a suit for partition in family property. It's an ancestor property also. Some of the property in the suit schedule are only self-acquired property of the petitioner.
What is the IA filed?
IA filed using all the income of the agriculture for himself. That is why the parents have filed a application, father filed application for expenses regarding to lead a life, that like maintenance. The trial court below, with due respect, the said 151 application is not maintainable. It's you have other remedies. The 151 is to wide power to do the justice.
Wide powers will not be used just like that because the plaintiff wants it to be, wants a relief. What you want is maintenance. If you want maintenance, court has rightly said that under the Senior Citizens Act, you have a remedy.
In a partition suit, Miller.
In a partition suit also, then what
It
is
is the
your
inherent
case?
power of the court.
No, correct. What is the case
To
of
do
the,
the
what
some
is the-
ends of justice.
the plaintiff? What is the case of the defendant?
To do the, in fact, we are even ready to give his share in the joint family property, except the self-acquired property. But he is not ready to do so. See, now the old parents, even for lead a life and even for feeding or medicine, everything, they're age old, 80 years one, and even wife is also age old. They are sick also.
You would get it. You get a relief under the Senior Citizens Act. Go there, because this is not an impediment for you to go before the commissioner.
That it fails to exercise the jurisdiction vested in the court.
Nothing is vested in them.
Your Lordship, kindly issue the notice that if suppose come to the
Counsel for the petition's prayer,
compromise.
Issue notice to respondent. Petition is permitted to take out transference of the counsel appearing for the respondent to the trial court and shall file a memo to that effect by 29th. If the memo is filed, list the matter on 30th. Specifically instruct the registry when I say if the memo is filed, only the memo is filed, then it should be listed. Otherwise, it should not be listed. Yes.
29.
30th, it will be listed if provided you file a memo by 29.
Much of it, much of it.
Cell number 24. 24, Mohan PS.
Petitioners are the defendants number 13 and 18 before the trial court. The suit for partition. Respondent number 1 to 6 are the plaintiffs before the trial court. The return statement was filed. The defendant petitioners were placed ex parte on 2/9/2024. The suit of the year 2024. Filed application order 9 rule 7 along with return statement
On?
on 7/1/2026.
When did you come to know? When did you come to know about this ex parte?
Only on 7/1/2026 we came to know about this ex parte. Immediately.
The same day you filed?
Along with the return statement, filed application.
You came to know about it on 7/1. On the same day you filed the written statement?
Along with ex parte set aside application.
How come you know about, let us see, look at your affidavit.
It's a partition suit, all the family members, and one of the family members have informed the case was pending. So other defendants have appeared and filed the return
See the
statement.
order impugned. Please come to the order.
No detailed order was passed. Kindly keep to page number 45, my lord. Impugned order.
Yes.
Mr. HKS advocate filed IA2 order 9 rule 7 of CPC along with Wakalat for
45.
D13 and 18. He also filed a written statement of D13 and 18. Shri CSC advocate submits that IA2 may be allowed on cost of rupees on cost. Hence, on a cost of 500, IA2 ex parte set aside application was allowed. However, the D13 and 18 have not filed their WS within 120 days from the date of service of summons. Hence, WS of D13 and 18 not taken on record, posted for further chief of PW. So my submission is the suit of the year 2024, prior to amendment, the suit was filed. The amendment came into force on 5/6/2025. So it is.
It has no application.
The amendment is not retrospective; it's only a prospective. So I filed a written statement along with the application.
Order passed 27 on 2026.
27/1/2026.
Did you file this writ petition?
Immediately filed the writ petition.
Not immediately, you filed it on 10/4/2026.
Applied for
After
the
4
copies, applied for the copies.
For 4 months. Notice to the respondent. Petition is permitted to take out hand summons.
Notice
Same,
to
if the,
respondent.
if the memo is filed by 6th of July, list the matter on 7 July.
Till number
Notice to
25.
respondent number 7 to 18 may be dispensed.
Notice is
Other.
Give the memo.
I'll file memo.
Memo is filed seeking dispensation of notice to
May be permitted to
respondents.
take notice to trial
7
court
to
advocate
7 to 18.
or 7 to 8.
The same is dispensed with at the risk of appellant. Respondent 1 to 6, petitioner shall take out hand summons. Yes, next.
Till number 25.
Stay the proceedings. It's
No,
for
no.
posted for evidence.
No. Yes. If you want an early date, I can give you early date, but I'll not stay the proceedings. If you want to take out hand summons at the earliest, I
I
can
may be permitted to take hand summons to the
hand summons,
trial court
and the
advocate.
memo shall be filed by 12th. This is a matter on 15th.
Memo could be
Yes,
12/6.
25.
My lord, I appear for the
Appearing
petition.
for respond number 6 to
Where
9.
is that memo? He said he'll give the memo for that dispensation of
memo,
notice.
sir.
I have already recorded, you have to give it there. Take it from the court officer. Yes.
Appearing for respond number 6 to
My
9.
lord, they were not entered caveat, my lord.
My lord,
They were
notice was
appeared.
not ordered to us.
My lord.
We were informed that the writ petition is filed. Voluntarily, we have
That's
filed.
what we'll hear him.
Please, my lord.
You're here will, yes.
I request my lord to pass over, my lord. My senior wants to argue this matter. My lord, the application for, my lord, LR application has been allowed in the FDP proceedings.
Yes.
There was an order earlier.
Pass over next.
Please.
Lords, if I may request, with the lordships, like kind leave, my lords, if they serve a copy to us, we'll file our objections to this. Maybe
Not required in the CRP, in this 227 writ petition, no objections are required.
Yes.
Because we are only looking at the order impugned.
Yes.
great.
Till number 26. Harassment.
Yes.
The petitioners are the purchasers of the property in the year 2014 from the respondent, your lordship. After 6 years from the date of the sale of the property, the father and mother, through the minor children, filed a suit for partition in respect of the very same property which has already been sold in the year 2014. On the ground that father has the bad vices of drinking. I have filed an appeal. Interrogatories have been submitted to the court seeking leave of the court that interrogatories I may be permitted to deliver to the defendant for his answer. That application filed under Order 11, Rule 1 has been dismissed.
Yes.
Now, your lordship, in the interrogatories I have sought the information.
Let us look at that order now. There is order.
Order is at page number 15, your lordship. A non-speaking order without dealing with the interrogatories with the
Point number 7, we'll read.
para number 13, page number 21, your lordship.
We'll read from 7.
From the
Para 7.
para 7, your lordship. The suit is one for partition and separate possession. The scope of inquiry in such a suit is confined to the existence of a joint family, nature of the suit, scheduled property, shares of the parties, and the entitlement to the part. Order 11, Rule 1 and 2 CPCs permit interrogatories only on matters directly on issue and which are necessary for fair disposal of the suit. On perusal of the proposed interrogatory, it is clear that most of the questions relate to alleged subsequent purchase of the properties, bank transaction, mortgages, educational expenses, lifestyle of the plaintiff and the family members. These matters do not directly arise for consideration in the present suit and do not form facts of the case. Several interrogatories are based on assumption and belief of the defendant, seeks explanation and justification, and are argumentative in nature. Such interrogatories are not
Your
permitted.
IA.
Yes, your lordship. IA is at page number 39, your lordship. Court may be pleased to grant leave permitting the defendants to deliver interrogatories in writing to the plaintiffs in the interest of justice and equity, Your Lordship. And the affidavit runs from para 1 to, shall I read the affidavit?
Page number?
Page number 40 is the affidavit, Your Lordship. Page number 39 is the application.
For 1 minute. Oh, where are those interrogatories?
Beg your pardon?
Where are those interrogatories? Yes, let's see this. What is it?
Interrogatories at the page number 46, Your Lordship.
What is this first one?
Did the suit schedule property have been sold to defendant number 3 and 4? When they have sold the, Your Lordship, partition is permissible under the law in respect of the property which are available for the partition on the date of filing of the suit.
That is, these are all like all lead questions you're asking by way of interrogatory.
No, Your Lordship, when they have sold the property,
No, it is a fact. That's the reason why.
no,
you
if
have
it
to
is
go
the
court.
fact, it should have been stated in the plaint, Your
It's
Lordship.
not, the court has rightly said, what is this, did the suit, you have a registered sale deed in your favor. No, they say that that property is not sold to you for the family necessities or for the bad vices of the father, he has sold it. That would be decided by the court. What is this interrogatory for that? Did the suit schedule property have been sold to defendant? That's a fact, which is, that's why they are questioning.
Which has not been accepted by in the pleading, it is not there, Your Lordship. Second is, Your Lord,
Next, what is that? Did not Srimati executed?
because she has executed confirmation deed. She has acted as a guardian to the plaintiff and she has executed the confirmation deed confirming the sale, receipt of the sale consideration, and interrogatory number 3, from the sale consideration which they have received it, they have purchased 2 agricultural property in the name of the husband and wife.
Oh, what all the questions you are going to put forth in the cross examination?
No, that is
all
not-
that answers
No,
you will know.
Your
it.
Lordship, then Your Lordship, I will read order 11, rule 1, Your Lordship. Discovery by interrogatories. In any suit, the plaintiff or defendant by
No,
leave of.
before that, do you say that this question number, this interrogatory number 1 is something to be revealed? First one.
Yes, Your Lordship.
There is a document. The property is sold by way of a registered sale deed. It is for them to say that whether such a sale is bad or not, or whether it's a joint family property, can it be sold to you or not? Whether it is for the family necessities or not. For that, why an interrogatory for that?
For that simple reason, Your Lordship. When the property does not belong to the family as on the date of filing of the partition suit, whether that can be the subject matter of the partition, Your Lordship?
2/4/2014 is your sale deed.
Yes, Your Lordship. Suit is filed in the year 2020 after 6 years from the date of execution of the sale deed in seeking the partition of the very same property. and calling in the plaint that the said property is the joint family property.
Property is a joint family property and the children have a share in that. The father, during when they were minors, if they sell the property, belong to them, they have every right to question it after.
They have every right to question. Your lordship, next interrogation, I will read it, order 11, your lordship.
Read.
In any suit, the plaintiff or defendant by leave of the court may deliver interrogatories in writing for the examination of the opposite parties or any one or more of such parties, and such interrogatories when delivered shall have a note to the foot thereof stating which of such interrogatories each of such person is required to answer. Now, your lordship, this is the judgment of the Honorable Division Bench of the Madras High Court, your lordship.
Take that. Yes.
Para 11 at page number 5 of the judgment, your lordship.
Yes.
I am reading para 11, your lordship. It is also to be noted that only for understanding the case of the opposite party and to strengthen their own case, a party will set interrogatories to the opposite party. Of course, the interrogatories should be usually liberally whenever it can shorten the litigation and serve the interest of justice. Power of interrogatories is not be confined to narrow technical limits, but to be exercised liberally to achieve the end of shortening litigation, reduction of expenses, and serve the ends of justice. The set of questions provided can only be question of fact and not question of law. In other words, interrogatories are confined to facts and it will not be conclusions of law. This provision grants a party right to information from the adversary. The process of interrogatory narrows the issues and makes the trial less time consuming. The primary object of trial is to discern the truth. The truth that is sought to be ascertained is primarily about the correctness of the allegation against the first respondent. It will be useful to refer to the judgment of the Supreme Court in A. Shanmugam versus Arya Chhatre Rajkola Samansatam. That entire journey of the just is to discern the truth. So, your lordship, when the interrogatories are served, the opposite party is called upon to give the answer to that. Without dealing with the interrogatories, the learned judge has dismissed the application without assigning any reasons. It is a non-speaking order. Which interrogatories, I have totally interrogatories in the applications are there. Which of the interrogatories is not connected with the suit? There is no finding. Which of the interrogatories are illusory? There is no such finding. Merely stating that interrogatories should not be issued at this stage. What is the meaning, your lordship? So any person can file a suit for partition after sale of the property after 6 years, when the law of the limitation says that the sale deed after sale, if at all, has to be questioned. 3 years is the limitation period, your lordship. And mother has executed the confirmation deed that it is a self-acquired property of my husband which has been sold.
Yes. Notice to the respondents. In addition, petition is permitted to take out hand summons and file a memo to that effect. If the memo is filed by 24th, this matter on 25th.
Bill number 27. Tejas.
The petitioner may not in this case. If we not reach Annex D, now the return to file beyond 120 days. I think page number 28 here.
Yes. It is ordered.
34 minutes.
It is ordered.
It is ordered, my return not taken on record on the reasoning that the return filed beyond 120 days. Now the suit is filed before the State Amendment Act.
Before the
State Amendment.
When was the amendment?
The suit is filed on 2/5/2025.
2/5?
2025.
And
State Amendment Act number 5/6/2025.
it's a fresh suit.
This is fresh suit, still that.
No. We'll order notice. What will happen?
Yes, ma'am.
Notice to the respondents.
As per the
Additional
respondent
petition
number
is-
4 to 14.
Huh?
Respondent 4 to 14 dispensation may kindly.
The memo is specific dispensation of notice to respondents 4 to 14.
4 to 14.
Petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court.
1 to 3.
That is respondent 1 to 4.
1 to 3, my lord.
1 to 3. 1 to 3. Does this matter? Does this matter on the petition shall file the memo by 7th of July? If the memo is filed, this is the matter on 8th of July.
Obliged.
Serial number 24, notice to 7 to 2018 was asked for dispensation, 7 to 23.
Take that, so no, who has taken, you have taken that matter.
Up to 23.
I understood who has taken, you or she has taken, give it to
Number
her.
24.
Yes.
Serial number 28. Ajit PB.
Appealing for the petitioner, Your Lordship. Lordship, decree holders petition. Initially, petitioner was a tenant and a respondent. Petitioner was running a bakery. Respondent filed eviction suit and that was decreed. RFA was preferred. In the meanwhile, although there was a status quo order, respondent took out delivery warrant and it took custody to some of the movable properties. Thereafter, in the RFA, this honorable court granted me liberty to move the execution code for the appropriate remedy in respect of movable properties that were taken. There we filed section 47.
You're the tenant.
I'm the tenant. Section 47 and liberty was granted to us to initiate proceedings for recovery of the movable properties. And when the movable properties were taken by the respondents, they also executed a warrant bond saying that we will be keeping the property in good condition and we will be returning the property as and when directed by the court in the good condition, failing which we will be paying twice the amount that is stipulated by the mahajars. Now we filed execution for another execution, which is the present subject matter, for delivery of the movable properties. There we filed another application under section 47 saying the properties are in dilapidated condition, so kindly grant us damages. The trial court comes to the conclusion that I have not proved negligence on part of the respondent and I have not placed any material on record to substantiate the amount of damages that I am claiming. And
This order.
order is at page number 15. The reasoning can be found at page number 76. Apologies, Your Lordship. Reasoning at page number 27.
Operative portion.
It starts with paper produced before this court, receipt regarding purchase of that property not produced before this court. According to DHR, after deducting the depreciation amount, the value of the B schedule property is 10,56,000. In order to prove this aspect, DHR not produced any relevant document. In order to ascertain the damages, assessment of condition.
Application is partly allowed.
It's not allowed. It's completely dismissed.
So it says is hereby allowed in part. Page 76.
In, page number 30, Your Lordship.
No, where is the impugned order?
Page number 27. Page number 27, 28 is the reasoning. Page number 30 is the operative portion. It's in the daily order sheet.
Hereby rejected.
Your Lordship, Annexure F, I'm producing the translated copy of Annexure F, which is the bond warrant, which the respondent have undertaken.
Will issue notice to the respondents.
The decree, the execution proceedings may be stayed because
So what is happening now?
now, apart from this, there's no other relief that is pending for me. The
That's what
execution,
I'm saying. What
the,
is,
the execution proceedings will be closed, and I will be made to initiate one more execution proceedings.
the petitioner is agreed with the order of report whereby the petition filed under section 47 and 151 CPC is rejected by the court without properly considering the case of the petitioner. Considering the submission, there shall be stay of all further proceedings. What proceedings will happen?
Execution, if execution proceeding is closed after this,
Say
my
stay
writ
of
petition also
execution.
becomes infructuous.
They shall stay of execution proceedings till the next date of hearing. Same hand summons and a memo shall be filed. Lissus matter. If the memo is filed on 14th, lissus matter on 15th. Yes.
Cell number
Much obliged.
29. Rahmatullah
I
Kutwa.
appear for petitioner in this case, challenging the impugned order at Annexure A. Lords may come to page 20. The execution petition arising out of judgment passed in the GNWC case, which was passed in favor of the respondents.
Respondent is?
Respondent is a father. It is a GNWC matter. Pursuant to which MFA was filed, there was an interim order which was granted. My lord, after the
What is the
thereafter,
order in GNWC?
please, my lord,
What is the
to grant the custody of children to the father. My lord.
custody is granted to the father?
Yes, my lord, but the children are still with us. My lord,
Then
there was
mother
an
filed
interim.
MFA.
We filed MFA. There was an interim
Order.
order granted,
Interim order is?
not to precipitate the matter. My lord. Pursuant to which, my lord's translated copy was directed to be filed in the registry of the trial court records. My lord, since that was not complied, my lord, MFA was dismissed for non-compliance of office objection.
When was it?
My lords may kindly note the dates. I'll just point out the dates. My lords, MFA was filed on 23/2023. Interim order was granted on 6/2/2024. My lord, the order to file the
You have no interim order for a period of 1 year.
no, my lords. My lord, order to file.
And you have not complied with the order of the court.
My lord, now we have complied. MFA is again restored. My lord, since that the MFA is restored, my lord, this execution order will not stay. My lords may kindly come to the.
Restored?
My lord, after pursuant to filing of this writ petition, I'll point out the date, my lord. My lord, recall was filed on 30/4/2026. And my lord, it was restored on 7/5/2026.
7/5?
2026.
Where is the order now?
It was revoked, my lord. Permitted.
Not that. The present impugned order.
Yes. Present impugned order, my lords. Present impugned order was passed on, my lords, 2/5/2026.
Page number.
Page number 20. It starts from page 20, my lords. Operative portion is at page number 22.
Therefore, the respondents ought to obey the order of the court and they have to hand over the custody of the children to the petitioner within a period of 1 week. Otherwise, the petitioner can take necessary action as per law.
Pursuant to this, my lords, MFA has been restored.
Please
Now,
come.
my lords,
The petition is agreed with the order dated 30/11/26. What is the order? 34/2026.
30, no, my lords. 34/2026
This
is
2/5/2026. Petition is agreed with the order dated 2/5/2026, whereby the court has directed the petitioner to hand over the custody of the children to the father. Then counsel submits that against the order passed by the family, by the orders passed in the JNWC case. They filed an MFA and initially stay was granted on 6/2/2024. Later, the same was dismissed for non-prosecution.
16/2, my lords. 16/2.
16/2/2024 and 16/2/2024. Later, on the application made by the father, this order is passed by the court. It is the submission that they filed an IA seeking to restore the said MFA and that came to be allowed on 34.
My lord, not, but IA has not been allowed, my lord. Notwithstanding the dismissal order, I have been permitted to file the translated copies that I have.
Latest order.
Latest order is, my lord, 7/5/2026.
Is it restored?
My lord, I have been permitted to file, notwithstanding the dismissal order, I have been permitted
How
to
can
file
you call it as a restoration of the?
My lord, pursuant to which I have filed the translated copies.
Then court has to recall it, isn't it? Without recalling, it will automatically happen.
My lords, may kindly peruse the order, my lords. I have just.
Sometimes what happens is, first you file the documents, then we will restore the order. That order should follow.
Documents have already, I have also produced that.
Then the court has to pass an order, isn't it?
Please.
Without passing, automatically it will not be restored. Then as of now, it is not. There is no order in your favor.
Please.
It is submitted that on 34/2026, notwithstanding the fact that the matter is dismissed, they were permitted
7/5/20.
They were from on 7/5/2026, an order was passed whereby the court has directed the petitioner, the court has permitted the petitioner to file the translated copies, notwithstanding the fact that the same is dismissed. It is submitted that as per the order, they have
Fine.
Filed the
On
the
19/5.
all the translated copies on
19/5/2020.
19/5/2026. It is submitted that if once an order is passed by restoring the MFA, the even the interim order that is granted will also be restored. It is submitted that as the same is coming up before the court, until the orders are passed in the MFA, the order impugned may be stayed.
My lords, even otherwise, my lords may kindly note the observation. The executing court has observed that the matter, if the order is passed on merit, my lord, there is appeal period of 90 days, my lord, which has not been. My lords may kindly peruse the order, my lords, impugned order.
Anyhow, you're getting stay the what is that? Maybe state considering the fact that you are not filed a petition to restore. Restoration IA is not filed.
It is filed.
Considering the fact that IA seeking restoration of the appeal is pending consideration, and earlier there was an order in favor of the petitioner, there shall be stay of all further proceedings pursuant to the order dated 2/5/2026. Petitioner is permitted to take out hand summons on the council appearing for the respondent before the in MFA and file memo to that effect. Once the memo shall be filed by 20th of July. If the memo is filed, is the matter on 21st.
Very great.
Number 30.
Petitioner. The first respondent initiated the proceedings before the joint register of cooperative. The surety holder of the JDR number 2, my lord, is not at all the borrow the chit fund amount. The government employees, without notice serving to the borrower, directly notice served and attachment order of JDR number 3 and 4.
You're the guarantor.
Guarantor.
So what is wrong if they initiate proceedings against you?
No, my lord, no notice was served to the principal borrower, my lord. He is the principal borrower. The petitioners are guarantors. Since they are government employees, they have
that is what I'm saying. It is a coextensive liability, isn't it?
Without notice served to the JDR number, since the petitioner number 1 and 2, my lord, the borrower is very much available. Without
that's what I'm saying. When you're stood as a guarantor, you can't compel them go against the borrower. It is for them either to go against the borrower or the guarantor. I mean, the principal borrower or the guarantor. It is there. We can't compel them.
Order dated 21 November 25, my lord. They have not received the salary, my lord. Timing, my lord, kindly stay the matter. Otherwise,
why to stay the matter? You have to tell one reason for that.
You will make efforts to.
Then legally it is permissible or not? Whether they can initiate proceedings
they
against you.
Filed application order 41 rule 48, my lord.
At best, what the court can do is only order notice to the respondents, nothing else.
No, stay the proceedings, my lord.
It can't be.
DHR is very much. DHR, he can take steps against the principal borrower, my lord.
You're saying something contrary to law, Mr. Counsel. Please understand that the counsel, the petition is issue notice to the respondents.
No, my lord.
Number 31.
This is matter once a notice is served on the respondent.
Then number 31.
The petitioner, my lord.
Yes.
My lord, the matter, my lord, on commercial code provision, my lord, order 11, rule 1, my lord. I'll just read that provision, my lord.
No, first of all, you tell the court what are the facts,
Yes,
then
yes,
we'll go
yes.
to that.
Yes, my lord. So, my lord, what happens where for the defendant in this matter, my lord, before the commercial court, copy is served on us, plaint with documents However, my lord, several pages are missing. For example, the plaint ends at page 16 and then again starts at page 35. So we don't know what is there in between. Then after it starts on page 35 also, in the list of documents provided, they have called document 1, document 3 till document 19, like that goes on. However, in the plaint, when they talk about document 1 or document 3, everything is contrary to what is there in the list of documents. And even the documents attached to the list of documents are also contrary to what is attached in the list of documents itself. So there is confusion throughout the plaint and the documents, one, my lord. Next is there is no details of documents given, my lord, because in commercial court, what happens when a plaint is being filed, they have to file it along with the detail of document. So detail of document says, as per the provision of Order 11 Route 2, my lord, where it was executed, who has the custody, how did the document go in the chain of custody, and all these 5 details. There's a tabular column, my lord. 5 details have to be given for every document. The reason that is there, my lord, because in commercial court, usually the additional documents are not allowed. Every document should be filed along with the plaint or the written statement. If anybody is giving a document subsequently, they need to give a reason as to why they're giving subsequently, and all the 5 details considering which is given along with the plaint is also considered while giving an additional document. So in this case, detail of document was also not given. We checked with the registry also how was the plaint even taken on record in such a condition. They said earlier they were not checking these things. But now from March or April, my lord, the registry has made it mandatory. Now anybody goes to commercial court for the filing, there is a table stuck outside saying detail of document table, it should be in this format. But however, this was probably filed before or whatever, but this has nothing to do with the registry, my lord. The provision itself says the plaint shall have the details of document. So it's a mandatory provision, my lord. So when we appear before the learned commercial single judge, my lord, every time when we have filed an extension application, we have brought out all these reasons, saying it is not served on us, etc., etc. The sets are not there, pages are missing. All this discrepancy was raised. So what the learned judge says, after that we gave a memo also, my lord, a detailed memo of discrepancy of 4 pages, detailing all the discrepancy after inspecting the court file also, because probably we thought the court file is different, our file is different. We inspected the court file. Even inspecting the court file, we gave a detailed list of discrepancies, my lord. So the court said, giving a memo, I can't give direction. So what we said, my lord, we filed an application. We filed an application asking for directing them to file the detail of document and serve the missing pages and so on, my lord. And what the court says, my lord, the order, it records all the discrepancy. The court records each and every discrepancy, the missing pages, the document missing, everything, my lord. But however, as far as the detail of document, which is a mandatory provision, the court says they have given the details, wherein there's no such detail given at all.
Come to that.
And therefore, my lord, now what happens tomorrow? The 120 days is expiring for me. Now the plaint with documents only is not served on me. And tomorrow there's a risk of my right.
See the order.
Yes,
Where
yes.
is the order?
My lordship's impugned order, my lord, is at Annexure D, my lord, 28 April, my lord.
Page number.
Page number 42, my lord. Lord's page 42, my lordship says, my lord. My lord, in this, my lord, the reasons, my lord, is from page 47, my lord. My lord, 47, my lord, I'll just read the bottom portion, my lord, the bottom para. A few discrepancies are pointed out here also, my lord. The list of the documents filed by the plaintiff is at page 30 of the plaint. In fact, pagination of the plaint is also not in order. After page 10, page 11 is missing. And after page 13, page 14 to 27 are missing. Thereafter, it is followed by page 28 to 30. There are 12 documents, and among them, document number 8 has been struck off by the plaintiff. The documents are shown to be running from page number 15 to page 214. Now, my lord, in the copy served on us, it is ending at page 212, my lord. That also we have detailed in the memo. Like 2 pages are even missing what has been served on us. It's unnumbered in the court file also, my lord. We checked it in the court file also. It is unnumbered, but it is there in the file nonetheless. Now, my lord, below, my lord, serial number 9, my lord, para number 9. The judgments relied by us, my lord, has been reproduced, my lord, because these judgments by the Supreme Court and the High Courts have said that Order 11 is mandatory. Detail of document has to be filed with the plaint. This is settled portion of law from the Supreme Courts and the High Courts, my lord. Now, my lord, next page of my lordship says, my lord. So, my lord, they consider the memo also, para number 11. Prior to filing of this application, the defendant filed a memo dated so and so, highlighting discrepancies found in the plaint. So, all that was there in the memo, then we filed an IA, my lord. Now, my lord, the actual reasoning is at page 51, my lord, the conclusion, my lord. Page 51, my lords, 12th para ending, I'll read, my lord, the last para. Again, my lord, what the clarification given by the court earlier is they say even though the document number and document detail and description is something else, you just file the written statement as it is. Tomorrow when he gives the documents, file an additional different statement. So this parallel read, my lord, again the same can also be highlighted by the defendant in the statement of defense and would seek the liberty to file an additional statement if plaintiff produce the water bills at a future date by seeking leave of the court. Now, my lord, difficulty I'll explain, but then para 13, my lord, next last para. Though the plaintiff has wrongly described some of the documents in the list of documents.
Please come. Then counsel appearing for the the defendant is before this court. Please, the past in. Passed on I number 3, form was number 125 2026, dated 28th April 2026. Then counsel for the petitioner submits that the defendant, the plaintiff has filed the plaint and the details of the documents were not given as contemplated under Rule 11.
Yes, my lord. Order 11, Rule subclause 2, my lord.
Order 11, subclause 2 of the commercial courts.
Well, Order 11, Rule 1, subclause 2, my lord.
Order 11,
Rule 1, subclause 2.
Rule 1, subclause 2 of the commercial courts Act. It is submitted that when all these facts were brought to the notice of the court, in fact, in the order, the court has also considered this, but however, according to the court, the the defendant can file the written statement, and if there is any discrepancy, he can come up with an additional pleadings. Then counsel submits that the plaintiff has to adhere to Rule 11 and so that Rule 11(1), so 2, and it is mandatory in nature as per the judgment of the apex court. If the plaintiff files a corrected copy, the copy containing all the details, the defendant would be able to file his defense before the court, and it is submitted that the reasoning given by the court is contrary to law. Next para. This court, having perused the order of the court, heard the counsels, heard the argument of the land counsel, and this court finds force in the argument. Accordingly, there shall be stay of all further proceedings in so and so on the file of so and so in the next date of hearing. Same, the petition to take out hand summons on the counsel appearing before the trial court, and shall file a memo to that effect on 23rd June. If the memo is filed on 23rd, list the matter on 24th. If the memo is not filed on 23rd, the stay granted by this court stands vacant.
Cell number 32.
Oblige, minutes.
Gurudat PS. 32 Gurudat.
For the petitioner in this case, I'm challenging the execution integrity order issue of attachment mobile. The suit was filed for judgment and arrears of rents. Suit was decreed. Then they filed an execution petition. In the execution, during the pendency of the execution petition, I handed over the keys, and also I paid a part payment of ₹3 lakhs. On 2/5, the last day of working, they filed a memo of calculation, which is contrary to the execution petition. I have 10 lakhs rupees advance. That also has been ordered. He has to be refunded the 10 lakhs rupees advance to me. They said, my lord, 2/5, page number 41, 2/5/26. Decree holder filed in a calculation memo. That calculation memo, I'm filing it, my lord. No. Calculation memo is there. It is very contrary, and excessive amount of the claim, the court blindly pass an order, issue of attachment on memo of calculation. The contrary is completely that the execution petition claim and the claim in the memo of calculation is
You have not disputed it. You only said that you will pay the money.
We'll pay the money. Now also I'm ready to pay 5 lakhs rupees, no, my lord.
What is outstanding?
Outstanding, according to them, it's wrong. It will not come that amount because.
No, when they give a calculation memo, are you not
No,
supposed?
they are not given opportunity to file the objection to the memo of clarification.
That is
And
not-
also they have not given opportunity to me to file that objection to memo of clarification.
You require opportunity to file. You
File.
don't require opportunity to submit. You can say, you can tell the court saying that I have objections to this.
But already they issued memo attachment removal. And I'm ready to pay 5 lakhs rupees. No only I can ready to pay conditional order. may be-
Counsel cannot say that before the court that he has objection as far as the calculation memo is concerned. Whatever submissions you are making before the court, your counsel cannot make before the executing court.
They have made, madam, the court refused it, madam. They passed an order on 2.5 not giving opportunity on the day. Please kindly see that order, my lord. Directly they have
Don't even know, nothing
on the last day of
record.
working, they have done, my lord.
Nothing on record. What is the amount? What is the amount as per the decree? What is the calculation? Nothing.
That memo calculation is there, my lord. Yes.
You should have filed it along with the writ
No,
petition.
I got it later, my lord.
Take that.
Please, please, my lord. Please.
Take that. Decretal amount itself is 21,69,267. When was
Yes.
the decree?
Huh?
When was the decree?
Decreed on, 1 second, my lord. On 15th October 25. Education petition was filed on November 2025, my lord. I vacated on 5/3/26. And I paid 3 lakhs,
Then the balance is 24,32,000 now.
10 lakhs rupees is there, my advance amount, my lord.
That is not deducted.
No, not deducted. In the education business, not deducted.
Or if it is deducted 24,32,000.
For 14 lakhs.
97, then it will become 14,32,000.
Then I have paid 3 lakhs rupees.
Then you paid 3 lakhs rupees.
I have paid 3 lakhs rupees.
Then what is remaining now? Another
No.
11 lakhs is remaining.
But one second, my lord. Damages, they have claimed 3 lakhs rupees, my lord.
Okay, we'll delete the damages also. Then what will remain? 8 lakhs.
I'll pay 5 lakhs.
8 lakhs.
5 lakhs rupees, I'll pay back. Please.
You say that this is bad and that's why you have come to the court.
No, my
What are
lord.
the bona fides? Then you pay 8 lakhs.
Uh,
8
fi-
lakhs is undisputed amount.
6 lakhs rupees, I'll pay, my lord. Please. 6 lakhs, I'll pay. I'll pay, my lord.
Just you need a reason to come to the high court.
No,
valid
my lord.
reasons.
Last day working, they have passed an order.
Petitioner submits that. The court, basing on a calculation memo filed by the decree holder, without even giving an opportunity to the petitioner, had issued the what is this AWM?
Huh?
Or what is meant by AWM?
Attachment of mobiles.
Attachment of mobiles.
Mobiles.
Had ordered for attachment of mobiles. It is submitted that in the said calculation memo, an amount of rupees 10 lakhs that is paid by the petitioner as advance was not deducted, and also towards damages without any basis, an amount of rupees 3 lakh and odd is mentioned in the said calculation memo. If an opportunity is given to the petitioner, it is submitted as contrary to the original execution petition, and the amount that is stated in that, if an opportunity was given to the petitioner, he would have brought all these things before the court. But court in a hurried manner has passed an order on 2/5/2026. It is stated that to show the bona fides of the petitioner is ready to pay an amount of rupees 6 lakhs. When?
1 week time.
Within 1 week, considering the submission of the land comes for the petitioner, there shall be stay of all further proceedings on the condition that petitioner shall pay an amount of rupees 6 lakhs by 9th of June. By 9th of June, if the petitioner pays about 9th of June, on that condition, there shall be stay of all further proceedings. Petitioner shall take out hand summons.
That will come, the matters in Mysore, my lord, council, local council will not take, Mysore it is, not Bangalore it is.
The petitioner, the notice to the respondents. Yes,
Till number 33, addend 34,
Accepted.
T. Sheshgiri Rao.
till the next date of hearing, stay. Yes, 30. Yes.
Impugned order, my lords,
Huh?
the impugned order, my lords, is totally in colloquial.
In Kannada. Is this matter?
Can it be had on Monday, my lords, so that?
Yes, list on Monday, then council shall file the translated copy of the impugned order.
I'm ready.
Yes, next.
Number 35,
Lord, I appear for petitioner. Lord, I am the plaintiff, Lord. In the partition suit, I am the plaintiff. The contesting defendant number 6 with respondent number 4, my Lord. Lord, the defendant number 6 filed an application to summon the witness who is the husband of the defendant number 3 to produce the will set up by the defendant, contesting defendant, my Lord. The application is allowed. Application under order 16 rule 1 and 7. The same is challenged before some. Lord, kindly no, I request this one to note some date. Suit is my Lord, 2016, my Lord. My Lord, the evidence of the DW1 contesting the defendant was commenced on 23 to 2024. It is completed on 26/11/2025. My Lord, the application was filed after the completion of the DW evidence of on, my Lord, 12th February 2026 under order 16 rule 1 and 7. My Lord, the will set up by the defendant, my Lord, dated 2 wills, 13/11/2019. My Lord, another will is 15/3/2021. In the application accompanying the affidavit,
3/2000.
21, my Lord. In the affidavit accompanying the application, the defendant says he came to know the will on 11/10/2023.
11.
10/2023.
And this application is filed on 12th February 2020.
Please, my Lord. My Lord, another, my Lord, another
Who executed this will?
2019, my Lord, mother, defendant number 2.
Defendant number 2.
She died on my Lord, 14/3/20. 14/3/2020. 2021 will, my Lord, father, defendant number 1.
D1 and D2 executed the will in favor of?
This contesting respondent, defendant
Respondent
number
is
6.
Defendant number 6.
Lord, the
Impugned order now.
my Lord, in another assumption, my Lord, another important, my Lord. I filed amended plaint, my Lord, on 5/11/2024. To that, my Lord, the contesting defendant filed additional written statement on 6/12/2024.
Why you, with what amendments you have filed?
My Lord, some sale transaction was taken place. It was not pleaded by me in my original plaint, and hence I filed a written statement. Application for amending the plaint. It was allowed. I amended the plaint, my Lord. He had opportunity at 2 times in the evidence to produce those wills, and he has not taken the those wills in the additional written statement, my Lord.
Pleading is also not taken.
No.
Now what is it
This
now?
is admitted, appreciated by the trial court, my Lord.
Come to the,
In
come to
the
impugned
impugned order para numbers 9 and 10,
Number.
the trial court appreciates my contention.
Please come to the impugned order. Let's see
Lord.
now.
Page number, my Lord, 30. My Lord, page number 20. Para number 9 starts from ink page number 26, my Lord.
Please read.
In this case, para number 9, in this case, the plaintiff has already adduced evidence, and defendant number 6 adduced evidence as DW1 and produced documents in support of the objection filed by the plaintiff, he has relied on the decision of the Honorable Supreme Court reported in 2002 AIR SCW
No, what
278.
I'm asking is, where is the pleading with regard to the wills?
There is no pleading. There is no pleading.
Now you want to summon those.
This is accepted by the trial court, my lord. I will read in further, my lord. 2 para, my lord. My lord, as rightly contended by the plaintiff, when the case is posted for further evidence of the defendant side, the present application has been filed to summon the original will deed from the custody of the witness cited in the publication. The plaintiff has filed a detailed objection and contended that since there is no pleading in respect of the said will deeds, it is relevant to summon the witness and to lead evidence. He has vehemently contended that there is no pleading in respect of said will deeds, and therefore defendant number 6 cannot be permitted to adduce evidence. Accordingly, he has contended that it is settled law that what is pleaded is to be proved and what is proved is to be pleaded. Therefore, the contention of the plaintiff is settled.
The
Next
petitioner
paragraph, very
is,
important.
the petitioner plaintiff has agreed with the order passed in I number 2 of 2026, whereby the court has allowed the application filed under order 16, rule 1 and 7, read with section 151 CPC to summon the witness to produce original will deed dated 13/11/2019 and 15/3/2021. When counsel for the petitioner submits that the evidence on behalf of the defendant number 6 was defendant number 1
DW1,
concluded
defendant number 6.
on 23.
Defendant number 6 was examined as DW1.
Defendant number 6 is examined as DW1 and his evidence was started on 23/2/2024 and concluded on 26/11/2025. Further, the plaintiff has amended the plaint on 5/11/2024 and the defendant has filed the additional written statement on 6/12/2024. According to the defendant, he is aware of these will deeds dated 13/11/2019 and 15/3/2021 executed by D1 and D2 respectively. That is on which date he knows?
Which
on 11/10/2023.
Yes.
23. In spite of the same.
I have produced the additional
In spite of the
statement.
same, there are no pleadings by the defendant. And after completing of the entire evidence of the defendant, now the present application is filed to summon the said documents. When there are no pleadings, any amount of evidence that is adduced cannot be considered, and this aspect was not considered by the court. This court having perused the order of the trial court and considering the fact that without a pleading, in spite of having a reasonable opportunity on the face of it, the order of the court appears to be without any reasoning. Accordingly, there shall be stay of all further proceedings.
No, impugned order only.
There shall be stay of all further proceedings pursuant to the order. Pursuant to the order dated so and so. Dated 10th April 2026 in I number 2 of 2026 by the so and so. The petition is permitted to take out hand summons on the counsel appearing for the respondent.
Respondent number 1 and 4 are contesting respondents. Other are not contesting. I am filing memo.
Take out notice on respondent 1 and 4.
Please.
And shall file a memo to that effect.
Please.
By 14th of July, or else a stay granted and granted by this court stands vacated. If it is filed on 14th, list on 15th. Next, a memo is filed seeking dispensation of notice to
2 to 3 and 5 to 11.
2 and 2,
2 and 3, 5 to 11.
5 to 11.
Please.
Memo is taken on record and notice to respondents is dispensed with at the risk of appellant. Yes, next.
Grateful.
Bill number 20.
36.
Bill number 36.
I appear for the petitioner, my lord.
Yes.
The petitioner seeking writ of mandamus to the respondent number 1 and 2 to consider the representation at annexure H and J, my lord.
Respondents number 1 and 2.
Respondent number 1, my lord, the Commissioner, Regional Transport Department, BMTC, And the respondent number 2 is the Regional Transport Officer, Bangalore West, Rajesh.
What is the representation?
My lord, the facts of the case is that, my lord, the petitioner, he purchased the two vehicles in the name of the petitioner's son, my lord. And the petitioner's son is expired, my lord. And before that, my lord, he has executed the form number 21 for the transfer of the vehicles in the name of the petitioner, my lord. And after the death of the son, my lord, the documents has been transferred in the name of the petitioner. And later, my lord, the petitioner daughter-in-law, she filed the application for the transfer of the RC in her name, my lord. And where, my lord, the second respondent, my lord, he passed the one order, my lord, saying that to file the suit for the declaration or the partition, and till then the RC will be stands in the name of the respondent number 3, the daughter-in-law, my lord. And accordingly, the RC has been stands in the name of the respondent number 3, and she filed the suit for partition with respect to the vehicles, my lord. And after institution of the vehicles of 1.5 year, my lord, she withdraw the suit, my lord. And after withdrawal, my lord, the RC card has to be, owner has to be transferred in the name of the petitioner, my lord. That's why we made the representation to the respondent number 1 and 2, my lord. He has not considered.
Annexure G, page 26, my lord. Proceedings before the trial court, my lord, in OS number 6483 of 24. Petitioner is the defendant, my lord. He has represented this suit, my lord. Kindly see the page number 32, my
Withdrawn,
lord.
it seems.
Please, my lord.
Suit is withdrawn.
Withdrawn.
Kindly see the order, my lord.
Page
Page
number?
32. Application was filed. This order is not challenged by the petitioner. He has contested in the suit. This is accepted. Now decrease.
No, she wants to withdraw the suit.
Yes, my lord.
She has withdrawn the suit.
Because suit was withdrawn because the RC.
So whatever, as per your procedure, whoever is entitled, that you have to know, he gave a representation.
Hello.
If you want to consider, consider, otherwise you say that you are not entitled.
We will consider. It will be considered.
Then counsel for the petitioners have to start.
Kindly fix the time limit, my lord.
Submits that the petitioner has purchased a property in the name, purchased the car in the name of the son. And before it is submitted that he is no more, and before his death, he has what is that form?
Form number 21, my lord.
He has given form number 21 for transfer of the.
29, my lord.
29 to transfer the ownership of the vehicle to transfer the documents in favor of the father. And the same was done by later the daughter-in-law, basing on a representation given by the daughter-in-law. The vehicle was transferred in the name of the daughter-in-law, and an endorsement was given that till that they can, as the daughter-in-law has already filed a suit, the parties can agitate the same for the civil court. It is submitted that the daughter-in-law has withdrawn the suit, that is OS number
6483 of 24.
483 of 2024. 2024. It is submitted that thereafter the petitioner has given a representation to the respondent number 1 and 2, dated 15/11/2025 and 27/1/2026. Hence, there may be a direction to the respondents to consider the petitioner's representation. Learned HCGP appearing for the respondent submits that when the daughter-in-law is withdrawing the suit, the petitioner ought to have questioned, ought to have raised his objection. And when an order is passed, the order should have been assailed by the petitioner. And petitioner, without doing so, the petitioner cannot come before this court. Next part. Having heard the counsels on either side, there's the material on record. The petitioner has given a representation to the respondent stated 15/11/2025 and 27/1/2026. If the petitioner is entitled for any relief, the respondents have to consider the same and pass appropriate orders. If he is not entitled for any relief, the same should have been communicated by the respondents to the petitioner, and they cannot keep the representation pending with them. In that view of the matter, without expressing anything on the merits of the matter, the writ petition is disposed of in the following manner. Yes, accordingly, who has to consider?
Respondent number 1, my lord, he has given
According to the
representation.
writ petition is disposed of, directing respondent number 1
Respondent.
to consider the representation dated.
Respondent
number 2, my lord.
Respondent number 2
To
has to
consider the
consider.
representation dated 15/11/2025 and 27/1/2026 in accordance with law within a period of
4 weeks, my lord.
4 weeks. Accordingly disposed of.
Publish.
And what about, is she made a party?
She is a party, my lord. She is
Here,
respondent number 3, my lord.
this court is not issuing notice to respondent number 3 as the respondents number 1 before considering the representation shall issue a notice and an opportunity to the respondent number 3 and then shall pass appropriate orders on the said representation. Yes. HCGP accepts notice on behalf of respondents 1 and 2.
1 and 2, my lord.
Yes.
Cell number 37,
And respondent number 2 has to consider representation.
2, yes, respondent number 2.
37A in Krishna's copy.
My lord, a wound damage claim was repudiated by the insurance company on the ground that fraud was committed in projecting the insured as the driver. They make a claim for damages to Kia car to an extent of 13 lakhs. But driver of this car is not injured. Other 2 occupants were injured. Somebody else was driving to suppress that he had no driving license. The insured himself volunteered that he was driving. And in fact, that is the reason the matter was repudiated. Then they approached insurance ombudsman. The award of insurance ombudsman is binding only on insurer, not on the insured. My lord, fraud and misrepresentation cannot be gone into by insurance ombudsman. Even a retired judge who presides over consumer protection forums, he also cannot decide the fraud and misrepresentation. Likewise, he had no jurisdiction to decide with regard to fraud. An award is passed directing me to consider the claim.
Let's see that. Let us see that order.
My lord. My lord, order page 45. My lord, may I request page 48 is the award passed. Page
40?
48, my lord.
But this petition has only 42 pages.
My lord, annexure L.
WP
My lord, is it 7518?
7518 is correct.
Page 40.
I think it is at 37.
Annexure L, my lord.
Confirms the vehicle was driven by so and so. The complaint is allowed. Is it the one?
My lord, yes.
Insurance ombudsman.
Insurance ombudsman.
Yes.
Complaint. My lord.
Yes.
Award. Taking into account the facts and circumstances of the case, documents made available and records, and submission made by both the parties during personal hearing, the R1 has failed to provide, that is insurance company, any evidence to support their assertion of misrepresentation by insured complainant with regard to the name of driver. There is serious deficiency of service on the part of R1 in repudiating the claim merely on suspicion and assumption that the insured vehicle may have been driven by someone else than the person mentioned in the claim form without any cogent evidence. And in fact, I investigated the matter. I lodged a complaint before the superintendent of police. Call records were also called for. He did not submit, and they expect me to.
Then what is to be done now? What is the remedy?
My lord, the best course open to him is to approach appropriate forum to recover it by only filing a civil suit.
No, he is seeking for the coverage, the personal accident coverage.
Not personal accident coverage. Wound damage claim. Damages caused to an extent of 12 lakhs. My lord, 2 occupants who were there suffer injury. This person insured will not suffer any injury.
Which year is the accident? Which year is the accident?
This accident occurred
On
in
11/2023.
2014.
So it's pending before the ombudsman from 23 till now. It is pending before the ombudsman from then to now.
No, my lord.
Last 3 years.
For 2 years, for 1 year, it was pending before ombudsman.
When is the order passed by the ombudsman?
Ombudsman order was passed.
30th October 2023.
Yes, yes, madam.
That you are questioning it now.
No, immediately I filed a writ petition. Some office objections were there because the
We'll issue notice.
insurance ombudsman would not.
Whatever it
even-
is, we'll issue notice. Has been
Melody,
almost 2 years.
I seek for issue of notice.
Yes,
and
notice to the
let
respondents.
Insurance ombudsman not precipitate the matter. He cannot execute it, but he will write a letter to IRDA to cancel my
Must
register.
have done it from the last, it's been 2 years.
Melody,
Order
so
is
far
passed
we
in
have
2020.
tried. Several attempts he has made. He has communicated.
I'll give a short date. Let notice go.
Short date.
Yes, notice to the respondents. Does this matter on, when do you want?
Any short 3 weeks.
Does this matter on 29? Yes.
Cell number 38. Sandesh Kumar.
And for the petitions, madam.
Yes.
Similarly connected matters were listed second list serial number 36 matters. This matter has to be clubbed along with that matter. Has to be here along with that.
How many matters? Only
There are
one.
5 matters are there in second list.
We'll hear it along with that.
It can be heard altogether, but the writ petition is not maintainable is my submission.
No, if that is the only submission, we'll hear it. That will apply to other cases
Yes,
also.
yes, very well, but I'm ready in this matter.
Along with that, the matters to have, because already this honorable court considered more than, the issue is, the vehicle purchased by the petitioner has not been registered because it has not been uploaded before cutoff date. This honorable court consider more than 8 to 10 writ petitions. I have, those owners are permitted to register the vehicle without insisting the notification. And the similar.
That's an interim order.
Yes, under minutes.
No, I'm saying it is an interim order or it's a final order.
Final order. Those orders are not challenged before the courts or anyone. The orders are implemented. And the similar grounds, I came before the honorable court. All these matters are.
That order. Have you filed in this writ petition?
I have produced 2 more orders, but afterwards there are 5 judgments, with respect to the similar matters. I will place it by 230, other 3 judgments also.
No, why the writ petitions are entertained and orders are also passed?
Can I explain what the issue is? Lord, under the Motor Vehicles Act, now the central government has got the power to define what is the emission limit, because all these vehicles have now become a major concern. So that power of the central government is not questioned. So what the central government does is it defines various stages based on the European system. For example, currently I think we must be in stage 6. So what happens is in every stage there is a definition of what would be the level of emission. For example, in this writ petition, would your lordship take up the amendment to the rules, which are at page number 23. He has produced a copy of the notification.
Yes.
Annexure A. Kindly take it. Lord, in the Annexure A, the English version, I don't have the page number. Did your lordship get a notification dated 5th of March 2018? Now, on 5th of March 2018, the central government said future manufacturing. 6 years later, when you manufacture, this should be the emission limit. Now, please turn and have a look at the table number 1. Table number 1 says stage 4. That is the stage 4. So, if this is 6 years advance notice is given to manufacturers. So, if you are going to manufacture a vehicle with effect from 1st October 2020, then the emission of carbon monoxide, which is CO, stands for carbon monoxide. If your lordships can see the table, very dangerous emission. So, the level must be 5. Hydrocarbons, so and so, nitrous oxide, another dangerous material, 0.4, and then particulate matter, so and so. Then in the next, for the next stage, stage 5, we made it even more stringent, the emission limit. We introduced a new category called particulate number on the last time, and we reduced the emission limit of particulate matter also. So this way, we have set limits and given them 6 years time for the manufacturers. Now, and we also say, we revised these 2 dates. The 1st October was changed to 1st October 2023, and the 1st April 2024 was changed to 1st April 2026. Now, these writ petitioners have come with vehicles which were manufactured, some of them in 2015. In the among, there are about 5 writ petitions to be listed today. Some of them were manufactured in 2015, 2017. They belong to stage 3. Not which cannot be permitted now. And today they are coming and saying, allow me to register a vehicle which was manufactured then in 2015 and 2017. And about 2 vehicles are
That
manufactured.
is manufactured there and sold now.
Yes, sold maybe in 2021, 22. Now, we do not know whether they were using or not. They should not have used. The law very clearly stipulates that you cannot use a vehicle unless it is registered. What did they do from 2015, 17 and 2024? There is absolutely no explanation. These kind of matters were coming before the other bench, my lord, and we thought there were only about 5 or 6 people, which is why that particular bench disposed of and very clearly observed in the end of it. The final conclusions are, as a one-time measure having regard to the peculiar circumstances, without citing this as a precedent, this is allowed. We thought that is the end of it. There are no more people. Now people are trickling in. There is no end to it. People have been using the vehicles without registrations since 2015, 17 and 24. And today they are seeking your lordship's discretion to register a vehicle in a completely illegal manner. So therefore, my lord, I would oppose these petitions, and there is absolutely no explanation on what happened to the vehicle since 2015, 17 and 24.
You were saying something about the maintainability.
I'm
Maintainability of the writ petition.
That would be my objection. These vehicles are all
No,
manufactured.
that is on the merits of the matter, not on.
No, my objection would be that in accordance with law, it cannot be registered now. The law is very clear that for all these stages, the dates were 6 months, 6 years time was given for the manufacturer. And it was revised, which means they got about 9 years time. From then, we gave another 6 months to register. So all these vehicles are not compliant with the emission standards. So therefore, they cannot be registered would be my objection.
We'll hear along with that. We'll hear along that petition. Let's call this matter along with, what is the number?
Serial number 36.
We'll call along with that.
I will take notice for respondent. I will take notice for respondent.
We'll hear him.
In this one. We will
Date
call,
code,
sir.
madam.
I will call along with.
Yes. Along with the list, we'll call it in the afternoon.
Malas, kindly with next week, Malas, I need to take two more copies. That is.
Then you're not insisting for an order in this.
Malas?
You don't want an interim order in this.
No, in all matters, I don't want any interim matters. Malas, the matter has to be here on merits itself. That's why. In those matters also, court has not granted interim order, matter will dispose on merits itself.
So you want adjournment in this?
After kindly be 2:30.
So today 2:30?
You're going to argue it today?
Yes,
Today 2:30. Very well, notes. I'll come back.
But 2:30 means I'll call it when the matter reaches, when the 24 reaches, because I have to complete it this list. Yes. Next.
Serial number 39 urgent, 40, serial number 40.
Here for the petitioner in this matter, my lords. There's a case where the petitioner had drawn a 220 line.
Please come to the prayer first. In all these writ petitions, please show the prayer first.
Please,
then make your submission.
My lords, in this I've sought for setting aside the impugned order passed in miscellaneous number, my lords. Miscellaneous number 216 of 2022 in awarding an additional compensation, my lords. My lords, the case of the petitioner is that, my lords, the petitioner is KPTCL, which is arrayed.
Let's look at this order. What is that granted?
My lords, the impugned order is at page 16, my lords.
Directed to pay compensation amount of rupees 44,845. As you're seeking enhancement of the compensation.
Please, my lords, the respondents had filed an miscellaneous petition seeking for an enhancement. What has to be appreciated here is that, my lords, the KPTCL.
We will consider, enhancement will consider. Yes, who takes notice?
My lords, it's private respondent, my lords, notice has to be taken. However, my lords, there are a series of
Notice
matters.
to the respondent.
There are series of matters, my lords. The coordinate bench of this honorable court is pleased to stay the impugned orders in all these series of matters, my lords.
That's what I asked. I asked, are you seeking enhancement? You said yes.
My lords, I am not seeking an enhancement, my lords.
That is what I asked. I thought you're a claimant. That's what you're asking. You're seeking enhancement. You're agreed with the order where it is fixed at so and so.
Please,
on what ground you're?
My lords, the KPTCL, while arraying the line, my lords, had already paid a compensation.
Come to the particular portion of that order.
Please, my lords.
What is wrong with that? You please argue later.
Page number 33 of the impugned order, my lords.
33.
Please, my lords.
Mm.
of my writ petition, para number 31, my lords.
Mm.
My lords, in this, the learned trial court observes that the petitioner herein has paid the compensation. My lords, the respondents have, if I may be permitted to
Please
read, my
read.
lords. The respondents have drawn high tension wire measuring 29 meters in length and 35 meters in width. Totally, the respondent has used 1015 square meters of land, including corridor area. 1 square meter is equals to 10.76 square feet. Therefore, 1015 square meters is converted into square feet. It would lead to 1091.4 square feet. 1 gunta is equals to 1089 square feet. Therefore, total area covered for drawing up of high tension wire, including corridor area, is 10.02 guntas. Therefore, the respondents have utilized 10.02 guntas of the land of the purpose for drawing up of high tension wire, wherein they excluded the area of 943.10 in square meter and taken into consideration 9.30 guntas. So the same is taken into consideration for calculation. The market value of the land per acre relating to Chikkabasuru village based on sub-register value as per Exhibit P5 is taken as rupees 5 lakhs pertaining to the agricultural land. Therefore, for 1 guntas of land, the market value of the land is rupees 12,000. The ownership of the land remains with the petitioner, and the petitioner still can cultivate other crops. Therefore, in view of my above discussion, the petitioner is entitled for the diminution value to the extent of 30%. The 30% of the amount out of rupees 12,500 comes to rupees 3,750. If we calculate the diminution value to the extent of 9.30 kuntas, it comes up to 34,000. Further, my lords, thus the petitioner is entitled to the compensation amount under the head of loss of diminution at 34,875 as per own admission, and in view of Exhibit R1, it is clear that the petitioner has already obtained compensation towards erection of tower. But in view of the judgment in writ petition number 39979 of 2013 dated 6/2014, the petitioner is entitled to claim compensation amount of rupees 10,000 per tower in addition to the compensation granted towards diminution value of the land. Hence, she is entitled.
This
to
amount is granted, 44,800.
Please, my lords. However, my lords, what has to be appreciated here is the petitioner herein, that's the KPTCL, while arraying the line, has already paid a compensation, my lords. The tabulation will be found at Annexure C, my lords, at page number 43 of my writ petition. Where, my lords, if your lordship see, land compensation of rupees 58,250 is paid, and tower footing compensation of 2,41,000 is paid.
What is that, tower?
Tower footing compensation, my lords. That is the
Where
tower.
do you get that?
My lords, if your lordship have found in Annexure C, my lords, the last but the second column, my lords.
Total areas in acres.
That's compensation amount. The
Compensation amount, yes.
There.
Land.
My lords, it's land compensation.
58,250.
Tower footing compensation 2,41,000. So total of 2,99,250 has already been paid, which has already been accepted by the respondents, my lords. And now yet again, the learned trial court, without appreciating the said fact that this compensation is given in terms of the DC order that is passed, my lord, Deputy Commissioner's order. The Deputy Commissioner has given 100% value, my lords. My lords, my apologies that the Deputy Commissioner's order at Annexure D is in Kannada, my lords. However, there, my lords, he says that 50% towards the compensation and 50% towards the tower. That is, the entire 100% of compensation is given. In terms of this, and in terms of there is tower A, B, and C, my lords, and the Deputy Commissioners has laid down for each tower certain amount of market value. In terms of that, the KPTCL at the time of arraying the line has given the compensation. The same was accepted by the respondent without any protest, my lords. However, now they go before the miscellaneous petition seeking for an enhancement. And then there is an additional compensation now awarded of rupees 44,000, my lords. Though the petitioners have already paid a compensation which has been accepted by them. Now there are a series of matter, my lords, and in the series of matter, the coordinate bench is pleased to pass an interim order of stay because there's an apprehension of execution that has been.
No, that is right. First of all, I have to be convinced on what is wrong with it. You have paid the money. Is it your case that they can't seek for enhancement? they can seek for enhancement. How you have to demonstrate how they are not entitled for enhancement.
My lords, the land that is utilized, my lords, if your
Now
lordship.
there is a calculation at paragraph number 31. So how it is bad, you have to tell the court.
My lords, there the market value, what they have taken is the sub-register's market value, my lords. So 5 lakh is what they have taken sub-register, but however, we have, when the matter was put forth before the deputy commissioner, my lords, there was a matter which was put forth before the DC, along with all the parties.
Then
Deputy
how the
commissioner-
market value is calculated?
My lords?
How the market value is calculated? You have to take, when you say market value, what value you have to take?
My lords, based on the tower value, DC has laid down the market values, my lords. In terms of that, the KPTC
No,
is
you
issued.
can't argue based on what DC is right. Because DC is not correct, they have gone to the civil court.
My lords, they've accepted that amount. On that, they have gone, my lords. After accepting
No,
it, they out to have gone.
forgetting about accepting, please tell the court why this calculation is wrong.
My lords, for the amount of whatever is used, my lords, the KPTCL has in fact issued the higher amount, my lords, with respect to 9.32 guntas. Whatever the tower has been utilized, the KPTCL has issued that amount, my lords.
No, there are series of writ petitions, just
Yes,
like
my
that we
lords.
can't grant stay in all the matters without the court being convinced with, because a coordinate bench has granted. Any reasoning is given in the order by a coordinate bench why the stay is granted?
My lords, subjective stay is granted, my lords. The reason-
You have to convince me what is wrong with it.
My lords, in fact, my lords, in the series of matter, the coordinate bench, my lords, if your lordship sees annexure F of my writ petition, my lords, E and F.
Yes.
My lords, it's the similar kind of matter which is considered by the coordinate bench of this honorable court with the reasoning that if your lordship sees at page number 57, my lords, the relevant paragraph at 5, my lords, para 5. Suffice it to note that on 14/6/2019, the Deputy Commissioner, after considering as to the erection of lines of 220 kV DC line from existing 220/6 kV station, Hidiur at Chitradurga station, and on the existing corridor, partly on multi-circuit line in between so and so, Chitradurga,
So
assess the
counsel-
diminution value per acre as 2,30,000.
Madam, he has given a reasoning. You just have to tell the court how that reasoning is not correct.
My lords, it's been considered by the coordinate bench of this honorable court that it would amount to double compensation, my lords. The said enhancement that is sought for would amount to double compensation. In fact, my lords, there was a contrary view that was taken by the coordinate bench of this honorable court in the previous roster. However, those orders have been challenged before the division bench, my lords, where there is an order of stay in those matters as well. There are two contrary views that is taken. One of this honorable court which says that it amounts to double compensation, and the deputy commissioner has issued.
Somehow I'm not convinced with what is that you are arguing. Whether how it amounts to double compensation, that you have to argue, and I should be convinced with that.
The double
So this is the amount. This is if this is a correct amount, whatever it is, there should be some particulars, not for some judgment of the coordinate bench or a division bench. Come up with that. This matter on 10th of June.
One in,
The 40 to 44 are the same.
42?
44.
Who takes notice to the respondent?
Well, the respondents are all private respondents.
Yes, notice to the respondents.
All the
This is a matter on, we'll have it on 16. Or if you want before, if you notice cannot be served by that time, 16. Yes.
may I seek one indulgence, my lords?
Yes.
One indulgence, my lords. Serial number 32 in list number 3, my lords.
Hmm.
My lords have directed my learned friend to file an affidavit with regarding to certain. They have filed it today, my lords. I need some instructions. Can I request my lords to have it on Thursday, my lords?
Lord, they have also filed an application seeking production of certain documents. I received the copy of the application along with those documents. I'll take instructions. I'll also file objections to that application. Lords may have this matter next week. Any date may be fixed, my lord.
Monday, my lords.
At the request of the additional AAG, this is the matter on 9th June.
Grateful, my lord. Please.
We'll have it
Interim
on
order may kindly be extended, my lord.
interim order in that matter extended.
Please.
Number 4, my lord, is list number 3. I am withdrawing the petition with
Take that.
before the trial court matter was posted for arguments. Therefore, we
The
can
memo is
permit-
filed, seeking to withdraw the writ petition accordingly. What liberty you want?
Posted for.
No, what is the liberty you want? What liberty? No liberty, that it is submitted that the matter is posted for.
Otherwise, we'll have
No, no, what will be the liberty? That I'm not able to understand.
before the trial court, my lord, matter
No,
is-
that you will agitate. As far as this court is concerned, you want to withdraw because already matter is posted for arguments. The trial court will not consider the impugned order. Memo is filed seeking to withdraw the writ petition as the matter is posted for arguments before the trial court, accordingly dismissed as withdrawn. Yes. Remaining after lunch.
My lord, serial number 34 in.
No mentionings. AAG has mentioned, which I generally don't entertain. Yes. What is that?
ಮೆಮೋಸ್ ತೋಡಲ್ಲ ಇವಾಗ.
ಮೇಡಮ್ ಆಫ್ಟರ್ನೂನ್ ಕಂಟಿನ್ಯೂ
2:30 ಗೆ
ಮಾಡಿದ್ರೆ
memo
ಬೇರೆ
ತಗೊಳಲ್ಲ.
ಲಿಸ್ಟ್ ತಗೊಳ್ತೀರಾ? Lords, with your kind permission, my lords, may I mention matter, my lord?
Who mentioning so?
No, my lord, I wanted to move a matter. In the morning, what happened was my colleague was unable to come in time. It's a matter wherein, my lord, I had filed a commercial OS before the court at Tumkur. My lord, what happens is I sought for an exemption from PIM proceeding by detailing the urgency involved therein. The suit comes to be rejected. While my application was rejected, the suit is also been rejected and the court fee is forfeited, my lord. My lord, therefore, what I was constrained to do was to save myself from limitation. I filed a fresh suit, but the court fee of 4.5 lakh rupees is not being refunded based on the ground that my suit is rejected because I had not made grounds for urgency under 12A of the Commercial Courts Act. Now, my lord, in fact, there's enough and more material produced and the judgments also were produced. The urgency is, my lord, is coming up on 6th for payment of court fee. My lord can have it any time tomorrow or day after, my lord.
The difficulty is now if I entertain one application of yours, every day I'll be flooded by these kind of mentionings at 1:30, 2:30.
I
As a
understand.
matter of procedure, I do not hear any mentioning
I'm really
either
sorry.
at 1:30 or 2:30.
I'm really sorry, my lord. One
Tomorrow you
exception.
can make, I'll consider tomorrow. Yes.
Please.
All continue the list, will complete this.
Sale number 45, list number 1, sale number 45.
Yes.
With your lordships kindly. Appeal was filed under section 63. Just to give a small background, my lords, as per section 164 of the Electricity Act, the provisions of the Telegraph Act are applicable, and in view of the same, my lords, we had drawn a line. And about after 13 years, my lords, they come and file an application under 16.3.
When were the lines drawn?
My lords, 2006. And before the trial court also a contention is taken, my lords, that the compensation or whatever damage was there, if there was any damage as such, it has been paid and the trial court in its impugned order notes it. But now, my lords, an issue was raised before the trial court as regards the delay. And the trial court was pleased to give a finding in the positive, saying that yes, the delay can be condoned. Now, my lords, this issue is squarely covered by the coordinate bench's decision, where the same coordinate transmission line, similar transmission line by the same authority.
Order first.
My lords, the impugned order incidentally is in Kannada. My sincere apologies for the same. I can translate, my lords, were to adjourn it, I'll translate it.
When?
Nevertheless,
When?
2 weeks, my lords, because similarly I have about 40 petitions. I'll have to translate all of them and I'll file them together.
No, whatever this, let me understand.
My lords could have it one week down the line, any date my lords gives.
Does this matter on 10th? Yes, next.
My lords, 45 to 48 are similar.
Yes, all matters.
After 1 week, my lord, so that I can file translations in all of them.
Sale number 49.
Deeply obliged.
49. Ravi Shankariya.
The petitioners are the landowners. On their land, these electricity lines have come. On the transmission lines have put. They have not even notified us for compensation. And only then I made necessary applications to them. I'm just requesting my lord for a mandamus. They have to consider my request and they have to pay compensation in the manner known to law. The difficulty is again, the request that I have made is in Kannada language, in page 67 and 53. And my prayer is only
You have given representation to whom?
to all the authorities, madam. All the respondents have given. In page 53,
Who are laying the lines?
the
Which is respondent?
electricity.
Corporation.
Yes,
Who?
madam, corporation.
Yes.
Just
One end? Who appears for the KPTCL? Let him be there, we'll hear him. AGA takes notice on behalf of the first respondent. First, 1, 3 also. Respondents 1 and 3. Mr. So-and-so is directed to take notice on behalf of respondents 2, 4 and 5. Then transfer the petitions or the copy of the writ petition. List it on 8th. Yes, 50.
Till number 50.
Would my lord want the translation of the?
I am for,
Required.
I am for the petition in this matter, my lords.
Yes.
My lords, the matter is simple, petition for the mandamus, my lords. In this matter, my lords, I have given a representation as the Bescom has given a wrong connection, installed another meter to my premises, my lords, without getting any proper document, my lords. That is why I filed.
Yes. Who appears for this Bescom?
Bescom panel councils are there.
Who is the council?
That is Swamini Ganesh Mohan Ambal and Chennai Gowda, C. Chennai Gowda and Kartikeyan PS.
Where is the list? There are panel councils on this.
That list is not there. They won't be.
Oh, some name. So and so is directed to take notice and the land cast the petitions or the copy of the writ petition. There's this matter on 10th.
Till number 51. 51.
For the petitioner in this case, Malad, I have submitted a representation to the respondent number 2 and 3 to stop the sale of liquor in the vicinity of my residency, which is situated within the proximity of 50 meters from the school. Malad, the respondent bar owner
is the fourth respondent.
Yes, Malad. Malad, in page number
Consider
24,
the
Malad.
Excise, sir.
Is concerned with excise. How will the police? How are the police concerned?
By oversight, it has been mentioned as a police, Malad. In the in the registry has changed it to excise classification of excise, Malad.
It's not about the,
Malad,
you have to change the array of the respondents, not the change in the registry. Array of respondent is superintendent of police would be district. This
Respondent number
deputy
3 is an
commissioner,
excise
Department of
commissioner.
Excise
Malad.
is there. And his grievance is against 3.
Yes, Malad. My grievance is against 3 liquor license. There is
And
an,
we will dispose of this petition. And after giving notice to the fourth respondent, pass orders. No, there is nothing. I'm not passing any order. He gave a representation to give notice to the fourth respondent and consider what is his problem. The
one FIR may be taken on record, Malad. It is a sumoto FIR registered by the jurisdiction police.
not necessary all that because I'm not going to give any positive finding on any of the issues before this court. The writ petition is filed seeking the following prayer. It is a case of the petitioner that the petitioners or the adjoining owners and neighbors of the property of the respondent number 4, wherein the respondent number 4 was running the bar and restaurant. And because of this, the residents of the said locality and particularly the petitioner are put to a lot of inconvenience. It is the case that in the month of December 2025, the respondent number 4 demolished his old building and started constructing the new building with an intention of expanding his bar and restaurant without obtaining the sanction from the concerned authorities. It is a case of the petitioner that the petitioner gave a representation to the third respondent on what date?
On 27 March 2026, Malad.
27th March 2026, seeking cancellation of the license as it is situated within the prohibited limits and the respondents have failed to consider the same. And then AGA takes notice on behalf of respondents 1 and 3 and submits that you would get instructions in this regard. Next person. Having heard the concerns on either side, there is a material non-record. Considering the fact that the petitioner, considering the grievance of the petitioner that the bar and the license to run the bar is granted with the where it is within the prohibited limits where the school is situated. And in this regard, they have given a representation. When a representation is given, the respondent number 3 is bound to consider the same in accordance with law. Considering the same, this court is passing the following order. The writ petition is disposed of, directing the respondent number 3 to consider the representation dated
27 March
27
2026.
March 2026 in accordance with law. Number 2, the respondent number 3. This court is not issuing notice to the fourth respondent, as no adverse orders are passed by this court. Number 3, the third respondent, before considering the representation of the petitioner dated 27/3/2026, shall afford an opportunity, shall issue a notice and opportunity to the fourth respondent accordingly disposed of.
For admission matter, cell number 52, in the house key.
For the petitioners, it's a defendant's petition. My application under order 7 rule 11D, filed seeking rejection of the counterclaim filed by respondent is rejected, my lord. Both the petitioner and the respondents are the defendants herein. The plaintiff has filed a partition suit. Both of us are the defendants. The petitioners are defendant number 1 and 2. The respondent is defendant number 24. I'm the bona fide purchaser. The respondent filed a counterclaim seeking cancellation of my sale deed, which the vendor had executed in my behalf. The counterclaim came to be allowed, and my application filed for rejection of counterclaim is rejected, my lord. The impugned order is at page 10.
Why is it a CRP?
My lord,
Why it is a CRP?
because my 711D is rejected. I sought rejection of the counterclaim, which is rejected. Therefore, I filed CRP, my lord.
No, you can't file a writ petition under 227.
No, my lord. If
Why?
if the order is under 711D, my remedy is to file CRP.
There are several matters are filed under 227. All matters are filed under 227 only.
Please, my lord. This is the original jurisdiction, my lord. It's the supervisory jurisdiction, CRP.
Hmm.
My first submission is the respondent had filed a counterclaim seeking cancellation of the.
No, against this interlocutory order, why the CRP? Not against that, they have come to the court straight away. No, your IA under order 7 to 11D is rejected.
Rejected, please.
So against that a CRP lies, against that a writ petition under 227 lies.
No, my lord. As per my lord, CRP is filed. If the order 711D application is allowed, the plaintiff will file RFA. If
The
my,
first appeal.
please, ma'am.
Against that, this
Please.
is an interlocutory order.
Please, please.
When a suit is pending, you will come under 227. And by filing, this is not, CRP is under 115.
Please, my lord. But as per my knowledge, the practice is such.
Yes?
Your lordship may issue notice to the respondents. My first submission is the counterclaim is
No,
barred by
first of all,
limitation.
you file a proper petition now, this 2025, it's been pending.
Please, ma'am.
First you argue on how it is maintainable. On under 115, your file under 227 or 115?
115. my lord. 115. Lordship may give me a short date. I will convince your lord.
This is matter next week.
Cell number 59, 53. 53.
The petitioner.
Petitioner.
My lords, the respondents have filed a suit for partition and separate possession and also for declaration of sale deed from the year 1968 to 1993 to be null and void, my lords. My lords, here what has happened, the first plaintiff, who is the respondent number 1, who is the first plaintiff, was not even born when the first alienation of the property took place, my lords. The trial court has erred in holding that Article 58 applies, my lords, instead of Article 109 and 1110 of the Limitation Act, my lords. And the trial court has failed to give any findings.
Order.
My lords, impugned order is at impugned order dated 16th June 2025, my lords. After 65 years, they have filed the suit for partition.
That I understand. This is an order where an application is filed under order 7 to 11 is rejected.
Please, my lords.
Is rejected. That's why you're
Please.
before this court.
Please, my lords.
That's what I'm not able to understand. How this, how this are numbered?
Rule 11, Order 7, Rule 11 is concerned, in the event of an order being passed in favor of the person approaching the court, if
It's a regular first appeal lies against.
what the present language of section 115 of the CPC says is that number 2 conditions may not to attract the revisional jurisdiction. Number 1, if an order would have been passed in favor of the petitioner, it should have resulted in disposal of the suit.
That then first appeal lies.
No, no. If the disposal takes place, then it is deemed to be a decree for the purpose of filing an appeal. Because while defining a decree, it says that it includes rejection of the plaint. So if an order is passed allowing the application, then it is deemed to be a decree and therefore an appeal lies.
Yes.
Then if it is not allowed, if it is dismissed, then a contingency arises that in the event if this application was allowed, it would result in disposal of the suit itself. The condition under section 115 is that if such an application, if the order which is impugned under the revision would have resulted in disposal of the suit itself, then it is the revision. So that's why your lordships will.
No, revision is like either under 227 or 115.
115, my lords.
No. Now all writ petitions filed under 227, but not they're nothing but a revision against that order.
Lords,
a supervisory
what happened
jurisdiction.
Your lordships were to recollect, lords, when this amendment came about in 2001, 2002. The scope of 115 was considered in Surya Dev Rai's case. So there it said, now the classical revisional jurisdiction against every order passed by the trial court is now completely ousted because of the amendment to section 115. Now it was restricted only in respect of those orders passed by the trial courts, which if passed in favor of the person seeking to invoke the revisional jurisdiction, would have resulted in disposal of the suit. So only those orders will come before a lordship in revision. Rest will come under 227. That's where even Surya Rai's case said that 227, but said that this is the limited extent within which the jurisdiction has to be exercised.
So for in Andhra and Telangana, what they do is all orders will come as all these petitions are called CRP, civil revision petition. All civil revision petitions, either while mentioning it, you mention it as 227 or 115. But there, when 227 comes, there is no limitation. When 115, there is a limitation. That's the only difference.
Now the dichotomy, earlier, prior to the amendment, this dichotomy was not there. But in the usual course, this honorable court was not entertaining 227 petitions.
But there are the petition CRPs or the 227 petitions are filed against all these orders. I have seen so many.
If a petition is filed, because I just wanted to say this, prior to the amendment, there are judgments of this honorable court which took the view that since 115 is a substantive remedy, which is a revisional remedy, 227 cannot be invoked. So all orders which were passed by the trial court was a revisable order at your lordship stands under 115 when it came under the Code of Civil Procedure. Post amendment, in view of Surya Dev Rai's case, any order which does not result in a disposal of the suit if an order was otherwise comes under 227. And if it is a matter where the order is passed against and if it is to be in favor that is resulting in disposal, that comes under 115. This is the fine dichotomy. If your lordships were to see 115, that language employed, so that's where the
yes. If anything, if the proceedings were pending before the trial court, generally the procedure is like it will come under 227. If nothing is pending before the court and any miscellaneous petitions and all there against that order, that is under 115.
Let's kindly have a look at 115. Just
Yes.
because this essentially was what was considered, in Surya Dev Rai's case. The transition of the jurisdiction from 115 to 227 in respect of certain matters. 115, but if your losses were to see 115, the High Court may call for the record of any case which has been decided by any subordinate court to such High Court, and in which no appeal lies thereto, and if such subordinate court appears to have exercised the jurisdiction not vested in it by law, have failed to exercise jurisdiction, acted in the jurisdiction of its illegality or with material irregularity, High Court may make such order as it thinks fit. This is what is important. This was what was inserted by virtue of this amendment. Provided that the High Court shall not, under this section, vary, reverse any order or any order deciding an issue in course of a suit or other proceedings, except where the order, if had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. So now, so far as Order 7, Rule 11 is concerned, if it had been passed in favor of the revisional applicant, it would have finally disposed of the suit. So only this is what is available, under 150. Rest of the matters will come before Lord 600 227. That's
Yes. Yes, sir.
Please, Manoj.
Please come to the order. Where is the reasoning part? Which para?
My lords, in nowhere they mention about the delay of 65 years, my lords. The
No,
plaintiff
in
has.
this order, where
Please.
is the discussion?
In para 6 minutes, para 6, and in the recent point 1.
That's what this limitation aspect is a question of fact and law,
Please,
which
Manoj,
cannot be decided at this stage. It requires evidence. That's why the court has dismissed it.
My lords, they have taken only
Paragraph number
consideration of
12.
article.
Paragraph number 12.
My lords, one point for consideration. They article 109 and 1110 applies, my lords. This is a suit for partition, my lords. Just on the basis of declaration, they're saying they're considering Article 58. They have never discussed about the partition, and why were they not approaching the court since past 65 years, my lords? I have
That's what the court said. No,
a
it can't be.
judgment. I'm relying on a judgment, my lords, passed by the apex court.
Please come. All notices to all respondents necessary.
Please, my lords.
The issue notice to the respondents. In addition, petition is permitted to take out hand summons on the counsel appending to the respondent and shall file a memo to that effect. This is matter. Once list this matter, memo shall be filed by 20th of July. If the memo is filed, list it on 21st. Yes.
Number 54. Ajit.
No representation for disposal. Tomorrow.
Cell number
Yes,
55. Cell number 55. Diallocate.
Against the rejection of Order 7 Rule 11.
Yes.
But the defendant's application at 711 was rejected. The application which had been filed on the ground, the plaintiff had no legal right to sue, and thereby there is no cause of action for the suit. For this reason, because the respondent.
What is a suit for?
Suit for a declaration declaring that the judgment and decree passed in the suit is not binding on the response 1 and 2. That is the, last I will come to that. The suit which had been filed among the family members of the petitioners in OS number 903/1995. Your Lordship may at page.
At page 41.
Please, ma'am. And the operative portion, my lord. Your Lordship may at page number 82, my lord.
82.
82. The judgment and decree, a legal heirs of the predeceased son and daughter, each children of late Timmaya are entitled equal share, plaintiff 1 and 2 together entitled for 1/3 share, and defendants 1 and 2 each entitled for 1/3 share.
Yes.
In this judgment, my lord, the court held that the will which had been executed by the grandfather of the petitioner is invalid. The first petitioner who had sold the property to the
This suit was decreed on 18/8/2004.
Madam?
This suit was decreed on 18/8/2004.
Please, madam.
Now, who is the plaintiff in the present suit?
The petitioners were the defendants. The petitioners had sold the property. First petitioner had sold the property to the response 1 and 2. On the basis of the will which had been executed by the grandfather, and that will was held invalid in the suit. And even in the appeal also it was confirmed. The judgment and decree was confirmed. The purchaser files the suit declaring that it is not binding. When he has purchased the property under the will, no legal right that arises.
Please come to the order.
Please,
come to the order. Impugned order.
Impugned order. My lord, relevant para at page 6, my lord.
Page 6.
I mean 124. Another important factor that requires consideration is that the defendants have sought to reject the plaint on the ground of adjudicator. The court, your lordship, got 124.
Paragraph number?
Paragraph number 9. In the order. (124).
I'm looking at 124.
Page 6, para 9 of the order.
Page 124 is a decree. Suit of the plaintiff is partly declared.
124, sorry my lord, maybe the page number. The OS number 265/2005.
No, I'm asking you about the present impugned order. That is at page number 164.
In my, this is 124.
Sorry, 164. Paragraph number 9.
9, my lord. Another important factor that requires consideration is that the defendants are sought to reject the plaint on the ground of adjudicator. The court cannot reject the plaint on the principles of adjudicator as the same request trial. In 2023 SCC online SC 224/59, the apex court has held that plaint cannot be rejected on the ground of adjudicator, as the previous suit documents have to be seen. Since the very plea of the defense in the instant application is purely based on the aspect of adjudicator, same cannot be considered. On that ground, it has been rejected, my lord. My plea is not that only, my lord.
Let us see your plea. Where is that application under Order 7, Rule 11?
Along with that, my lord, I have also taken contention. At page 112, my lord. That for the reason stated in the accompanying affidavit.
I think something pages are not matching.
Sorry, mistake. Application annexure F, my lord. Annexure F.
Yes.
Reasons stated in the accompanying affidavit.
Let's look at the affidavit.
I, Narsimha, so and so, I am the defendant number 1. I state the present affidavit is filed in support of the application filed at 711D. I submit the relief sought in the present suit by plaintiff, namely declaration, the judgment and decree passed in.
Now, basing on the pleadings in the plaint, this application cannot be decided. For that, court has to look into several other material, which cannot be decided under Order 7, Rule 11. The court has rightly held that.
Apparently, my lord, on the face of it, my lord, what I submit, my lord, when already the will, the judgment and decree.
No, you're relying on a judgment and decree passed by that has to be looked into by the court.
No, that's what I'm submitting. He has sought for the declaration of that suit that is not binding on him. And when there is purchaser do not get the legal right, because already this will is held to be invalid and suit is decreed. When it is held invalid, my lord, when there is no legal right, there is no cause of action for the suit to file. That's what my contention, my lord.
Please come. The petitioner who is agreed with the order passed in I number 1 of 25, invoice number 265, 2005, dated 1st August 2025, whereby the court has dismissed the IA filed under Order 7 Rule 11A and D of the CPC. The respondent herein, who is a plaintiff, has filed the suit seeking declaration that
on the basis, sorry, on the basis of the will, the property had been sold. Property had been sold to the purchaser on the basis of the will. That will is held invalid in that suit. That is what I am submitting, my lord.
that I'll record. The seeking a declaration that the judgment and decree is not binding on the plaintiff. In that, the defendant, who is the petitioner herein, has filed an IA seeking rejection of the plaint on the ground that the sale deeds dated 18/5/1995 and the sale deed dated 14/7/1995 alleged to have been executed have attained finality upon confirmation in the regular appeal. Hence, the suit is barred by res judicata, principles of res judicata and constructive res judicata, and is liable to be rejected. The court has considered the IA and dismissed the same. While dismissing the same, the court has observed that in order to adjudicate an application filed under Order 7 to 11 CPC, the court has to consider only the plaint averments and the document annexed to the plaint. As per the plaint averments, the cause of action arose when the judgment and decree was passed on 19/8/2004, OS number 903 of 1995, and when the defendant number 6 approached the acquisition authority, and also when the defendants made an attempt to dispossess the plaintiffs by denying the plaintiff's title and possession. The plaintiff defendants have sought to reject the plaint on the ground of res judicata. The court cannot reject the plaint on the principles of res judicata, as the same requires trial, and the court had relied upon the judgment of the apex court in Keshava Sood versus Aarti Pradeep Sood, reported in 2023 SCC online SC 2459. And the court has further observed that Since the very plea of the defendants in the application is purely based on the aspect of res judicata, the same cannot be considered for rejection of the plaint. As in this regard, evidence has to be read in whole and accordingly dismiss the application seeking rejection of the plaint. Plaint counsel appearing for the petitioner submits that when basing on uh, the will, when a document was executed, and in the earlier proceedings, when the will is, what is the finding in the earlier proceedings? The will was?
Will was invalid and the suit was decreed
The
for
court
partition.
has considered the said will in the earlier proceedings and has and has decreed the suit, and even in the appeal, the same appeal.
Among the family members, my lord, he is a purchaser, purchased the suit, and the suit which had been filed among the family members, and that was decreed holding it, the will is invalid. Then the purchaser files the suit, it is not binding.
The against that an appeal is filed, and the appeal has become and even the appeal was also dismissed, and the judgment and decree have retained finality. And counsel submits that is barred by res judicata, and the plaintiff cannot file a suit on the same grounds which are already decided in the earlier suit. The trial court has failed to consider all these aspects and dismiss the petition. It is submitted that there is no cause of action for the plaintiff to file the suit, and the court ought to have considered the application filed by the petitioner and defendant. Next part, having heard the learned counsel for the petitioner, there is entire material on record. This court has perused the order passed, particularly the order that is passed by the trial court. For the cause of action to file the suit, the plaintiff has stated about the different causes of action that has accrued to the petitioner, to the plaintiff, and according to the defendant, the suit is barred by res judicata. The court at the trial court has rightly observed that the plaint cannot be rejected on the principles of res judicata, and the same has requires trial and in the light of the judgment of the apex court in Keshav Sood versus Aarti Pradeep Sood referred supra, and has rightly rejected the application. The grounds that are raised by the petitioner cannot be considered at the stage of 47 at this stage, and it requires evidence, and that can be decided only after the evidence is adduced by both the parties. In view of the same, this court do not find any reasons to interfere. Accordingly, dismiss.
Lordship kind merely, my lord, with an observation that whether the to court to consider whether there is legal right and cause of action to continue the suit, my lord.
How?
Because
how the court will consider
this aspect of the matter.
That aspect will be considered only after when the issues will be framed with regard to that, and you have to adduce evidence, and only the court will
That is
consider.
the contention which I have taken before the court.
All the contentions are left open to the parties.
Cell number 56, adjourned 57, A. Abdul Ramanan.
Abhinav Ramanand.
Abhinav Ramanan.
Yes.
My lord, this is the defendant's petition. My lord, wherein, my lord, an application under Order 7 Rule
What is
11
the
was
suit
filed.
for?
Suit is filed for partition. My lord, without seeking, my lord, the challenge to the sale deed, without seeking cancellation of the sale deeds. My lord, the latest judgment of the division bench of this honorable court, my lord, has held that, my lord, without seeking cancellation, a suit for partition is not maintainable, and such suits are liable to be rejected under Order 7
Let's
Rule
see
11.
the order first.
Please, my lord. Lords may kindly take. Lord, page 14. The reasoning, my lord, is at page number 16. Plaintiff has
What you
filed-
said was To reject the plaint as it does not disclose any cause of
Cause
action.
of action,
from
barred by
plaint government.
limitation, and my
Barred
lord,
by law,
yes,
law of
please.
limitation.
On these two primary grounds, my lord, I had filed the application.
Before this, let's go to your IA.
Please,
Where
my
is
lord.
that IA?
My lords may kindly take page number 24. Reject the plaint as it does not disclose any cause of action from plaint governments. It is also barred by law and provision of Law of Limitation Act 1963.
What did you say so in your affidavit? How it is barred?
Please,
by
my
law?
lord, please take para 3, my lord, of the affidavit, page 25. Submit that the case of the plaintiff, as could be seen from the averments in the plaint, is that the plaintiff and defendant 1 to 6 are joint family members. In para 3 of the plaintiff mentions that her father expired on 23/1/1981 and mother 26/9/2004. At para 8 of the plaint, averments, it is averred that the name of Muni Chennamma entered in revenue records of the suit scheduled property. She and defendant 1, 2, 4 to 6 sold the entire B scheduled property and some portion of suit A scheduled property in favor of defendant 7 to 9. The said sale deeds dates cause of action and not sought for any cancellation. The plaintiff have not whispered about my sale deed and only mentioned that I have leased out building to DMart without seeking any cancellation of the sale deeds. Now what happens, my lord, is please take, my lord, the plaint now. My lord, the plaint is produced at page number 35. My lord, in the plaint, my lord, at para 3, the plaintiff, my lord, who is the daughter, she, my lord, says the father passed away in 1981.
No, in the plaint she mentions about the sale deeds.
Sale deeds, yes, please, my lord. And mother passes away in 2004. Say 24 years have passed. Sale deeds have, my lord.
The sale deeds were executed according to the plaint.
2002, because mother passed away in 2004. Plaintiff herself admits that her mother, along with the brothers and sisters, sold the property to defendants. My lord, sale deed is of the year 2002. Now, suit is filed in
No,
2021.
it is stated in the plaint.
Yes, please, my lord. In 2021, my lord, the present suit is filed without, my lord, seeking cancellation of those sale deeds, though it is stated in the plaint. But this is the latest, my lord, the position of the. May just pass on. May just request that copy, my lord, that is office copy. May just pass on this, my lord. Sorry. My lords, may I please take para 1, my lord, similar circumstance. My lord, the present appeal has been filed seeking.
Para number?
Paragraph 1, my lord, the very first paragraph. The present appeal has been filed seeking to challenge the judgment and decree dated 24/2/23 in notice number so-and-so, passed by so-and-so. By the impugned judgment, a suit filed for partition and declaration was dismissed by the trial court under Order 7 Rule 11A, B, D, similar provisions as that of mine, my lord, of CPC, holding that the plaintiff does not disclose any cause of action. Suit has been filed with insufficient court fee and barred by limitation. Now, please take, my lord, para 4. During the pendency of the suit, an application filed by defendants under provisions of Order 7 to 11, setting out 3 grounds. Firstly, suit barred by limitation, no cause of action, no proper court fee. It was contended that the application, that declaration that was sought for were in respect of 3 sale deeds of the year 1980 and 2 release deeds, and no challenge to these sale deeds after 42 years can be maintained. Now, please take, my lord, para 5. In reply to said application, plaintiffs contended that the cause of action to file suit only arose in 21 when the respondent defendants gained knowledge thereof. Similarly is what has been stated in my plaint also in the case. Now, please take 7, my lord. The learned trial court, after examining the plaint provision of plaint and provisions of Order 7 to 11, as well as provisions of Hindu Succession Act, and relying on judgment of the Supreme Court, held that the court fee should have been assessed as per 35(1). In addition, it was held that since material was produced to show that the cause of action arose in the month of December 2021, and since the sale deeds were executed in the year 1940, suit was hopelessly barred by limitation. Now, my lord, please see, my lord, the reasoning of this honorable court. My lords may kindly turn to page para 21, internal page 22, my lord. So, this honorable court, my lord, by referring to the decision of the honorable apex court in Dahiben's case, held that where a suit appears from the averments of the plaintiff to be barred by law, it shall be rejected in terms of Order 7 to 11D of CPC. Thus, a suit which is barred by limitation would also come within this definition. It was further held that where the plaintiff files a case with a clever drafting to make out a illusory cause of action, to bring the suit within the period of limitation, the provisions of Order 7 Rule 11 of CPC would come into play. And where a plaintiff deliberately did not mention the date of registration of the sale deed, since it would be evident that the suit was barred by limitation, the omission was such that so as to mislead the court to this case, this issue. The suit was thus held to be barred by limitation. Now, please take, my lord, page para 22. Thus, where from a plain reading of the plaint, no cause of action is disclosed or the suit is barred by limitation, the court would not permit the appellant plaintiffs to unnecessarily protect the proceedings in the suit and would put an end to the
No,
litigation.
in this case,
Please.
where the sale deeds were executed in the year 1980 and a suit is filed for cancellation of those sale deeds.
No.
It's barred by limitation. That's what the court said.
Yes, they did not seek for cancellation of the sale deeds, my lord. So this honorable court held that such suits are barred by limitation. Now, please see, my lord, para 24. I'll just read. As stated above, the appellant plaintiffs have averred in the plaint that the cause of action has arisen on 18/12/2021. Para 24, my lord.
I've seen that.
Yes, please. So the suit is within limitation. However, from the documents annexed with the plaint, more specifically schedule E to the release date, it can be seen that there is a sale deed executed and registered in the year 1994 by the predecessor in interest in title of the plaintiffs. And thereafter, several sale deeds have been executed. Thus, the title of the suit schedule property stood transferred in 1944 itself by the predecessor. Given the foregoing admitted facts and the fact that there was no challenge to these deeds executed from 1944 to 1980, it can be said that the suit has been filed within time. The contention of the plaintiff that they were not aware of the sale deeds also cannot be believed. The plaint that has been filed for cancellation of 3 sale deeds and the release date, and these release deeds and sale deeds refer to several registered documents onwards. In any event, since the grandfather has executed the registered instrument not in 1944, the challenge by the appellant's plaintiff in the present suit to the subsequent sale deeds cannot be maintained unless all other sale deeds are also challenged as well. So in my case, my lord, there is no challenge to any of the sale deeds, though there is a mention of the sale deeds in the plaint
Come to
averments.
paragraph number 18.
In fact, my lord,
Come to paragraph number 18 of the impugned order.
para 18, my lord, please. Since these release deeds form part of the documents annexed to
18
the
of the impugned order.
impugned order, I'm sorry. Please, so from the averments of the plaint, it is clear that the plaintiff is claiming her share from the self-acquired property of her father. According to the plaintiff, after the death of plaintiff's father, khata has been transferred in the name of the mother of the plaintiff. But after the death of the mother of the plaintiff, the defendant sold portion of suit schedule properties in favor of defendant number 10. Therefore, it is clear that the plaintiff is claiming her share under Section 8 of the Hindu Succession Act, but not under Section 6 of the Hindu Succession Act. Hence, the proviso under Section 6 of Hindu Succession Act is not applicable to the case on hand. As such, the suit cannot be rejected on this ground. My lord, please see, my lord, my application is under Order 7 Rule 11 A and D. My lord, I am stating that there is no cause of action for filing this suit. And my lord, that the suit is hopelessly barred by law of limitation. Since, my lord, the plaintiff has not sought relief of cancellation of the sale deeds that are mentioned in the plaint.
The petitioner is agreed with the order. Asked by the court in I number 9, filed under Order 7 Rule 11 A, B, and D of CPC, whereby the petitioner has sought for rejection of the claim on the ground that it is barred by limitation and it does not disclose the cause of action. In consequence, the petitioner submits that. You are the purchaser.
I am one of the purchaser of the property.
The purchaser of the property. Petitioner defendant is a purchaser of the property. The having stated about the sale that has taken place, which year?
2002, my lord.
A sale deed that has been executed in the year 2002 without seeking cancellation of the said sale deed. The present suit is filed. The suit is filed. It is submitted that without seeking the cancellation of the said sale deeds, the present suit is not maintainable. It has relied on a division bench judgment of this court in RFA number 862 of 2023, dated 22nd April 2026, arising between Sri Narasimha Murthy and others versus Sri Mallesh and others. Considering the same, there shall be stay of all further proceedings. The petition is permitted to take out hand summons. The council appearing for the trial court and shall file a memo to that effect by 6th of July. If the memo is not filed, stations, the interim order granted shall stand vacated. If the memo is filed, is the matter on seven. Yes,
Case number 58.
My lord, may I request for stay of further proceedings? My lord?
yes.
Noblest.
58.
Petitioner has challenged the order passed by the Honorable Civil Court. Page number 16, my lords.
Page number?
Page number 16, order passed by the Honorable City Civil Court. On the application filed by the petitioner, who is the defendant number 1 in the suit, my lords. Under order
Yes.
7 Rule 11A and D, my lords. Not the facts of the case, my lord. The relationship
Where is
between
the
the
IA? Where is-
petitioner and respondent.
Where is the IA?
Please, my lord. IA may kindly be perused at page number 37. my lords. IA for rejection of the plaintiff. Suit for partition filed by the respondent number 1 and 2, who are the sisters of the petitioner and other respondents.
Yes, come to the impugned order.
Please come to page number 16. my lords. May narrate facts or
No, I've seen your affidavit, I understood.
please. My lord, the observations of the Honorable
Mm.
Trial Court, my lord, page number 25, my lord, ink page 25. My lords, please, para 15 may kindly be put.
Please read.
Last paragraph. In the instant case, admittedly, the alleged registered partition, deed of partition is said to have been taken place in the year 2003 by virtue of Hindu Succession Act, Karnataka Amendment Act 1990. If a partition was effected between members of the family during subsistence of the Karnataka Amendment Act, such partition deed does not bind the interest of the daughters, as they have already acquired the status of the co-parcelers. Under these circumstances, it cannot be said that there is no cause of action by virtue of the principles laid down under Vinita Sharma case. My lord, in this regard, my humble submission, my lords, please. The provisions of section 6A, my lord, may I read the provisions of section 6A of the amended provisions of 2005 of in the section. My lord, after 6A, B, C, a specific reference is made, provided that it commences from the word provided that.
6.
After 6A, B, C,
Mm.
my lords, provided that nothing contained in this subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of property which had taken place before 20th day of December 2004. But in this case, my lords, please, the partition was affected by the propositor Nanjundaya during his lifetime itself, my lords, please, in presence of a registered partition deed dated 10/1/2003, my lords. 10/1/2003 itself. My lord, furthermore, in this matter, my lords, please, after effecting of this partition by Nanjundaya, he passed away subsequent to that. Then, in fact, my lord, the plaintiffs, respondent number 1 and 2, are having knowledge of this partition also, my lord. And a portion of the property by one of our brother, that is Shashi Bhushan, who is the husband of the defendant number 10, my lords, please, who is our brother of the petitioner. He has executed a registered gift deed in favor of both the respondent number 1 and 2, my lords, please, which was,
That registered partition is given effect to.
it was prior to 20th December 2004. That is as per the provisions of the act. Then, my lord, they have questioned the validity of this. Then another question also, my lords, please. Delay, my lords, please. In 2014, they get the property by way of gift deed from my brother, my lord, a portion of the property. In 2014, they filed this suit.
Agreed with the orders passed in I number 1. Invoice number 5682, I number 1, invoice number 5682 2022 dated 31st July 2025, whereby the application filed with the petitioner defendant under order 7 to 11 is dismissed by the, is rejected by the court. Then counsel for the petitioner's officer, a registered partition deed is executed in the year 2003, and the court refers to the amendment to section 6A of the act. It is submitted that it has no application to the prior transaction that had taken place. Further, it is submitted that the said registered partition deed is acted upon and certain documents were executed pursuant thereto, and all these aspects are not considered by the court. Considering the submission, there should be stay of all further proceedings in OS number 7. In this also, like in the other case, and summons, and what is the date given in the earlier case? 7. Let it be by 13th and 14 should be the date. Yes, next.
59, Karthik Surya Prakash.
Lords, the petitioner is the first defendant before the trial court who's filed the order 7 rule 11D application, which has been rejected, and challenging the same, the petitioner is before this honorable court. But the impugned order may be found at page 39, my lords. The chief ground is on limitation, my lords. Page 39, the reasoning of the court starts at page 44, my lords. And the finding of the court as to limitation is at page 47. The plaintiff has challenged the compromise decree between the first and second defendants, which was executed, which was on 25/1/2014, my lords. 25/1/2014, and the present suit has been filed on 5th January 2023.
5th January
2023, my lords.
Filed by whom?
Filed by the other sisters, my lord.
No.
Filed by the
earlier suit, that is 25/1/2014.
Was filed by the first defendant against the second defendant, and it was settled by way of compromise.
And what is the relationship between the plaintiff?
Mother and my lords.
What is the relationship between the plaintiff and this suit?
The plaintiffs are sisters who were married long before and who were not residing in the said property. There was a dispute between the mother and the daughter over.
Come to the plaintiff.
Lord, the plaint may be found at page 22, my lords. Page 25 is the averment as to the knowledge. Para 7, my lords.
Now, please come to your IA. Where is that affidavit?
Page 28, my lords. The affidavit is at page 29.
You are the sister.
Indeed, my lords. Para 5, my lords. The ought to have filed a suit for declaration declaring the decree passed in OS 2 of 2014 to be set aside within 3 years from the date of judgment and decree. Plaintiff is having due knowledge of judgment and decree as on 28/10/2017, and hence the date of knowledge of decree is in the year 2017 itself, which is the date of application filed under Order 1, Rule 10 CPC.
Now, please come to the order.
My lords?
Come to the order.
Indeed, my lord. Page 47 is the page 47 para 12. The trial court notes that admittedly no suit was filed within 3 years, but subsequently at para 13, the trial court goes on to invoke section 14 of the Limitation Act and goes on to say that section 14 of the Limitation Act saves the limitation in the present case. Without there being any averment as to due diligence or good faith, or whether an impediment application can be considered the same as a suit for cancellation of a decree. Without any of these considerations, the trial court goes on to hold that section 14 would be extended in toto. Para 51 is the page 51 is the conclusion, my lords.
Court was right. Read paragraph number 15.
It is also worth to note that this court has already framed the issue regarding limitation, and if it is found during the trial of the suit that the plaintiffs were well aware of the consent decree in OS 2 of 2014, which prior to 2017, that the said fact would certainly help the defendant number 1 to prove the said issue. But at this stage, the said fact cannot be ascertained without full-fledged trial. Since it appears the limitation of 3 years is available to the plaintiff was saved by the provision of section 14, it cannot be held that this at this stage the suit was barred by limitation. However, my lord, section 14, the requirement is not that any proceeding.
Forget about section 14. Now that issue is left open, whether the suit is barred by limitation or not. A question of fact and law will be decided by the court, not at this stage.
The only consideration is, my lord, even the attractability of section 14.
No, that
may
is
not be
court has not, though a discussion was made, no finding is given on that. Court said it cannot be decided at this stage. And an issue is already framed with regard to this. That will be decided by the court.
The only concern is the requirements of section 14. It may not be considered as res judicata because
it will be decided by the court. That issue. That is why I asked you to read paragraph number 15. Paragraph number 15. What did the court say? It is also worth to note that this court has already framed the issues regarding the limitation. And if it is found during the trial of the suit that the plaintiffs were well aware about the consent decree on so and so, much prior to 2017, then the said fact would certainly help the defendant number 1 to prove the said issue. So court has not expressed any on the merits of the matter whether section 14 will apply, it will lend you to their benefit or not. Please come. The
para 14. Therefore, the time spent by the plaintiffs.
Discussion is made, but none
Only,
of these
our only concern, limited concern, is even that subsequent to 2017, the section 14 findings as to due diligence and good faith, there was no warrant for any consideration for any such categorical statements to be
Then you take out notice. I'll after. Then if that has to be.
That is the only limited.
Yes, the petition is permitted to take out hand summons on the respondents and file a memo to that effect. When can you file?
My lord, it's in Shimoga. It will not in Bangalore. Shimoga. It will 2 weeks, my lord.
This matter. A memo shall be filed by 30th of June. If the memo is filed, list the matter on 1st.
Obliged.
Yes.
Number 60. The 7 Rule 11 rejected by the trial court, which has been challenged here, my lords. The defendant number 12 is the purchaser of the property. Plaintiff and
defendant 1 to 20 are all family members, my lords.
Suit for partition.
Suit for partition and declaration that the sale deed in the year 2000 is null and void, my lords. My primary ground under Order 7, Rule 11, it is barred by limitation, and second one being that there is no cause of action displayed in the plaint, my lords.
Come to your IA affidavit.
IA is at page number 74, my lords. It's a slightly badly drafted application, but the substance is there, my lords.
You're the family member?
No,
Or you're a purchaser?
I'm the purchaser.
You purchased in which year?
2000, my lords. 2000.
From whom?
From the plaintiff's step uncle.
That is defendant number?
Defendant number 19, and the other one is deceased, so no more.
And no plaintiff, sir?
Plaintiff is,
What is their age?
he is 26 years of old. He was 6 years when the sale was made. He turned 18 in the year 2013, my lords. By my primary argument, my lords,
Suit is filed in 2022.
2021. It's filed after 21 years of the sale having been registered, my lords. The fact of registration is mentioned in the plaint. The plaint does not disclose when his father died or when his grandfather died, my lords. And he says that the sale was made when his grandfather and his father were both alive. The primary ground being, my lords, say the registered document functions as constructive notice to all the family members. Irrespective, if one were to take the argument that he was a minor, my lords, 2013 is when he attained majority, my lords. May I just pass across one judgment? The trial court, I'll just point to the impugned judgment, my lords. It's at page 30. The operative portion, my lords, is in page 9. Page 42, para 9. The trial court says it's a mixed question of fact and law, and hence I cannot answer it at this juncture.
Please come. Then counsel for the petitioner submits that. The suit is filed in the year 2021, seeking partition and cancellation of a sale deed which is executed in the year 2000. It is submitted that the petitioner has attained majority in the year 2013, and the suit is filed in the year 2021. When these facts, on the face of it, when it makes clear that the suit is filed nearly after 8 years after attaining the majority, and on the face of it, the suit is barred by limitation. The trial court had dismissed the IA, saying that it's a question of fact and law. Fact and law. Next para, considering the submission of the learned counsel to the petitioner, there shall be stay of all further proceedings pursuant to the order dated so and so. This matter is a hand summons. Notice, in addition, hand summons. Memo shall be filed by 20th, not 20th. Memo shall be filed by 31st of July. If it is, list this matter on 1st.
My lords may consider staying the further proceedings of the case, my lords.
61. Timappa.
No representation for dismissal. Yes. Dismissal tomorrow.
Then
Yes.
number 62. Anupama Bodoli.
The alienation, my lord, as evidenced by documents, my lord, 1979. The suit is filed, my lord, after 40 years.
What is the suit for?
The suit for partition. And Lord, we filed a 711, my lord, on these two grounds. It's outside partition, there is lack of cause of action. The learned judge would say, would accept all our contentions, but my lord, the learned judge would say, there's one of the items in the suit property is not at partition and not even alienated. Therefore, a partial rejection of plaint cannot be done. My lord, this is the view taken. My lord, I am afraid. I understand, my lord, suit cannot be dismissed, my lord, in parts, but My lord, this is total ignorance to my lord 7 rule 13. My lord, the right course should have been, if someone mixes, my lord, an infested cause of action with, my lord, a clear cause of action, suit has to go. Under 713, my lord, they can come back to the court. Your lordships may kindly see, my lord, 7 rule 13, where
Let's-
rejection of plaintiff.
Before that, let us just see what did they say from the order.
Your lordships could kindly have, my lord, the order impugned at page number 35. The relevant portion is, my lord, on page number, my lord, 42, paragraph 11. On going through the contention of the defendant number 30, that the present application is not forthcoming, that the entire affidavit accompanying the application show that the defendant number 30 has claimed that there are various sale deeds in respect of suit item number 1 property in the year
There is a
19.
discussion in which para?
This is at page number 11, my lord, paragraph number 11, page number 42.
Yes.
On going through the contention of the defendant number 30 in the present application is forthcoming, it is forthcoming that the entire affidavit accompanying the application show that the defendant number 30 has claimed that there are various sale deeds in respect of the suit item number 1 property from the year 79 to 2018. It is further contended that Nanjappa has already sold the item number 1 property in favor of different persons as the item, so as suit item number 1 property is granted property in favor of Nanjappa. He was eligible to sell the same. However, there is not even a single word regarding suit item number 2 property in the affidavit. It is well settled principle of law that the plaint cannot be rejected in part. We are not on that. It is agreed. There is no quarrel on this principle. That a plaint cannot be rejected, my lord, in halves or in parts. But when somebody files, my lord, a suit by, my lord, composing a property which could fall outside the suit, but by mixing it, then, my lord, the entire plaint has to be.
No, the court, he refers to two properties.
Yes, my lord, two properties.
What is item number 1 property?
Item number 1 property, my lord, appears to be a granted property, on which, my lord, the court says he had right, he would do that. But item number 2 property, my lord, is my property, where, my lord, I am the self-acquired property.
No, item number 1 property, in respect of that, there is no alienation.
There is no allegation. There is no allegation. What the learned judge would say is that since I have not stated anything about item number 2 property.
You purchase the property.
Yes, which could be partitioned. Therefore, I can't reject the plaint. Then.
No, you are concerned with only item number 2 of
item number, my property, my lord, of which I am the present. Item number 1 property, of which, my lord, I am the present owner. Now, what the learned judge would say is the item number 2 property, there is no claim. My lord, I have not leveled any claims against, my lord, item number 2 property. Therefore, I can't reject the plaint because it could be partitionable. Now, that is not possible. There is no quarrel about the position of law that, my lord, plaint cannot be rejected, my lord, in parts. But if somebody, my lord, composes, my lord, a suit in such a way that there is a particular property which would hit, my lord, a bar, and a particular property which would not hit a bar, my lord, they have to file, my lord, the suit in such a way, my lord, by keeping the suit clean. My lord, if such a mixture is done, a hybrid plaint is presented, then the plaint has to be rejected, and, my lord, because Article 7 Rule 13 provides for coming back. Article 7 Rule 13, your lordships may kindly see, my lord.
Yes.
The rejection of plaint on any of the grounds herein above mentioned shall not of its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action. So if this plaint was, my lord, rejected, the plaintiff could still go back. At the same time, my lord, this very plaint, my lord, cannot be held against me, my lord. I'll have to face, my lord, a trial for no good reasons. This portion of, my lord, Article 7, my lord, is rarely seen, because everyone stops at 7 Rule 11, my lord. It's quite, my lord, largely and, my lord, vividly used provision. 7 Rule 13, my lord, we generally don't look at it. My lord, 7 Rule 13 clearly provides if a plaint is rejected, we can go back, but by deducting those areas, my lord, which was found to be, my lord, defective. are barred by law.
No, with regard to partial rejection of the plaint, he has relied on all these.
Yes, my lord, that position of law is well settled. My lord, now I'll put it this way, my lord. If a partial rejection of plaint is not possible, and my claim is such, my lord, I should not, my lord, be put to the ordeal of facing a trial, then what is the remedy for me? That is the reason, my lord, that 7 Rule 13
Order
is called
passed.
out and kept.
When is this order passed?
This order, my lord, is passed.
On 4th August.
Yes.
In civil issue notice.
Yes.
Notice to the respondents.
My lord, your lordships may allow me, my lord, serve them by hand, my lord. Other defendants,
hand
respondents
summons.
may kindly be dispensed.
Whom to be dispensed with?
Defendants, my lord.
Number. They are read as respondents.
Respondent number 3 to 31.
Memo is filed seeking dispensation of notice to respondents 3 to
31.
3 to 31. Memo is taken on record and dispensed with at the risk of appellant, the petitioner. The petitions of the hand summons on respondents 1 and 2 who are defendant number 1 and 2 before the trial on the counsel appearing before the trial court.
Plaintiff 1 and 2. Respondent number 1 to
plaintiff from 1 and 2 and shall file a memo to that effect by when do you want?
any shortest date, my lordships, next week, sometimes we'll take hand summons, my lord.
Next week, I think you may not be able to. 18th, if the memo is filed on 17th, list the matter on 18th.
Your lordships may kindly allow, my lord, hand summons. Dasti.
Hand summons.
Greatly obliged.
Number 63, Naveen GS.
That we be permitted to serve upon the council, my lord, who is greatly obliged.
It's a petition against the dismissal of application under Order 7, Rule 11, A and D. The suit is one for specific performance, my lords. I am the purchaser from defendant number 1. Lords, the plaintiff and the defendant number 1 enter into an unregistered sale agreement on 17/12/2015, and the time is fixed as 3 months for the execution of sale deed. The plaintiff herein files the present suit on 15/6/2019. That is after lapse of 3 years, my lords. I filed an application seeking rejection of plaint based on there is no cause of action, and the suit is barred by limitation since 3 years has elapsed from the date on which the sale agreement was entered and the 3 months time that was fixed for execution of the sale deed. My lords, the operative portion of order is at page number 38, my lords. Page 38, last line, my lords. On perusal of the case record, the suit filed for specific performance of contract.
Where do you get that?
My lords.
Page number?
Page number 38, my lords.
38. You're reading the reasoning part.
Yes, my lords, the reasoning part.
The defendant number 2 has filed I number 10.
Yes,
That's
my
how
lords,
it
the
starts.
last line, my lords. That is on perusal of the case record, the suit filed for specific performance of contract based on an agreement of sale dated 17/12/2015. It has contended in the plaint that the defendant number 1 executed unregistered sale agreement on 17/12/2015 by receiving advance sale consideration of amount 10 lakh out of the total consideration amount. The defendant number 1 agreed to execute regular sale deed after conducting survey, POD and collecting necessary documents. The trial court has missed the part, my lords, the fixation of time limit, 3 months. Finally, the defendant has not fulfilled the said terms and the condition, and the plaintiff got issued legal notice on 15/4/2019 and calling upon the defendant for executing regular sale deed. But the defendant number 1 failed to do so. Hence, the plaintiff has filed the suit against defendant number 1 on date 12/6/2019. Subsequently, defendant number 2 impleaded himself as per the order made by Honorable High Court in WP number so and so. It has specifically contended by the defendant number 2 that the suit of the plaintiff barred under law of limitation not properly valid and not disclosed any cause of action. But on the perusal of case record, the leased agreement dated 17/12/2015 held between plaintiff and defendant number 1. The defendant number 2 is not at all party to the said contract. The suit filed within limitation. The cause of action shown with
Come to the plaint.
plaint, my lords, kindly, my lords, at page number 20, my lords. para 2, my lords, which says about the title of the defendant number 1, the seller. May I read, my lords?
When did you purchase the property?
My lords,
When did you purchase the property?
my lords, I purchased on 28/2/2019 by way of a registered sale deed. Before that, I had an unregistered sale agreement on 5/5/2015 and a registered sale agreement on 7/9/2018.
And this agreement is also the same year, I think.
My lords,
It is on 17/2/2005.
17/12/2015, my lords. Mine was earlier to them, 5/5/2015, my lords.
Yes, notice to the respondent.
Lords, I may be permitted to serve
And summons
the council on
for the respondents before the trial court. If the memo is filed on 14th of July, list on 15th.
grateful, my lords.
Yes.
Case number 64. Krishnamurthy KR.
Lord, an application filed under Art 7 Rule 11D has been rejected by the trial court, against which
What is the
challenge
suit
is
for?
said order before this.
What is the suit for?
The suit for declaration and injunction. Multiple prayers are made. The suit is principally filed against the cooperative society registered under the Cooperative Societies Act. The suit is filed by the members of the society, stating that the society is not managed legally against the society itself. Such a suit is not maintainable because there is an alternative forum created under the statute itself. There is a bar under section 118 of Cooperative Societies Act, where a dispute which can be adjudicated between the members and the society under section 70, no civil court can entertain the suit. That is the first ground.
How it was dealt with the court?
That is now the court has misread the facts and said that the plaintiff are not the members of the society, which is factually incorrect. Your Lordship may kindly see the
What is
order.
their case in the plaint?
Their case is also their members.
Let's see the plaint.
Yes. Plaint is at 38, page 38. Starts from 36 and 38. Kindly come to para. Para 2 of the plaint.
Plaintiff herein or the life
Or
members
submit
of
the plaintiffs herein are the life members of the defendant number 1 society, bank offices, so and so.
And come to this observation.
Now in the order, my lord. Para 14, my lord. After relying upon the judgment of this court, where the judgment is rendered between in a case wherein a suit is between a non-member and the society, that judgment is relied on, and then.
And where are the contentions that are urged saying that they are not the members?
No, there is no such contention. On the other hand, the plaint governments.
But how come the court has come to this conclusion?
In para 14, Lordship, the said judgment is very much applicable to the case on hand on the reason that the dispute in the present suit is not between the members of the society, and the present dispute involved the present suit does not come within.
Section 17, Cooperative Societies Act.
Yes. Section 70.
You have the book?
In the order also it is called out at
Where
page 26. Page 26. Ink page 26. Notwithstanding anything contained in any law for the time being in force, if any dispute touching the constitution, management, or business of a cooperative society arises among members, past members, and persons claiming through members and past members and deceased members, or between the member, past member, or a person claiming through a member, past member or deceased member and the society, its committee, or any officer, agent, employee of the society.
On all this, the suit is not maintainable.
Now, and suit 118, your lordship may kindly see in the under the act, my lord. Section 118 of Cooperative Societies Act. Okay. I may pass. I will read and pass it on.
Yes.
Bar of jurisdiction of courts, save as provided in this act, no civil, labor, or revenue court or industrial tribunal shall have any jurisdiction in respect of the registration of a cooperative society. 1. B. Removal of a member. C. D. Any matter concerning the any surcharge application required under section 69 or any dispute required under section 70 to be referred to the registrar, or the recovery of monies under section 100. May I pass on?
Please come.
118C.
Please come. The petitioner is agreed with the rejection of the IA that is filed seeking rejection of the plaint on the ground that the suit is not maintainable in view of section 7, in the light of section 118 of the Cooperative Societies Act, which bars the jurisdiction of the court in matters pertaining to section 70 of the Act, which has to be referred to the registrar. It is submitted that the court has rejected the IA on the ground that the dispute is not between the members and the society, and the present dispute involved in the suit do not come within the ambit of section 72 of the Act, and will not come under the Act. It is submitted by the Land Council that in fact, the dispute falls very much within the ambit of section 70, and a suit is not maintainable, and this aspect was not considered by the court. Considering the same, they shall be considering this an express submission of the Land Council for the petitioner. They shall be stay of all further proceeding pursuant to the order dated 17 September 2025 in IA number 6 and 7. In OS number 3608 of 2022 on the file of so and so till the next date of hearing. See, the petition is permitted to take handsome.
2 to 6 may be dispensed with it. My
MO is filed seeking dispensation of notice to 2 to 6. Dispense with at the risk of appellant. Notice to respondent 1.
2 to 6. Respondent number 2.
No.
Only one.
Notice to respondent. In addition, petition is permitted to take out handsome and file a memo to that effect by 3rd of August. If it is filed, this is the matter on 4th. Yes, next.
Number 65. Murali Babu.
It for the petitioners.
Yes.
Respected by the rejection of 7th rule and application by the trial court. Nanjundappa plaintiffs have filed a suit for partition. Nanjundappa was the owner of suit scheduled properties. He sold the property in favor of the petitioner's mother on 18/6/1967. That sale deed I produced at Annexure A, page number 16.
Please come to your IA.
IA at Annexure F 48, page number 48. The cause of action, lack of package of cause of action, and also on the ground that suit is barred by law. Last week at the plaint, in the plaint, para number 7, cause of action para. Nowhere in the plaint.
Let's come to the order.
The plaint.
Order.
Let order blood para number 14.
Page number.
Page number blood the at 65. It is well settled principle of law that question of limitation is mixed question of law. That fact whether suit is barred by limitation or not considered only after trial. With regard to cause of action, plaintiff in the plaint as clearly pleaded about the cause of action in the plaint. This is not the wrong observation but made by the trial court. You last make at plaint at page number 32. Nowhere in the plaint pleaded the cause of action. Para number 6, 7, my lord, lordship kindly see cause of action para of the plaint. Plaintiff have not pleaded.
Come to paragraph number 13 and read.
13, in this case, plaint applicant, plaint defendant 1, 6 and 7 filed application to reject the plaint stating that there is no cause of action. Suit is barred by limitation. Bad for non-joinder of parties. Plaintiff has suppressed the two facts with the intention to get favorable orders as filed the suit. His father has filed suit for declaration. Now this is with respect to earlier the Veere Gowda in the year 1992. He made some disturbances with the possession of the petitioner's possession over the suicidal property. At that time, father of the petitioners here in Malad had filed suit for declaration and permanent injunction. Up to the trial of the initially suit Malad was dismissed. In Arya Malad,
What about all that litigation? Now in this suit, there is a cause of action as stated. According to you, there are certain suppression and misrepresentation of facts that cannot be decided in an application under Order 7, Rule 11. And remaining other issues also, as looking at the plaint, all these issues cannot be decided. Even the document that was filed along with it.
Entire plaint, Lordship mechanism that sale did not question. Lordship mechanism plaint.
They have not even stated.
Not stated. Suppressed.
No, that's why you filed your written statement now.
One more thing important, as on the date of the sale of the suicidal properties, the plaintiffs were not barred.
And when the court is deciding an application under Order 7, Rule 11, it will look at the plaint and the document that was filed along with the plaint. Now, for appreciating all these, court has to look at the written statement and the documents you have filed. Such exercise is not permissible under Order 7, Rule 11. The court was right.
Not the plaintiffs have no locus standi, not the file the suit
That
for
will be
partition.
decided not under Order 7, Rule 11.
Not the Lordship cast title, plaint. Not the plaintiffs are residing at not Tumkur. They are not residing at in the village, where in the Kolar district. Not the age of the plaintiff number 1 pleaded 48 years. Not say sale was took place as as per his age stated.
Before making that submission, whether the sale deed, execution of the sale deed was mentioned in the plaint, it is not mentioned. By way of a written statement, you have stated so. How the court will consider that aspect for rejecting the plaint? He has dismissed. I'll discredit the order.
The age of the as
all
on
that issues cannot be decided.
the age of the plaintiff number 1 stated 48 years as on in the year 2022. The 67 was sale.
Sale deed is not part of any of the averments of the plaint.
Correct. Sale deed was not part of the.
Then why should we consider that? I've seen it. At the dismissed order will follow.
Lordship may direct the trial court in the speedy disposal, madam, because.
Where is the suit?
Right?
Which year is the suit?
22.
Why? What speedy disposal for a 22 suit? Yes, next.
I am the owner of the property. Unnecessarily, they are making disturbances of my possession. They have no right at all. Locus standi. 1967,
yes.
the sale.
Reasons to follow dismissed. Yes.
At least not the disposal direction. Lot.
Because you have come to the
Because-
High Court, we can't give some order or the other. 22 suit, how can there be an expeditious disposal?
Speedy.
What will happen to the others?
Speedy disposal. At
I
least.
can't. Yes, next.
The plaintiff Lords is at page number 31. The plaintiff says they are the members of the cooperative society. Lords, may kindly take page number 31 is the plaint. And page 34, paragraph number 3 is where they say that they are the members of Guru Krupa Housing Cooperative Society Limited. Lordship gets it. The next page, paragraph number 7. The president of the society, in order to grab the property, has sold the property in favor of 12 members as per the sale deed dated 4th May 2007. Now, saying that this is a transaction which was not on the basis of seniority or otherwise, page 39 is the prayer. The suit is filed on 26/9/2023, challenging the sale deed dated 4/5/2007 by the member of the cooperative societies, challenging a sale deed executed by the society in favor of its members. Now, the application was filed raising 3 contentions. Number 1, the members will have to agitate their grievances under section 70 of the Cooperative Societies Act. Now, to address this, what the trial court says is that since the society is now under liquidation, so therefore question of initiation of proceedings does not arise. That is not correct. Liquidator steps into the shoes of the board. All proceedings will have to continue under section 70, number 1. Section 118 was referred to, where it says
It's only like it accepts that under 118 there is bar. But
the
as it is
118
under
there is a
liquidation-
bar, section 70 there is a bar, and this is a suit filed in the year 2023 challenging a sale deed of the year 2007, when under the section 70 capital A of the Karnataka Cooperative Societies Act, limitation is 6 years because it's a special right. Now this is filed as a civil suit, then 3 years under Article 58 will apply. Lord's judgment was read to your lordships, not the division bench judgment. I'll not trouble your lordships. I saw that that judgment was read to your lordships. They have referred to the sale deed of 2007. No facts are stated as to why or in what circumstances they held themselves back to file the suit after a lapse of 16-17 years.
No, that apart. What about how did the court decide about
Plus the court,
bar
this
of
is
bar of
page,
jurisdiction?
if your lordships may kindly take the order at paragraph number 15, 1-5, which is at page 27. 15 and 16 is how they deal with the bar, which is absolutely absurd, Minots. No rights in a cooperative society gets a right until and unless he becomes a member of the society. All his disputes are required to be raised before the register under section 70 of the Act. 15 and 16, Minots, is where the court deals with why the suit is not barred. But can I just pursue it? There is one issue which came up before the Supreme Court. A constitutional bench of the Supreme Court dealt with this issue. Can I just pursue it, your lordships? May kindly have a look at this judgment. What is the consequence of constitution and registration of a cooperative society qua the member? Paragraph number 11. Lords, an amendment was made permitting amalgamation of the societies which came to be challenged by the individual members. Then referring to an earlier constitution bench of Damayanti Narang, paragraph number 11, Milords. It's a very interesting judgment.
Yes.
The next submission of the Learned Council was that section 13(8), 9, 10 did not make any express provision for issue of notice to members of the concerned cooperative societies and were therefore violative of principles of natural justice. He argued that in the absence of provisions of the rules of natural justice may be read into the provisions and the notice to the members of the affected societies was imperative. Otherwise, he argued the members of one society could be formed against their will and without being heard to associate themselves with the members of another society. We have no hesitation in rejecting this submission also. Once a person becomes a member of a cooperative society, he loses his individuality qua the society and he has no independent rights except those given to him by the statute and bylaws. So if the statute and bylaws is not referred to in what manner he is seeking to raise these contentions, he will not.
No, this registered sale is executed long back.
2007.
Now under section 70, what the registrar can do?
Lord, registrar can set aside the sale deeds. It is a plenary jurisdiction under section 70. Lord, section 70, any dispute between the members Intersect between the members and cooperative societies, every dispute is amenable only under section 70. Now, let us assume a circumstance that
After these many years. After
Lords,
these
now that's the reason why I said, Lords, within 6 years the dispute could have been raised. Now a remedy which is already lapsed under the Karnataka Cooperative Societies Act, under which the rights arise, cannot be reinstated saying that this is a civil right under section 9 of the Code of Civil Procedure. This is purely a right arising under the Cooperative Societies Act between the members.
The senior counsel, appearing for the petitioner, defendant submits that the report is filed by a member of a cooperative society and sought a relief for cancellation of the sale deeds that are executed in favor of other members of the society. It is submitted that this dispute squarely falls under section 70 of the Cooperative Societies Act and under section 118 of the Karnataka Cooperative Societies Act. There is a bar of the civil court jurisdiction. It is submitted that this aspect was not considered by the court. Further, it is submitted that the sale deeds were executed in the year 2007 and a suit is filed in the year 2023. When it is submitted that even under the Societies Act, Cooperative Societies Act.
Please, Karnataka Cooperative Societies Act 1959.
Within 6 years, they have to seek for, within 6 years.
Within 6 years, they will have to seek for any remedy before the registrar.
It has to be within 6 years. And even when, and as such, they approach the civil court and the civil court has no jurisdiction. Next para considering the submission of the learned senior counsel. There shall be stay of all further proceedings in OS now, pursuant to the order passed in IA number 2 in OS number 6270 of 2023, dated 18th August 2025. What about notice to the respondents?
It's, respondents are all the plaintiffs.
The hand summons on the petition is permitted to take out hand summons on the counsel appearing for the respondent to the trial court and shall file a memo to that effect shall file a memo to that effect by 20th of July. The memo is filed as the matter on 21st. The memo is not filed, the stay granted shall stand vacated. Yes.
67.
Same matter, Lords.
Same.
Exactly the same matter. Please. Great.
Yes. Next.
Cell number 68. Jayaraju.
For
Jayaraj
the
DS.
petitioner, a suit for partition and separate possession. This is a subsequent suit seeking for the same and similar relief by the plaintiffs and as against the defendant. Prior to this subject suit, there was a suit in the year 2004 instituted by the
The present suit.
present suit is also for the partition and separate possession. Earlier suit was also partition and separate possession.
Between the same party.
Between the same parties.
Hmm.
Therefore, this application was filed to reject the plaint. The Honorable Trial Court does not
Check the plane on the ground.
plus the application is rejected on the sole ground that one of the scheduled property is not mentioned.
You have sought for rejection on the ground of
Cause of action and barred by the law of limitation as well. Plus the earlier suit, the very averments in the plaint itself by the plaintiff, they say that one of the suit scheduled property was not mentioned inadvertently.
That's why to say, when you're saying that in the earlier suit, they have said so.
Yes.
That is stated in the present plaint.
That's correct. Kindly see para 7 of the plaint. Your Lordships will get the plaint.
So before that, we'll see what did the court say.
Please, Your Lordships may kindly see the reasoning of the impugned order, page 35.
In view of the law laid down in the aforesaid decision, I have carefully gone through the plaint averment. No doubt the plaintiff has pleaded the cause of action for the suit.
Para
Therefore,
7.
the question of relinquishment as
Correct.
contended by the defendant number 1 will be dealt at the later stage of the suit. It's your case that he has relinquished his rights.
Correct. The relinquishment by way of a partition which affected in the year 2003. So nevertheless, my lords, the daughter.
That
Kindly see para 7 of the plaint. Page number 43.
Yes.
It is pertinent here to state that in the said suit, OS number 156 of 2004, filed by the plaintiffs before the civil judge, Junior Division Dodbalapur, only 4 items of the properties were included in the schedule for partition. The lands in survey number 72 measuring 7 guntas, survey number 74 measuring 1 acre, survey number 2.1 acre, all situated at Kulvanelli village, Madure Hobli, Dodbalapura, and survey number 312 of 1 measuring 29.5 Gunta, situated at Esargata village, Esargata Hobli, Bangalore North Taluk, but the item number 5 property in the registered partition deed dated 21/7/2003 fallen to the share of the first defendant. The lands in survey number 3 measuring 20 guntas and survey number 4 measuring 1.19 acres, situated in Dasampura village, Esargata Hobli, Bangalore North Taluk, was left out by oversight and inadvertence in that suit. Para 8. Though the plaintiffs brought to the notice of the council in 156/2004 that the item number 5 of the properties was left out, the council had stated that the property is situated in Bangalore. As such, the Dodbalapura court has no jurisdiction to adjudicate the suit relating to the property situated in Bangalore, and a separate suit has to be filed. Nonetheless, in the previous suit, the item number 4 is also Esargata. The present suit, your lordships may kindly see the present subject suit schedule property. That is also in Esargata.
No, they are referring to a Bangalore property.
Correct. Bangalore North Taluk.
That is already part of the part of the earlier.
Yes. Partition took place on 21st July 2000.
But they are not accepting that.
No,
In
they
the
say
plain-
they have accepted it. They have relinquished
In the
it.
plain, they say that particular property
Correct.
is not included.
It's
And
not
when they've
included.
asked the advocate said that is situated in
Correct.
Bangalore, the
Correct.
separate suit has to be filed.
Correct.
Now, it is your case that in the earlier suit that is included.
That is not included. The subject suit schedule property, by oversight or by mistake,
What is their case?
that is what their case is. But there is a bar, even as per order 2, rule 2. Secondly, of course, Manoj, section 6 of the Hindu Succession Act provides a coparcenary right even for a female by birth. Nevertheless, there is a proviso to order section to section 6. Your lordships may kindly see the proviso to section 6 of Hindu Succession Act.
Just now I read it.
Please. Provided that nothing contained in this subsection shall affect or invalidate any dispossession or alienation, including any partition or testamentary disposition of property which had taken place before 20th December 2004. Nonetheless, by partition effected on 21st July 2003, they leave out this property. They accept the partition. They relinquish the subject scheduled property. Thereafter, lapse of 12 years, in the year 2012, they initiate a separate suit taking such a contention.
What the court said. You are
That
speaking
is wrong.
about a relinquishment. That will be decided during the course of trial.
No,
not
they cannot, my lords, my respectful submission is they cannot institute a separate suit making such an averment because the same is barred by order 2, rule 2. Your lordships may kindly see order 2, rule 2, CPC.
This to the respondent.
No, it's also, my lords, covered by several judgments. I have it in hand.
Let them come, we'll see when this order is passed.
This was in the past in the September
We'll see.
2025.
I'll give a short date. The petition is permitted to take out handsomens from the counsel appearing for the respondent to the trial court. Shall file a memo to that effect by 7th of July? If the memo is filed, list it on 8th.
Files memo for dispensation to respondent number 4.
A memo is filed seeking dispensation of notice.
A date may be fixed in this.
I have already fixed. Accordingly, notice is dispensed with. So 1 to
3.
1 to 3
Akiti.
is fixed.
Great.
69.
The suit for declaration injunction, let's say, plaintiff was sought to be rejected on the ground.
4, 6 and 11, 14, your lordships.
Tomorrow is 3rd. You seen how many? Yes.
Happy for the cavator, lordships.
Papers are served on you.
Please, moderator, sir.
The cavator, I got the copies. I will file the objections. There are several other plaintiffs. There. I have appeared for only 4 plaintiffs, 4 of the respondents.
Yes.
Please. Suit for declaration injunction.
Hmm.
Now, my lord, the plaint was sought to be rejected on the ground of limitation. My lord, the plaintiff says, my lord, he was he executed a registered GPA in the year 2007. My lord, he comes and says, my lord, I not executed registered GPA. I only executed a sale agreement that was not concluded. And my lord, based on that registered GPA, my lord, from 2012 till 2021, my lord, several sale deeds has happened. Several sale transactions has happened. Because after 15 years, my lord, he comes and says, I have not executed registered GPA. And it's only a sale agreement. My lord, I just request my lord to kindly take the plaintiff para 41. He does not give that particulars, my lord, when he came to know that the GPA has been fabricated. Page 41 is the plaint, my lord, the relevant. Lords, you find at page 48, my lord. Para 7, my lord, bottom.
Hmm.
Lord, it is submitted the plaintiff number 1 and his family members required money for urgent necessity for their family. They negotiated with the defendant number 1, M.K. Nagaraju, defendant number 4, M. Vishwanath, and defendant number 5, H. Kumar, in respect of selling 10 guntas land in the total extent of the above said land, as they are interested in purchasing the same. Further, plaintiffs have
That also there is no date.
there is no date. Let's further the plaintiffs have obtained an amount of 50,000.
2007.
Please, Mullah. No, they say Mullahs on the. I'll just conclude, Mullah. Further, plaintiffs have obtained an amount of rupees 50,000 towards advance sale consideration from M.K. Nagaraju. It is submitted that for the said transaction, defendant number 1, M.K. Nagaraju, called the plaintiffs on 6/11/2007, stated that he is going to get the registered agreement of sale and obtain signature of the plaintiffs on a paper. Plaintiffs have put their signature to the said paper, believing the words of the defendant number 1, 4, and 5 as the plaintiffs are related persons. As the said defendant number 1, 4, 5 did not turn up for several years, and on inquiry, Mullahs, kindly note there is no date, Mullahs. On inquiry, the plaintiff number 1 came to know that the said defendants have fabricated a registered power of attorney dated 6/11/2007, allegedly created in favor of the defendant number 1, M.K. Nagaraju. The said defendant number 1, 4, and 5, without the knowledge of the plaintiffs taking advantage of their illiteracy, fabricated a general power of attorney in respect of the land to an extent of 2 acres in survey number so and so, in place of an agreement to sell to an extent of 10 guntas of the said land, only with an intention to deceive the family. Mullahs, I'll just pause. Thereafter, Mullahs, para 11, the first sale has taken place. Mullahs. He himself mentions.
So when the first sale?
First sale is taken place on 18/8/2012.
18/8?
2012.
What is the nature of property?
It's agriculture land. 2 acres of agriculture land. First sale to an extent of 39 guntas, Mullahs, has happened on 18/8/2012. There's another sale in Mullahs on 13/11/2012 for an extent of 1 acre, 1 gunta, stated in para 13. Para 14, Mullahs, from 2012 till I purchased in the 2020-21, he narrated all the sale deeds. I just request Lordship.
How many in number have taken place?
Mullahs, the nearly Mullahs, document number 12 to 31.
No, he says documents 31, document number 31.
Please, Mullahs, total document number 31. So several persons have purchased. I am Mullahs, the 9th purchaser of the property. Mullahs, I also filed a suit against him and got an injunction. Well, after 15 years, he comes and says, Mullahs, I would have believed Mullahs.
Not for cancellation of all this.
The cancellation of the GPA he sought, Mullahs. The prayer Lordship find it para 59.
And consequentially to satisfy.
The document based on.
Come to the order.
No, so order Lordship in the Learned Trial Court says, page 37, Mullahs. Para 26. The appellant defendant so and so contention that the GP and the sale deeds were executed long back and therefore the suit is barred by limitation, and of the fact that plaintiff had knowledge much earlier in respect of those documents. That is a disputed factual plea which cannot be adjudicated under order 11 to 11 application unless the plaint on its face shows that the suit to be barred. The plaint, by averring discovery of fraud and police complaint in 2022 and by alleging attempts to dispossess in year 2000, January 2020, shows cause of action arising within the period which would ordinarily make the suit maintainable. On the face of the plaint, this court is unable to hold there is no cause of action. After in the year 2020, to create a cause of action, he goes and approaches the police station, gives a police complaint, and comes with the police saying, they've interfered. I gave a police complaint. From this day, I got the cause of action. But it's a registered document. of the 2007. We would have been appreciated with its unregistered GPA.
Where from the code gets this at page 29?
The court says in the cause of action, he vaguely stated that page 59, para 31 in the plain, 58, para 31. He says on 1/1/2022 at about 3 p.m. when the defendant number 1, 4, 5, 10 to 12 illegally entered into suit property and tried to dispossess the plaintiff based on the concocted documents. Further, defendants continuously attempted to dispossess the plaintiffs by illegal means. Only when we tried to dispossess him, he came to know. And it's agricultural property, my lord. If he is in the possession, my lord, several transactions have, 2 acres has been sold in 39 guntas, 1 acre and 9 guntas, my lord. By bits and bits, my lord, it has been sold. And registered GPA, my lords. It's a registered GPA of the year 2007. Now, according to him, he was my lord, agreeing to sell, my lord, the property. Now, he would have issued some notice saying that this transaction has not been happened, and he has not given any particulars. If clearly, my lord, that fraud has taken place, he would have, my lord, mentioned the date on which date he came to know this kind of transaction has happened. I took lordship to the particulars. He only said, my lord,
Better appears for whom? Plaintiff? Yes. Yes, what do you say?
Hello, sir.
Yes, your
Serial
lordship.
number 69.
Ah, your lordship. Yes, your lordships.
Yes.
The thing is, there is a police complaint accompanied by the plaint, which clearly demonstrates the cause of action, whatever my learned counsel has read over. Thereafter, the suit came to be filed. It is a mixture of fraud and misrepresentation. The GPA was taken. So that's why they have sought for cancellation of this GPA as well as sale deeds, your lordships. As your honor, as your lordships know, the fraud vitiates everything. So the fraud has to be decided in the trial, not by the rejection of plaint. And they have sought for limitation. The limitation is also taken care of by the very cause of action. It is coupled with the cause of action is clubbed with the limitation. That is, as on the date of filing of the suit, they have filed a complaint, and based on that, they have come to know all these transactions. And the GPA was they were never knowing about that particular GPA, as they have stated that it was taken on the guise of helping the plaintiffs. They have taken a signature by the alleged GPA holder, and he, after taking the advantage of the illiteracy of the plaintiff, he's got executed the registered GPA, and thereafter is transacted. Since it is an agricultural land, there was no occasion for them to know about it. All the sale transactions will not be reflected in the Pahanis. So only on when the petitioners and others who were actually wanted to take possession of the properties, whatever he is telling, all the suits are filed subsequent to filing of these suits. The transaction is subject to this suit because it is the original document. The GPA is challenged. So when GPA is a resultant of fraud, the other documents will follow, whether the foundational document is correct or not. I have challenged the very foundational document, your lordships.
it's regarding the cancellation, the date of knowledge needs to be Article 59 of the limitation.
Oh, we cannot meticulously go like how you are submitting. He says we can understand like when a documents are executed from 20 till 2022. What the plaintiff is 2022. What the plaintiff is doing, but he alleges fraud and he alleges ignorance, and all these aspects have to be decided.
Even if the fraud is taken into consideration, Section 17 covers within the limitation of 3 years. I'm sorry, 3 years. Even I just request para 11 of the plain. Even he say first sale deed, he does not.
According to him, he has come to know about it in the year.
He did not mention the date, that is the reason. I would have appreciated 2022.
2022.
No, he did not say. Kindly take page 50.
But that's what the court says. He said only in or about 2022.
That too, he created event and gave the police complaint.
The complaint date is there, your lordships. They are misguiding the court. The complaint was there. Police complaint is lodged. After the police complaint, he has approached the police. Have declined to help the plaintiffs. Thereafter, they approach this honorable court. There is a police complaint accompanying the plaint actually.
Which
is the date of the complaint is made as confirmation, your lordships.
This page 49, para 9, my lords. The first para.
Page 49.
Para 9, my lord. As stated, the
And
defendant number
moreover,
one
your
court
lordship,
did
moreover,
not
there is a
have.
one judgment, latest judgment of the Supreme Court, which is just a week earlier, where the division bench of the Supreme Court has held date of knowledge has to be taken when the sale deeds are seek for cancellation. It is not from the date of execution. It is the date of the knowledge has to be taken. It is the latest judgment of the Honorable Supreme Court of India, which I'm not having it. I place it, your lordship. Short
The
date is
date
given.
of
I place it before the Honorable Court.
my contention,
Limitation.
the date of knowledge is not mentioned is my contention. On para 9, my lord, it says, let's just read the para 9.
No, what they say is, they came to know about this, no, they gave a complaint on 29/11/2022. That day somebody, these defendants have come and tried to dispossess them. And that is the date of knowledge, which has to be looked
No,
into.
that is vaguely stated because my lord, para 9 may just request. Para 9.
Understand, but we cannot
It's
decide.
para 9 and 11, my lord. He did not say, my lord, on inquiry he came to know. But he did not mention, my lord, what kind of inquiry he did. My lord, what was the occasion for him, my lord. My lord, he would have stated on this day there was an interference. So,
It's not the kind of inquiry we can do.
registered documents from the year 2007.
Let the court decide.
And my lord, the prayer is also not sought against the
I'll dismiss, order will follow. Yes, next.
Then number
Blood.
70.
Yes.
Partition suit, please, my lord. 7 to 11 application is filed by the defendants herein. But for a moment, plaint at page 39. My lord, the plaintiff pleads that, please, my lord, one Basante Gowda, my lord, was the propositors of the family having two wives, my lord, Narsamma and my lord, Kariyamma. Through Narsamma, please, my lord, he has three children, and through second wife is concerned, please, my lord, one son by name Chiknarsaya. Defendant, please, my lord, is none other than the grandchildren of Chikka Narsaya is concerned. My lord, Basante Gowda, insofar as, my lord, at para number 6 and 7 of the plaint is concerned, my lord, they say that, please, my lord, after the death of Basante Gowda, please, my lord, Chiknasaya, the second son, was acting as Karta of the joint family property is concerned. And after the death of Chiknasaya, please, my lord, Srinivasaya, please, my lord, was acting as Karta is what their contention is. Now, please, my lord, the partition, please, my lord, is affected way back, my lord, much prior to independence is concerned. Now, Basante Gowda also, please, my lord, died much prior to independence is concerned. Now, the plaintiffs are residing.
Please come to your affidavit.
Please, my lord.
In support of the IA. We'll look into it.
Impugned order, please, my lord.
Affidavit.
Affidavit.
In support of that application under 7 to 11.
Lord, affidavit would be at page 54. Application at page 54. My lord, where I have sought for rejection on 4 grounds is concerned, please, my lord, 7 rule A to D. As far as B and C is concerned, please, my lord, I'll not precipitate at this point of time. I'll only, my lord, I'll submit on the cause of action.
No cause of action and limitation.
Limitation
So
is.
what are the grounds? Come to the affidavit.
My lord, affidavit is concerned, please, my lord, at para 5, I have stated that, please, my lord, the cause of action would be an imaginary and concocted is concerned. And the plaintiffs are not in physical possession of the property is concerned, please, my lord. Para number 8, I have extracted, my lord, the history is concerned. Para 9, I would say, please, my lord, there was a partition, my lord, way back 80 years ago. My lord, the scheduled property, my lord, which consists of, my lord, a property situated.
All these facts, you can find these facts in the plaint.
Please, my lord,
Can disclose all that.
My lord, they only say at para page 6. At para 6, please, my lord, they only say it, please, my lord, the properties were Karta revenue documents were standing in the name of Basante Gowda. And after the demise of Basante Gowda, please, my lord, the second son, the second wife's son, my lord, he was acting as a Karta of the property is concerned. And after his death, please, my lord, the defendant number.
So basing on those elements.
My lord, only if your lordship.
No, basing on those
please,
elements in the plaint, can your application be decided?
My lord, my submission would be, my lord, as far as the death of, my lord, the Basante Gowda is concerned, please, my lord. My lord, the date of death is not reflected. They only say, please, my lord, after the demise. What happens, please, my lord, if the date of death is being disclosed?
My lord, suppose for example, please, my lord, if I say he died, my lord, in the year 1955 or 56 is concerned. My lord, according to their pleading is concerned. My lord, in the year 1957, please, my lord, the son of second son, my lord, would be at the revenue records in his name is concerned. They do not disclose the date of death is concerned. Nor the second son.
Oh, the difficulty is what is disclosed in the plaint can only
My
be
lord, they
looked
only
into.
disclose, my lord, what is my submission would be, please, my lord, is in respect of suppression of facts is concerned.
That can't be decided in
Well,
a.
the Supreme Court, please, my lord, in one judgment, please, my lord, Dhai Bain, my lord, has referred to, my lord, various judgments, please, my lord. In fact, Arvindam's judgment is also taken into note of, my lord, which clearly says, please, my lord, if clear, may I read that particular portion, please?
So, no, according to you, the Honorable Supreme Court has said that under Order 7 to 11, suppression of facts has to be considered.
My lord, in Madanari's case, please, my lord, in Madanari Sri
Who will
Ram.
say that it's suppression of fact?
My lord,
To say that there is suppression of fact, what you say in your written
Lord, what-
statement has to be considered.
Lord, my submission would be, please, my lord, 80 years ago, there's a partition affected. Lord, they go and
That those are all on the merits of the matter, Mr. Counsel. How your application or 7 to 11.
Well, they only say, Millard, how they, Millard, as far as the cause of action is concerned, they say, please, Millard, in the year 2019, they go and approach. If your lordship would see para number 7, they say, please, Millard, may I read para 7, please, Millard, with your lord. The plaintiff further submit that there is no partition or legal division in the family of the plaintiffs and defendants. Now, the defendants, in collusion with the revenue officials, created the revenue documents in inter se. Millard, revenue documents are affected way back, please, Millard. They
Who will
only
tell
say,
the court?
please, Millard.
Who will tell the court all that?
Millard, at least, Millard, the pleadings, Millard, must be there, is what my submission would be.
If there are no pleadings, he will not be entitled
And please,
for
Millard, the
anything.
revenue records, please, Millard, clearly disclose. The
That's not
documents
the
are
case
standing.
under
Millard,
Order 7 to
from
11, yes.
1956, please, Millard, much water has flown, please, Millard. Revenue records are standing in
Yes,
the name.
dismissed. Order will
Please,
follow. Yes, 71.
Till number 71. Till number 71. Santosh.
List is smart, no representation. List is matter on 22nd of July. Yes,
Till number
72.
72.
I appear for petitioner, Your Lordship. Lordship, I seek some accommodation in this matter because the parties are already there is a decree against the plaintiff.
This is a matter on 15th of July.
Till
Yes,
number
73.
73.
73 also same.
I appear for a petitioner. In this matter, Your Lordship, there is a application filed for rejection of plaint. That is with respect to the partial partition. The plaintiffs have filed a suit for partition, wherein they have not included
We'll
all
see
the.
this matter some other day. List the matter on 18th of June. Yes, 74.
Till number 74. Anandich.
Lordship, the respondent has filed a suit for declaration, position and injunction. Respondent is a society, my lordship, which is registered under the Cooperative Society Act 1956, my lordship. See, before filing a suit against the society, the mandatory provision of 125 has to be followed, my lordship. See, here, what 125 provision says is, unless notice necessary in suits, no suit shall be instituted against the cooperative society or any officers in respect of an act touching the constitution, management or business of the society until the expiration of 2 months next after notice in writing has been delivered to the register or left at its office, stating the cause of action, name, description, the place of residence of plaintiff, and the relief which he claims, and the plaint shall contain the statement such notice has been delivered or left, my lordship.
What is now? Let's look at the plaint. What is the dispute?
My lordship, here the respondent has filed a suit for declaration against the society, my lordship. See, it is a society which is.
Come to the plaint. Let me look at it.
Yes, my lordship. Page number 36, my lordship. Right. Here, the respondent admits that in the para number 4, my lordship, page number 37. Submits that meanwhile the defendant was taken the permission from the plaintiff to construct a milk dairy in measuring east to west 30 feet and north to south 40 feet in the suit scheduled property. There were illegal encroachment on the eastern portion in the suit scheduled property. He admits that. So this milk dairy was constructed in the year 1999, my lordship. So respondent is also the resident of the same village. He is well aware that. So a milk dairy is there collecting the milk from the villagers and rendering the services for the villagers, my lordship. So after lapse of 30 years, he comes before the court stating that there is a encroachment in the survey number property. Now the dairy is located within the Gram Thana where where Khata has been issued and all the documents have been issued and they have obtained the electricity.
He's the owner of the, he's seeking declaration.
He is seeking the declaration.
How it will fall under section 149 or
125, my lordship.
25?
See, once 125 says that unless a suit is instituted against the society, which touches the management, constitution, business, it is the place where the business is conducted, my lordship. Commerce is conducted. So directly institute, because they have made the president and secretary as the party. So it is the public property.
Let us see what is the, please come back to the plaint again.
Page number.
The defendant has taken permission from the plaintiff to construct milk dairy in the measuring east to west.
Yes, my lordship.
Please come. The society is before this court. Agreed with the rejection of an application that's filed under Order 6 and under Order 7 to 11. It's a case of the petitioner defendant that Section 125 of the Cooperative Societies Act contemplates a notice to be issued filed to the institution of the suit, where it touches upon the aspect of constitution and management of the business of the society, and there's no such notice is issued on Section 125. The suit is not maintainable. Then counsel submits that this aspect was not considered by the court. And the court has observed that it do not fall under Section 125 of the Act. It is submitted that in it is very much falls within Section 125 as the transaction between the petitioner, plaintiff, and the defendant is in the process with regard to the business of the society. Considering the submissions, there shall be stay of all further proceedings pursuant to the order passed in I number proportionate to the application filed under Order 7, Rule A, B, and D, dated 10th October 2025 on the file of so-and-so. See, notices to the respondents, hand summons, in notice and in addition hand summons, and the memo shall be filed by 29th of July, or else a stay granted with this court stands vacated.
Cell number 75.
The council, my lord.
Puneet Street.
Yes.
For declaration is concerned. My lord, at para number 5, please, my lord, they say that, please, my lord, father of the plaintiff, he purchased, my lord, 9 guntas of land way back in the year 1965 is concerned. He approached the revenue records, revenue authorities to seek for enter the revenue records based on the registered sale deed is concerned, and the revenue authorities have not affected the revenue entries based on the sale deed is concerned. That is precisely the case of the the plaintiff is concerned. If at all, please, my submission would be, if at all the plaintiffs and the father of the plaintiffs my lord, the revenue authorities have not affected the entries based on the sale deed is concerned. The plaintiffs had an alternative remedy. Now, the right to sue for the plaintiff first accrues in the year 1965 is concerned, please, my lord. Now, from the plaint at page 5, please, my lord, page 29, relevant. Para 3, they would state, please, my lord, the acquisition of the property is concerned. Page 28.
So cause of action, what did they say?
My lord, cause of action, my lord, it runs from page 29, para 5. My lord, the father of the first plaintiff, Ram Subramaya, was uneducated. After the purchase of the scheduled property, he has approached the revenue authorities for change of kata as well as RTC. But the best reasons known to the revenue authorities, they have not changed the kata and RTC in the name of Ram Subramaya. After the demise of Ram Subramaya, his son Muni Chaudhary and first plaintiffs are in continuous possession of the scheduled property. Late Muni Chaudhary also uneducated and he was cultivating the land without any disturbance and interference with anybody. The plaintiff, first plaintiff joined the so and so and he has served in so and so and in India in so many places. The continuation of wrong entries in the RTC as well as the kata in the name of Hanumaya, that is would be my lord, the defendants is concerned is illegal. By taking advantage of the continuation of the name of the grandfather of the defendant has colluded with the revenue officers and he gets his name in the kata as well as in the pani. The change of kata and RTC in the name of the defendant is illegal without any authority of law and not based on the registered document is concerned. Para 6, please, madam. It is submitted that after purchase of the scheduled property, the predecessors of the plaintiffs are in continuous possession is concerned. The encumbrance of the suit clearly shows that the plaintiffs are absolute owners.
We'll see tomorrow. From, this is 75.
Please.
From 75 to 80, repeat tomorrow.
Please.
Case number 2. For orders.
75 to 80.
1. Serial number 1.
Yes, serial number 1.
75 lakhs are the rent due.
No, this is rectification of office objections on I number 1 for vacating stay.
I sent a copy of the IL2 email as well as the register post, which he has refused to receive. I have produced it.
Where is the counsel for the petitioner?
Raghavendra K.
List is marked tomorrow.
Serial number
2.
2.
There is some.
For withdrawal.
Tomorrow the first list won't be this big because all these matters are pending from September, October, all are listed today. This one. Memo is fine. Seeking to withdraw the writ petition. Memo is taken on record as dismissed as withdrawn.
Serial number 3.
Yes.
Petitioner.
Serial
Office
number
objections are complied, madam. The
This
office
is non-compliance.
because the common order has been challenged on both IAS, common order was passed. Madam. The office objection is that single writ petition is filed on common order. That's the office objection. Common order, single writ petition is maintainable on common order. Madam.
So yeah, have you, then you should give, there should be a note of that, the council.
I have written on council submission. I have written.
It is there? It is not there.
It's not put up.
To that objection, I have written council submission. Madam.
Is it there? No? Office objection shall be complied with. S4.
Serial number 4.
That's serial number 1 interim order.
One interim order earlier granted is extended. 4.
Serial number 4. Jagdisham. Awaiting service.
Yes, the notice on the trial court advocate and a memo shall be filed in that regard by, there is a stay in this? No? Memo shall be filed in that regard. Yes, 5.
Serial number 5.
In this
Devendra
case,
Bellari.
in this case, my lord, I have completed the office objections of serial number 1 to 3 by mentioning the pin code and as well as the note in the I have not
What
carried
about the
out.
other objections?
Other side is there. My lord.
You that, I said, what about the other? It says
And the
non-comprehensive
one, the
of office
last office
objections.
objection is only for production of the death certificate is remains, my lord.
Yes.
And the other side is not disputing. The father respondent, Pampapati is died. So that the other, the trial court is urging
Yes.
and
Who appears
insisting
for the
to carry out the
respondents?
amendment, my lord.
Mr. Siddaramaiah.
Siddaramaiah, VB.
This is matter tomorrow. Yes, 6.
Till number 6.
My lord, I prefer the petitioner in this case. Objections is by the copy has not been served, my lord.
They have not cleared it.
Huh?
The petitioner sir has not come, they have written it back. I'll file the-
Take it now. Give it, serve it on them. He's here. And what about this rectification of office objections? What is that objection?
That's the only object. Copy has not been
That's
served.
only, sir.
Please.
Then counsel for the respondent has served the copy of the vacate petition on the counsel for the petitioner. This is matter on 20th of July.
Till number 7.
Interim order earlier granted is extended.
Interim order may convey.
7.
The office objection is
Again, the furnishing of PF.
servicing the notice, my lord. The copy of the petition. I have served the copy, my lord. Memo is to be filed.
7.
Dispensation, yes, my lord.
7. Notice to R2 and R3. To pay the process has to be paid.
Process.
A week's time is granted for paying process.
Interim order may be extended.
Then why don't you take notice on the council appearing handsome?
My colleague is saying that he has filed a memo seeking dispensation.
In that case, then where is the necessity to issue notice?
The other side is also appeared, he is telling.
PF shall be paid
Interim order may be
within a week.
Interim order may be
Interim order
extended.
earlier granted is extended. Both in 7 and 7.1. Look at it in 7.1 and 7.2. Wherever interim order is there, extend. Where interim order is not there, time of 2 days to pay the process. Yes, 8.
Till number 8.
R1 to R14 are served.
Process.
Then council submits that. Mr. Uma Shankar has already filed wakalat on behalf of 1 to 14. Where is the memo for that? And it is, he's only for R4 itself. Where is it? See? Where he has undertaken? Look at the order. Do that. Already notice is dispensed to 15 to 35. Then what about other that undertaking is? No, that undertaking you're referring to is not there in the order. You have an interim order. List the matter on, we'll have it on 10th. List the matter on 10th. Yes, 9.
But 9.
I represent the 19th. Your Honor, in this case, only one office objection in respect of the petitioner name is not properly mentioned as in the plaint. There is a where in my petition I represented one Mr. is a secretary. In the suit, they have mentioned.
No, you are questioning an interim, some order passed by the court. In that, whatever is mentioned in that cost.
I have submitted my counsel submission has been made in respect of the office objection.
You that?
See, here is represented by president. They have mentioned as a president. I have represented by the secretary. In other suit, they are represented.
What is questioned?
That is the office objection.
What is questioned in this writ petition? Where is the impugned order?
Impugned order is, Your Honor, kindly see. In page number 10. In page number 11.
Is the cost title before this court is tallying with that or not?
No, it is a interim application. They have not mentioned the entire cost title.
Look at page 11. 11 and 3.
Page 11.
Yes.
Short cost title has been mentioned. It is order on application.
Then in the suit, how it is?
Suit is in
Plaintiff.
page number 18. Kindly come to the in page number 19. It is mentioned defendant number 4, Measure Telecom Employees Cooperative Housing Society Limited. In the bottom, represented by its secretary in one suit. Kindly come to the next, another one suit is there. In that suit, they have represented the manager. There is a difference. What they are telling that there is a.
In the present suit, what is mentioned?
It's in my petition, I have represented the
No,
secretary.
the present suit is 609.
Represented by secretary.
The present suit is OS 609 of 2014. Whatever is mentioned in 609 of 2014, that is what you are supposed to
mention in
this. So please do that. Office objections to be complied with.
Can you?
Yes.
Within 2 days.
Within 2 days, please. Yes.
Till number 10.
Or else the writ petition shall stand dismissed.
My lordship, kindly
one?
praying for liberty may be granted. Liberty may be granted, my lord.
What is the liberty?
See, to file appropriate. Memo is already. My lordship, memo is filed to withdraw the petition.
Where you have to go? What is the remedy available to you? What is the order? Where is impugned order? Direct the principal civil judge and JMFC to consider and pass necessary orders in IA number 1 and IA number 2 for temporary injunction. Where is the order sheet? This coming up for the first time, or an order sheet is there? In this, you got a status quo.
Please, my lord.
You wanted a mandamus and you got a status quo. Now you want to withdraw this.
My lord, parties do not want to continue.
This also will go. Interim order also will go.
Please.
The petitioner wants to withdraw the writ petition to avail the appropriate remedies, under law. Accordingly, the writ petition is dismissed, giving liberty.
Okay. Grateful, my lord.
All IAs
11.
stands vacated. Yes.
11. Anjaneya.
Huh? Ah. 3 days time, default order. Yes, 12.
Till number 12.
For
Once
the
you
petitioner,
comply, then it will come in the fresh matters. 12.
for the petitioner, my lord, the officers raised the objection. I challenge the common order passed by the trial court in IA number 2 and 3, my lord. I have
Yes.
made court fees also made, my lord.
There is a circular. As per that, they are questioning. They're raising the objection.
Yes, madam. There is two IA number 1 2 for 10 rule 1 and another IA for 6 rule 17, my lord. The trial court has passed the common order, my lord, on 23/3/2026, my lord. The FTP proceeding.
The office objections will be considered at a later stage. Yes.
Date may be
13.
fixed.
It will come.
Till number 13.
Yes. When did you complain? There are 12 objections, it seems. Office objection shall be complete within 3 days, or else same default order. 14.
Till number 14.
My lord, I am for the petitioner. Only 2 minor objects, that is only marking that I can do it anytime. That's not an issue.
Do it.
No,
Now, right across, I can do it also, very minor, only annexes and this one.
Give the file to him.
The problem is, this is a very urgent matter. A widow, the petitioner is a widow who purchased the land. There is a criminal trespass. She is from Bangalore. She purchased the land at Alur.
When the impugned order is passed?
Passed on 2nd February 2026.
It is waiting
No,
till such
my lord,
time.
one small submission. Subsequently, I approached this Honorable High Court. They directed me to approach the district court. I approached the district court on 21st. They passed an order telling that you file a fresh petition. Liberty was given to fresh petition on 22nd of May. Subsequently, when I filed the fresh petition on 29th, they said, okay, you will transfer this case.
This is matter day after
On
tomorrow.
30th.
Office of, give him the file. Yes. Then council shall
Date can be given.
Day after. Yes.
15.
Appearing for the petitioner, my lordship. My lordship, office objection is annexed to be stated a prayer only, my lordship. Wide annexed lane.
Within 3 days.
Please, ma'am.
Mute. Yes.
2 days, my lordship.
16.
ಅವ್ರೇನೋ ಮಾಡಿದಾರ.
Disconnect her. Matter is done. Yes, next.
Cell number 16.
This also 3 days default order.
Cell number 17.
Not 17 is similar objection, not common order passed on IS 224 for injunction.
Yes, the office objection.
Would your lordship have it tomorrow or day
Kept
after?
open.
There is some urgency.
Yes. What urgency? When is the order passed?
Not order is passed just in the vacation, not beginning. I had filed it in the.
Yeah, list it on day after tomorrow.
Great.
Yes, 18.
Cell number 18.
Look at it. You will comply or you have complied? You will comply. Office objection shall be complied with within 2 days. If office objections are complied, list the matter on 8th of June.
Cell number 19.
But in this case, we
Samir?
have compared the office objection, my lord. One office objection is DCF has been paid, my lord. DCF, deficit court fee also. It was paid, my lord. Another office objection is single order was passed in.
How many objections are there? 19.
One objection.
One objection is regarding.
What is that objection?
Single WP file for 2 orders. Single order was passed, my lord.
So this also kept open. The office objection with regard to the office acceptance, same is kept open. List this matter on 10th of June.
Cell number 20.
20 and 21, they are connected matters. In fact, most it is not yet ordered, but the defendant and respondent is appearing. I kindly have it day after. There is some urgency during vacation, it was moved, and the date is fixed today. Kindly have it day after. Now they have voluntarily appeared. That's why tomorrow, day after.
They can file my written statement, it may be taken up there.
No.
No, what is the urgency in this?
Grievance is that ex parte order was
Not
not granted.
granted, but entire parties can be relegated to the trial court for consideration of IA. In
Yes.
fact, that's why.
List this matter tomorrow. 2 matters. I'll ask the court to decide it.
Yes. That's all.
But that's what he's asking.
Day after
Yes.
tomorrow.
Day after tomorrow. Yes.
2021. 2021.
22.
22.
Milords, for petitioner in this case, Milords, the objection is that I hadn't produced a certified copy of the impugned order, Milords. Milords, I have filed along with memo on 27/5/26,
That's
Milords.
the only objection.
Yeah, that's the only objection, Milords. Milords, the urgency is that.
He has complied with the office objection and filed the certified copy along with the memo according to the office objection. And as such, office objections are complied. List this matter for preliminary hearing.
Milords, the urgency case is listed tomorrow before the trial court, Milords.
The office objections, there are 5 office objections still to be complied with.
my lords, all the objections are complied, my lords. Only this objection was pending, my lords. We hadn't received the
If there are
certified
any
copy, my
office
lords.
objections, they have to be complied with it 2 days. This matter on on 9th of June. Yes, next.
Till number 23. Arjun Masih.
Dismissed of he has filed a withdrawal petition. Next matter also take it. They have filed a withdrawal petition. Memo is filed stating that the petition has become infractions. Accordingly, dismissed as infractious. What about the next matter?
Till number 24 memo.
Yes. Oh, why they say that there should be a liberty to question it in future? List this matter tomorrow.
Till number 25.
My lords, I am appearing for the petitioner, my lords. The matter is settled before the mediation center, my lords, but the other counsel is not well. He is seeking tomorrow accommodation, my lords.
Yes, tomorrow.
Please.
Till number 26.
Appearing for the petitioner in this matter, my lords, we had applied for certified copies to RTI, my lords. Certain government documents, layout plans have been requested for. I request a my lord. My lord, they do not have a valid sanction plan, my lord. They have a temporary sanction plan.
That will decide. No, I'm not hearing the matter. He has filed a vacate and that has to be heard. When are you going to argue the matter?
2 weeks time.
2 weeks. 23, you are having an interim order and you say 2 weeks. How is it possible?
My lords, the documents.
Not necessary. In this, see, in these matters, no documents are necessary. List this matter on 17 June.
Number 27.
Much obliged.
Interim order only granted is extended.
Kindly have it next Monday, my lord. Kindly have it next Monday, 27th.
List it on 11th June.
Please, madam.
Till number 28.
Interim order earlier granted is, and what about the non-compliance of office objections? 7th time. If office objections shall be complied by the next date of hearing, or else the writ petition will be dismissed on that ground. That's 28.
Petitioner in person, my lord.
Yes.
That there is an objection in the transfer petition. This is not a routine administrative transfer for the sake of convenience under section 24 of CPC. This is the transfer prayed to address a manifest procedural bias, and the evidentiary proof is in the main petition, my lord.
No. What is the office objection?
That the objection is under section 24 of CPC.
26 returned with office objection. Two prayers sought in
My
one
lord,
IA
I will
and
restrict it.
without acknowledgement not filed.
I will restrict it to primary prayer, my lord.
What it is, the petitioner shall comply with the office of the party in person shall comply with the office objections.
My lord, I will restrict it to primary prayer.
But you have to write it, go before the registry and do it.
I will file a memo, my lord.
Then
before your lordship.
28.1 memo for overruling the office objection regarding maintainability filed by party in person. What is this? This list along once the office objections are.
My lord, I will file a memo, my lord, regarding that. I'm not pressing on the second prayer. What they have mentioned is there are two prayers.
That is what I'm saying. Please understand. Do it in the registry.
Okay.
Whatever you want to do.
Much obliged, my lord.
Yes.
A date may be given, my lord.
Now, both the matters, the office objections shall be complied with. This matter on 17th of June.
Cell number 29.
For the petitioner, my lords. My lords, kindly have it on 15th June, my lords, if possible.
Listed on 15 June.
Cell number 30.
My lords, the interim order may be
Earlier granted
Grateful.
is extended.
30.
I have asked in this list, only orders matters to be listed. Why these matters are also listed? These matters. There are nothing IA1 for vacating the state. How can it be ordered? Huh? No, there is no office objections in this. Why they have come? It's not that small. It's not that. Look at it. Look at the list. What IA order? She has no brain at all. Yes, call the list. Yes, 30.
Respondent, Your Honor.
Murthy,
I have filed a vacating application for kindly out on some other day, kindly out on 24th or 25th.
What is this rectification of office objections?
copy not served.
I received you.
It is submitted that the copy is already served on the counsel for the petitioner. Less this matter.
Kindly out on 24th.
24th,
25th. Alla, kindly out other 2 days. Alla, 10th or 11th.
Based on 22nd. Interim order earlier granted is extended. Yes, 31.
Number 31,
22nd.
Sarath S. Gowda,
Appearing for respondent.
22nd.
Milord, appearing for respondent.
This is
Date will
matter.
be fixed, Milord.
This is matter on 1st of July. Interim order earlier granted is extended.
number 32,
32 Milord, in the connected case, there is an interim order. The same may be granted in this case also, very same.
In which, in 32.1, there is an interim order. How are they connected?
Milord, that is filed by my brother and parents, and this is filed by.
But I have to see that. Now at this point of time, we can't.
Because very
This-
same impugned order is stayed in the connected case also.
List
Very
is
same
matter. No, we'll see. List is matter on 16. Yes.
number
sir.
33,
And in the connected case, interim order to be extended.
In 32.1, look at it if interim order is there extend. Yes, 33.
33, A. Madhusudan Rao,
Application to permission to produce several documents. Already served the copy.
Hmm?
Already served the copy. Right, application for the additional documents.
In this matter,
Serial number 33.
permission to file by advocacy.
we will see. We'll see when this matter is heard. Yes.
Interim order will be extended. He has undertaken, he has done. There is no interim order. Last week, oral submission is there.
Yes. This is matter on 7th of July. Yes, 35.
Number 34, urgent 35,
Witnesses are not parties in this implement order. Therefore, Madam, officers raised the objection, the permission to file the IA for challenging the order. We have filed the IA.
Permission?
On 22
Permission?
Permission to file the writ petition. That IA is need, that is the office objections for.
Oh, you are not a party before the trial court.
Yes, yes, Madam. We have
Yes,
filed the IA,
tomorrow. We'll see this tomorrow. Yes, 36.
serial number 36,
I appear for respondent 1 and 4, Milord.
Yes.
The first list, serial number 36 has been connected along with this matter.
Oh, that's
Yes,
this matter tomorrow,
day after tomorrow.
day after tomorrow, along with that matter.
Serial number 36.
Yes.
serial number 37, 36 over. List number
Yes.
3, serial number 1,
In this list, wherever the matters.
I
if-
appear for petitioner.
If the.
Your lordship kindly extend the interim order.
This one.
Please.
Milord, one indulgence.
List number 2, Milord.
I'll be calling the cases.
serial number
No
1,
hurry at all.
I appear
One.
for.
One.
I
Madam,
appear
for the
for petitioner. I appear
Yes.
for petitioner, my lord. Interim order may kindly be extended, my lord.
Yes.
There is a liberty is reserved to file objection and vacating stay. Till date, they have not filed anything.
Yes.
For the petitioner, my lord, respondent.
I go for the respondent. David, this is for the fourth time, this matter is posted for admission. There is no interim order.
There is interim order, my lord.
Adjournment.
Please check the.
Your
Yeah.
lordship kindly see the earlier order. my
Earlier
lord.
area order.
Earlier
Okay, it's a
order.
connected matter. There is urgency in this matter, my lord. Both the petitions arises out of interim order passed in commercial suit.
This is matter on 15th of June.
Please.
serial number 2,
Interim order may be.
Interim order may kindly be extended.
Look at it.
Interim order in this.
1 minute. Look at the proceeding sheet. If the interim order is there.
Please,
Interim
ma'am.
order is extended on the last occasion. How can you say?
It is in a Connected petition, my lord.
Wherever there is interim order, it will be there.
Yes.
Look at it, 1.1, in which case there is interim order extended. Yes, 2.
Grateful.
Petitioner, kindly have it on next week. For petition.
You have an interim order?
No interim order.
List is matter on 21st of July.
Serial
Yes,
number 3
3.
and 4 are ordered. Serial number 5. 5.
These are all fresh matters.
These are
Huh?
The matters that come up before the vacation bench, my lord.
These are all adjourned matters.
My lord, serial number 7.
these are the matters which are attached to the other.
This matters because these are all 26 matters.
Please.
Bill number 6, Your Lordship. Yes,
all
please.
these matters, all these matters till 18, list tomorrow in the first list.
Please, my lord, grateful.
And
31 also.
If you ask day after tomorrow, I'll post it next week in the month of July.
Serial number 19. Admission.
Yes. Huh?
Applying for petition.
19.
19, serial number 19, my lord.
I'm for the respondent in that one.
It's also a fresh matter.
Fresh matter.
There is a
Tomorrow
fresh
let it
matter.
come. Yes.
List number 1. Serial number 28 to 20. Serial number 22, 25 urgent, 26. Serial number 26.
For petitioner. Kindly have it on next week, madam.
Any urgency in this?
Urgency is there, madam.
List this matter on 17th, 26th on 17th. Any interim order?
Interim order is there, madam.
Look at it. In all the matters, look and then explain. 27.
7. Pradeep Kumar KH.
This matter on 24th. Look at it. Any interim order?
Serial number 28. T. Sheshgiri Rao.
This on 2nd of July. Look at if interim order is there, extend.
29 urgent. Then next part that matters.
Let all these parted matters be in the list. All parted matters.
31 minutes. My lord, serial number 31, my lords, before the trial court, the warrant has been kept in abeyance because they in fact appeared before the trial court and made a payment of 2 lakhs, if I'm not wrong. My lords, what the arrears are to the tune of 1 crore 60 lakhs.
Okay, they're asking for a date. I'm not passing any order now. He's
Please.
asking the matter
My
to
lords,
be taken up.
the matter before the trial court is on 14th of July, if I'm not wrong.
Court has no time this week. Court cannot take up these matters now. List these matters on 11th of June. Yes, I'll release it. I have no interest to hear your matter. Release the matter from part 30 and 31.
Please.
30, 31, 31.2. List the matter before the court having roster. Yes.
Serial number 33 urgent, 34.
32, what happened?
32 also urgent. 32, 33 urgent, serial number 34.
My lordship appearing for the petitioner in this case, my lordship, kindly list this matter on 15th, my lordship.
Yes, 15th.
My lordship, interim order may be extended.
Yes, look at it. If it is there, yes.
Number 4, serial
Much
number
obliged.
1. Yesterday's matters.
Yes.
List number 4, serial number 1. Ashwat Narayan Reddy.
My lord, from yesterday to today,
What do you expect the court to do? No top of the list. When court can take, will take up. This is matter tomorrow, wherever list it comes. Yes, true. Let it come on. I'll have a 5th list for your case. Yes, next.
Serial number 2.
I for petitioner, madam. Interim order.
Yes, 2.
Kindly activate interim order. Kindly activate.
2. What do you want?
Kindly activate interim order. Interim order.
This is matter on list this matter in the first list. Yes, 3.
tomorrow.
Interim order is extended list tomorrow. Yes, 3.
Till number 3. Till number 3, Nagbhushan.
This matter on 18th. Yes, 4.
Till number 4, Sidramaya VP.
Serial number 2, my lord. Next week in date. Serial number 2, 4th, sorry, my lord. Next week in date.
No, he was insisting.
He is sitting.
You are insisting. Let's next week, that next week on 9th.
Serial number for admission, serial number 5.
Not appear for the petitioner.
4, what happened?
4.
4. Not 496. Before that is 96. That matter is not called Anita. No, that is not tomorrow. That is what they are mentioned now. That matter. Just write 96, list number 2, that case number 2. Yes. Just call this matter, Sidramaya.
VP Sidramaya, serial number 4.
This matter tomorrow's list is a fresh matter, it appears.
Serial number
Yes.
5.
My lord, I appear for the petitioner, my lord. This matter had come up in the vacation bench, my lord said,
This matter in the first list tomorrow.
great for me.
Serial number 6.
This is that flat case.
Yeah,
my
that
lords.
is what, it's an accommodation for the petitioner. We
Lords,
can't accommodate it now.
we tried to approach the bank. Bank said, my lords, no, when the matter is pending for consideration, we will not accommodate. Now, my lords, I'm not trying to, my lords, improve my case, my lords. But what they could not achieve, my lords, in the competent civil court, they want to, my lords, make an entry through the back door. Now, my lords,
First of all, we are on the maintainability of the.
now that is what I just wanted to point out, my lords. I have the benefit of injunction order, my lords, passed by competent civil court.
Go there,
My
go
lords,
there and have enjoyed.
now the question is, my lords, a person who, my lords, played fraud on the bank, as well as, one second.
One minute.
I'm-
You are come to, you
I'm
have
saying
come,
he has played fraud on you. I'm not saying bank has played fraud on.
now, you have come to the court.
Yes, please.
Whether what is your legal right
Now, my lords,
is has to be established.
yes, now that is why I wanted to bring it to the notice of the court, that, my lords, we are before the competent court. Competent civil courts have granted injunction order. Now, my lords, when the injunction orders are operating, bank in collusion with, my lords, the second respondent borrower, they want to bring my property for auction.
Then you please, then when there is an injunction,
Yes,
when they are violating the injunction order.
Now, my lords, bank is not a party.
Bank also have a party to that.
My lords, now we have brought it to that is why, my lords, I fairly said, my lords, this is a case where, my lords, we are ready to purchase some of the properties.
We cannot,
No, my lords,
this
now-
is under
Now,
public law remedy. You can't
ultimately,
ask for this.
bank is, my lords, interested with regard to their money. We are saying, my lords,
When bank do something contrary to the procedure, anybody will point out.
now, my lords, we are not requesting them to go do anything contrary, my lords. We are only requesting them 2,000 and odd
I
square
have
feet of.
heard it, I remember all the facts, I'm not inclined. The only
I'll try to
only-
further persuade, my lords, by, I'm not.
No, I heard it enough, I have
Now, my
given
lords,
enough time for this.
Now, my lords, what are all the documents also I have produced, my lords. Bank.
Whatever are the documents,
Now, my lords,
you have no legal right for the
Now, my lords,
reason
we have legal rights because
to come before this court, you
Lords,
don't have a document in your favor.
we cannot go to any other court forums also, my lords. This is our grievance. Otherwise, I would not have troubled my lords.
If you do something which you can't have a remedy,
My
then
lords.
nobody can help you.
Now, the problem is, my
You
lords,
pay the money to
No,
somebody
my lords,
without, no,
Yes.
without a document, you pay the money and
we
say
have
that
the documents.
What documents
We
you
have the sale agreements.
Agreement of sale, enforce it before the
Now,
civil court.
we are before the civil court.
That is again like, it is like a.
Now, that is what
story
that
we
is why I
can't,
said, kindly call this matter tomorrow, my lords. I'll further try to.
I can't hear it so many times. I heard enough. And I'll.
Lords, now the
basic-
practical difficulty what we are.
Whatever it is that you have already agitated.
Yes, please,
And you have already argued.
Now,
I heard it.
now,
I
my lords,
heard
if the,
it, and-
imagine a
and in
situation,
spite
my
of
lords,
the-
may kindly appreciate one aspect, my lords. Imagine a situation where, my lords, now the injunction orders are operating in my favor. At the same time, my lords, if the bank auctions my property and throws me out of the property, except approaching this honorable court, we cannot go to any other forum, my lords.
And this court cannot, because
lords,
there is nothing wrong with what bank is doing.
Now, my lords, bank is doing at the instance of second respondent. That is my grievance.
That is you
Otherwise,
have to,
now kindly look at the affidavit what they have filed. I'll point out, my lords, call this matter tomorrow or day after tomorrow, my lords.
Let it be tomorrow.
I'm sorry. When the affidavit was filed, I pointed out they have left out one of the apartment also.
That is not the concern of the court.
Now, my lords,
council.
My lords, they play.
How the bank conducts their affairs is not the scrutiny of this court.
If I cannot bring it to the notice of this honorable court, now kindly see, my lords,
First of all, how do you substantiate your case before this court?
Now, my lords,
you are a bank is doing something.
Now, my lords,
you have no relationship with the bank. Your relationship is
insofar as some of the purchasers are concerned.
Whoever are the petitioners have no nexus or have no relationship with the bank. You have paid the money to a owner of the property or the builder.
Yes.
Builder in turn the bank has given them the loan. No, if whatever the bank has against your
my vendor.
That they will take
my
care.
Vendor.
We cannot stop them because there is no
nexus
requesting between you and them.
Now, I am not requesting my lords to stop what the bank is doing. Now, I am only bringing it to the notice of the court. We are before the courts of law. Injunction orders are there. Some of my lords, rare authority has passed order. Division bench of this honorable court has protected our interest. In order to circumvent that, my lords, they want to take physical possession.
There's nothing wrong with the bank. What bank is doing?
Same properties are before the court.
Let it be. Bank is not a party.
Bank is, in some cases, bank is also party.
Take action against the bank.
Now,
why are we doing it under
we cannot go to any other forum except persuading my lords.
No.
Now, that is my grievance.
No.
My lords,
a party who pays the money basing on an agreement of sale and keeps quiet. And
no, we have not kept quiet, my lords. We are before the court.
Oh, you can't. When you have already have exhausted another, you are availing another remedy.
That is my grievance before my lords. That is exactly my grievance. May I persuade? I know, my lords, I have argued enough.
It is waste of court's time,
my
nothing
lords,
else. Because whatever you submit, you have argued at length. I heard
all
this
humility,
matter.
my lords, I am submitting this, my lords.
Look at that. Look at the case sheet. At least I heard it
No,
7-8 times.
My lords heard me twice, my lords. So
Not
then,
twice.
my lords,
If I show how many times it has come
no,
up.
then my lords, that is what, my lords. Initially, when this matter, my lord.
Yes.
Give me half a minute time, my lords. When this matter was initially heard, my lords, then I pointed out the lacunae. Then my lords directed the bank to file affidavit. Then my lords posed me this question with regard to maintainability.
I'm consistently asking, what is your?
I'll try to persuade, my lords. I am not.
Because you cannot persuade because
lords,
that is
now the issue is, my lords, where else we should go, my lords, except a person.
Court is not here to tell you
Now, my
where
lords,
to go.
now ultimately,
you should do something where you have a relief.
Now, my lords, ultimately we are before the court.
And we cannot stop the bank, whatever type of
Now,
transactions you have between your vendor and you. We can't stop. We can't tell the bank to do something.
Now, my lords, in case if my lords bank files a false affidavit before this court.
First of all, forget about what the bank is saying. I am not at all convinced with the case of the petitioners. That is where that is at the threshold you are. Forget about what is the conduct of the bank. Whether
lords, I'll point out, my lords, may be taken up tomorrow or my lords day after tomorrow.
Matter on next Tuesday.
Please.
At 2:30.
Please.
And I am not going to adjourn it. I will pass orders.
Please, my lords. I am.
My lord, I have.
Passed over, my lordships. Passed over,
My lord.
my lordships.
All part of
Tomorrow. Obliged. Tomorrow.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರೆ ಸರ್ ಅವ್ರ ಡೈರೆಕ್ಷನ್ ಇದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಇಂದ ಸೀರಿಯಲ್ ನಂಬರ್ 19 ವರೆಗೂ ನಾಳೆ 36 ಇನ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ. ಇದು ಸೀರಿಯಲ್ ನಂಬರು ಇದು ಬರ್ಕೊಂಡಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 32 38 ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆನ್ 46 ಇದೆ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 38 ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಪಾಸ್ ಅದಪ್ಪ ಪಾಸ್ ಓವರು ಅದು ಅಲಾಂಗ್ ವಿತ್ ಸೀರಿಯಲ್ ನಂಬರ್ 38 ಇನ್ ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಅದನ್ನೇ ಡೇ ಆಫ್ಟರ್ ಸುಮಾರು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು ಇದು ಒಂದರಲ್ಲಿ ಲಿಸ್ಟ್ ಆನ್ 46 ಅಂತ ಮಾಡಿ, ಒಂದು ಇದರಲ್ಲಿ serial number 38 in list number 1 ನಲ್ಲಿ, in list number 2 ನಲ್ಲಿ 38 ಅದು 36, list number 2 ನಲ್ಲಿ 36 ಅಲ್ಲಿ list along with ಅಂತ ಮಾಡಬೇಕು. 36 ಅಲ್ಲಿ along with serial number 38 ಅಂತ ಹೇಳಿದ್ದಾರೆ 146.
Number 2 and 28 and 3.
Hello, sir, ಲಲಿತಾ ಮೇಡಮ್ ಎಲ್ಲಿದ್ದಾರೆ ಬಾಬಾ? ಇಲ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬರ್ತಿ ಅಲ್ಲಿ ಬರ್ತೀಯ ಸೆಂಟ್ರಲ್ ಕೋರ್ಟಿಗೆ ಬಂದ ಬಾಬಾ, ಇಲ್ಲಿ ರಿಪೀಟ್ ಎಲ್ಲ ಇದೆ. ಆಮೇಲೆ ತಗೋ ಇಲ್ಲ ಅಂತ ಮೇಡಮ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡು ಆಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಬಂದ್ರೆ ಅಲ್ವಾ ಚೇಂಬರ್ ಹತ್ರ ಬಾ. ಲಾಸ್ಟ್ ಹೌದು, ಇದು ಲಿಸ್ಟ್ 1 ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಬೇರೆ ಲಿಸ್ಟ್ 1 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್, ಅದನ್ನು ಲಿಸ್ಟ್ 1 ಅಂತ ಬರೀಬೇಕು.
ಅಲ್ಲ ಫಸ್ಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಪ್ಲೈ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. 14%.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬೇಕು, ಸಬ್ಮಿಷನ್ ಬರೀಬೇಕಾದ್ರೆ ಲಾಸ್ಟ್ ಸರಿ ಸರಿ
ಏನ್ ಹೇಳಿ ಸರ್?